Zoning Division, so we will get started. So we know the subject site location. The land use is Economic Development Center. The zoning is multiple use plan development. The overall acreage, 202.67 acres. There were two requests with this application. The first one was a type 2 variance to modify how we calculate parking specifically for data information and processing. The code requires one parking space for every 100 square feet. The variance that was approved was to modify it to be one parking space for every 2,000 square feet. And that was approved by the Zoning Commission in December. It's not effective yet until there's a decision on this request. The second request that is here before the board is an amendment to the overall master plan to add square footage and to modify the phasing. And that's the zoning location. So just to step back, because I know there were some questions on square footages. We know that the board approved the land use, and as part of that approval for the land use, it included square footages for light industrial, warehouse, and it also had equivalent trip requirements. So that was a legislative action that the board had done. That isn't the official development order. So you entitle the property with the land use, and then the zoning application is the development order with the development permit. So that's why the numbers are a little bit different. So the actual development order that the board approved with the master plan in 2016 was for 2,020,000 square feet of economic development center uses. So the history, LGA 2016, it modified the future land use on roughly 130 some acres. It modified the maps. It changed policies in the comprehensive plan within the GAPO and the Glades tier. The companion zoning application modified parking, freestanding building requirements, and rezoned the property from special agriculture to the multiple use plan development district. In 2016, we had another application that did additional variances that was presented to the Zoning Commission for fencing, landscaping, pedestrian amenities, and interconnectivity. In 2018, there was another legislative application, a large scale in 2018, that modified the conditions that were part of the Economic Development Center future land use conditions. And then the most recent applications in 2024, where the decision was done in January of 2025, the land area for the overall increased by 64.46 acres, which gives us now the 202.67 acres. That square footage that's in the master plan for that concurrent zoning application did not change, 2,020,000 square feet. So that's generally a little bit of the history on it. And then I want to talk about the uses. So the uses that are on that master plan that the applicant has on that includes a multitude. It has warehouse, it has data information and processing, and it has or other economic development center uses as allowed. And you see that a lot on many plans that are before the board. Even a shopping plaza that comes to the board as a multiple use plan development will say retail. And then administratively, either or through building permits, they'll put in an office, or they'll put in a type 1 restaurant, a fast food restaurant that doesn't have a drive-through. So we allow uses to move interchangeably. And we still review concurrency. We still make sure that it's part of the intent of what the board saw for that plan. So these are a mix of different uses that are permissible in the EDC flu, and I've included if it's an administrative process, sometimes it's by building permit or DRO. And then of course there are some uses that are Class A conditional uses, and they'd end up coming back to the board.
Commissioner Flores?
All right, can we go
One back.
Yeah. Oops. Keep going?
No, go one forward,
Okay.
right there. So what you're saying is, yeah, if we can get the presentation on our screens, that would be great.
Yes.
All right, so what you're saying is, right now, they've been approved for data information center, warehouse, and light industrial or minor utility, is that correct?
Yes.
Right. So those are the 3 approved current uses. What you're saying is that they were approved for 2,020,000 square foot,
Correct. That's what's on the master plan.
divided among those 3 uses. What I'm seeing is, if I'm reading this correctly, that for data information and processing, if they wanted to change square footage, that would be an administrative process
To increase the square footage?
to change within that 2 million.
If they wanted to switch out uses.
Switch out uses, correct.
Depending on the use, they could switch it out
But I'm
administratively.
specifically talking about right now, data information.
Data
and processing.
information and processing, it is an administrative use approval that
Administrative.
can switch out.
Then minor utility is also administrative.
Correct.
And the other one I said was warehouse, correct?
Yep.
That's also administrative.
Manufacturing and processing is another administrative use.
So
Mhm.
if they keep what they have, could they come and say, hey, we want to change square footages later, and it does not come before this board?
They can change uses out, yes.
As long as it's in this
Yep.
chart here, and it's administrative.
Administrative, and it meets
Which
concurrency.
administrative means it does not come to this body.
Correct.
And what is the parameters for administrative approval? What are the requirements? What are the guidelines? What are you guys looking at? How do you make that, how do you determine a yes or a no administratively?
So we do have standards similar to what you have in the backup here. So in the staff report here, you have 8 standards that you're evaluating this request on. Administratively, we have 3. We have consistency with the comprehensive plan, consistency with the code, and that it meets adequate public facilities. That's the standards that we evaluated, in addition to looking at all the policies of the plan, all of our building code, fire code, zoning code requirements. They still have to comply with all that.
So theoretically, they could say, we want more of this or more of that administratively right now.
Correct, as long as it doesn't go beyond the
Beyond the
2,020,000 square feet. Yep.
Okay, thank you.
Commissioner Powell?
Thank you, Madam Vice Mayor. Wendy, when they added the additional 64 acres to the EDC, or to this particular site, and it still allowed for the 2,020,000 square feet of uses, at that time, if they would have requested, let's just say they're doing 64 additional acres, let's say they would have requested another 1,000,000 square feet of EDC uses. Let's just, they've got 2 million. 2,020,000, when they added that additional land area, that land area came into the EDC or the GAPO. Did it automatically have the same development rights, or was that particular area that came in, did it not have development rights once it came in? Once it came in, it received the same 2 million that was spread out across that entire area now?
Yes.
Is that the case? So I guess my question would be similar to Commissioner Flores. Since those uses are permitted by right in the EDC, and we're going to see this as this was originally on consent, that's why, right? Potentially, they could have come in, the developers of this could have come in and decided EDC uses, we're going to eliminate all the warehouse. It'll just be a development order amendment, or would it not have been, would it just been DRO? They eliminate all the warehouse and increase the amount of use to data information and processing. Was I clear? Was I not clear?
So if they could site plan 2,020,000 square feet, and it could be 100% data center, it could be 100% warehouse, and all those other administrative uses. The data center could go away, and it could be 100% manufacturing, and as long as it meets our concurrency requirements and the traffic limitations that are established in the plan by the EDC flu, they could do it administratively.
Okay. Thank you for that.
Okay.
So my question now is, sorry, Madam Vice Mayor, the total request for the master plan would be 1,032,000 square feet of data information and processing. If, just hypothetically, if the applicant had come in and said they were going to use, of the uses that are allowed, 1,032,000 square feet of data information processing for their site plan and not exceed the 2,020,000 square feet, just portion it out the way it would be, would that still have had to come before us?
So we have two different property owners here also in this development. And one of the property owners currently has 1.2 million square feet of warehouse. So the difference of the 2,020,000 is roughly 820,000, which is one of the slides that I am going to show.
Okay, sorry.
No, not a problem.
All right, I'm just place setting for better understanding for myself and
Yep.
for other people.
Okay.
Thanks, Wendy.
Okay.
Hold on, Commissioner Weiss has his light on.
Since they started,
Yes,
I'm going to keep going.
of course.
So this, and I just want to be clear because I want the public to really understand that we're not using zoning, planning, jargon, which we are very good at, and all of us, I think, understand it pretty well, but I don't think everybody does. So can I break it down into really simple terms?
Sure.
Okay. They were approved in 2016 for 2 million square feet of development on their site. One of the allowed uses for that type of area that they were zoned into and land use allows is data and information processing.
Correct.
They can do warehouses, you have a whole list of things, and that's all permissible. Some have to, be approved at different levels, but everything on that list is potentially permissible.
Yes.
So right now, they sit here with 2 million square feet of allowed data center use,
Yes.
if that's how they choose to configure their site. So that's where we are today.
Yes.
Okay. So whatever we decide on this other application does not stop them from developing that other 2 million square feet.
Correct. Your decision will not take away their current development order, which is the 2,020,000.
So sitting here today, they can build 2 million square feet of data center by right.
Correct. Through staff approval.
They have to come
yes.
through, but they've got to, you've got your standards they've
Yep.
got to meet. But beyond that, they can do that.
Yes.
Okay. So I just want to be very clear. This is where we're starting from
Right.
in this case. So I think that, why, and following on to Commissioner Powell's question, when this is, that whole site now is by right, and they added on, we approved the add-on of the other 62 acres. Why does this master plan, because it is in compliance with the comp plan, why does this request come in front of the board as opposed to staff level or DRO approval. I'm not going to say DRO, staff level approval.
Okay, so the master plan that we have, the development order that the board approved was for 2,020,000 square feet. Administratively, we can add 5% or 5,000 square feet. That's the most we can add administratively.
Okay.
They're asking for 1.5 million.
Okay, all right, very good. Thank you.
Commissioner
And-
Sacks?
And I'm rounding, just, in my presentation, I'm doing a lot of rounding, so.
We appreciate that.
Yeah.
Yes. Commissioner Sacks?
Thank you, Matt. Thank you, Vice Mayor. Wendy, could you put that back on our screen so we can read it easier? So it's not so much that they could have gone through DRO because it is a data center and it was approved in 2016. But the uses for the 2016 approved data center are as listed here in front of us, right? One of them was an education center. One of them was a call center. You know, people make mass calls to sell you land in Arizona or someplace. So, but none of the uses in 2016 contemplated the uses that they have applied for today because it didn't exist in 2016. Isn't that correct?
No.
So high link, hyper, and I don't know the magic words here, data centers existed in 2016.
Large-scale data centers across the country did exist. They started constructing them roughly in 2010.
And so it doesn't say here in the uses that they applied for in 2016, that data center, that is what they could have done.
You're correct. At that
So-
time, the zoning director at that time, when this application came in through planning and zoning applications, determined that the data center fell into the data information and processing use.
A little bit like data processing in the old days, where they put in cards with, you don't know this about Flores. You weren't around, you were in grade school, but my dad used them in IBM, and that was the data processing of years ago. Today, it's all
Technology's changed.
hyperlink and all. Okay, good. So I wanted to make sure that what was approved, which you all approved, and the board, all right, in 2016 is not what they are applying for today, the uses.
Well, in 2016, in the backup information from when the land was entitled with the Economic Development Center use, it was stated in that staff report, that staff was aware, presented it, that it would be a large-scale data information and processing use or a data center, and that as part of that backup, it said roughly around 1.2 million that they had proposed at the time. They knew that it was going to consume a lot of energy, and why it was in the location it was adjacent to the FP&L plant.
Right.
So that was in the backup, yes.
Because if we knew, we in the county knew that it was going to have the effects that they are saying that it's going to have today, we would not have approved an elementary school within so many hundred feet.
I
I mean.
remember the
I-
timing of Arden, but yeah.
Right, okay. Thank you. I appreciate it. Thank you.
Ready?
Go ahead.
Okay. Okay. Okay, so the current development, I already said this is the master plan. A master plan is different than site plans that you see because it just looks like a big bubble. And the Unified Land Development Code says that when the board approves a master plan, after the board approves it, a site plan is required to be completed administratively. So what they show on the master plan, then they have to site plan. So what we have, this is probably a little bit, I think I'm going to go to my next slide here. This is the master plan again. This is their proposed master plan, and you can see ultimately it really didn't change. It's still a bubble, and it will change the square footage from 2,020,000 square feet to 3,594,564 square feet. you've seen master plans before. They generally have more than one pod. Residential developments have master plans, and you will see those bubbles. We had one just yesterday where they were deleting part of the open space, and that particular planned development had up to, I think, 11 or 12 pods in their master plan. You're not seeing the location of all the houses, but you're getting the intensity and the density assigned to it. So this is the intensity that's proposed, 3,594,564, so roughly 3.6 million. Okay, so once the
One
board
moment,
approved,
Commissioner
go ahead.
Flores.
I just, you went over a slide really quick.
Sorry.
Can we go back to?
One more?
One more. Okay, I think this is a great slide that we were discussing earlier this morning about the numbers, how it changed from 3.6 to 3.5. What they're now requesting is an increase of 1.574. The warehouse, what it's gonna be, what they're asking is $1,032,000 now for data and for data information processing, and 216,000 for minor utilities,
Oops.
right?
Yes.
Okay. The applicant does not challenge that, correct? Because earlier we had a misunderstanding regarding numbers.
So
This is what the application states, correct?
the April 2026 details is what would be the totality of the master plan with approval today, yes.
Okay, thank you.
Yes, which is the column on the right.
the right.
So
Thank you.
they're requesting to increase the overall square footage, 1,574,564, which would give a total for that development, 3,594,564 square feet. So, and that is a slight decrease from what was in the December backup, because they modified those numbers. Okay. Okay, so this is the master plan. Okay, so when the board last approved the master plan in December, and actually before that in 2016, they came through and got site plan approval. And their site plan at the time, and it's shown on the screen, is 1,200,000 square feet of warehouse and 206,000 square feet of data information and processing. And the remainder, 614 square feet, is future, and it's not site planned yet. But that total, when you add up all those numbers, is 2,020,000 square feet.
Wendy,
That's what their
can I
current
ask- I'm sorry.
administrative development order is.
This included the additional 60-something acres?
60,
that-
yeah,
Okay.
yeah. Let me skip through that. Okay. This is the concurrent site plan that's in, that is pending a decision from the board right now, okay? So the master plan is showing the 3.5 million square feet, and this is ultimately the site plan that would implement that 3.5 million square feet. So you have the 1.2 million square feet that's already site planned. They're proposing 612,000 square feet of data information and processing, which on this screen, it's on the bottom, which is actually to the west. They have around roughly 420,000 square feet to the south of the warehouse building, along with 216,000 square feet of minor utility. And then what's on the top side of the screen, which is actually to the west, is 1.146 million square feet of warehouse.
One moment, Commissioner
Yes.
Sachs.
Hi, I just wanted to get into this a little bit, Wendy. What is going into, first of all, the 1,146,560 square foot warehouse?
Yes.
What's going in there?
The uses that the use they have proposed is warehouse, so it would be ultimately long-term storage.
So we need to know, could be ballistics, could be fireworks, right? So in the plans, we county know what is planned to go into that 1 million square foot. Bring it back up again. I don't need to look at myself.
Bring it.
Yeah.
On our
what-
screen,
what's-
it's on our
Oh,
screen.
okay, I'm sorry.
Yeah, what is,
Okay.
yes, it's okay. What is going in there? What have they said is going in there?
In the 5 buildings and the blue buildings, I would say,
The
is
1
just
million
approved as warehouse. which is
Warehousing, but
storage.
for,
Long-term storage of
Of-
businesses. It could be a contractor that is, has a plumbing business. It could be a tile contractor.
we don't know.
Yeah, we know
We
that
don't
it's
know.
warehouse. That's,
We don't know what's going into 1,146,000 square foot of warehouse. We don't know. Right,
we don't have the end user, but we know it's warehouse. That's
good.
what we.
It's a
know.
warehouse, we don't know what's inside. How about the 1,200,000 square foot of warehouse on the left, to the left? We don't know what's in there.
The end user, no. We just know that the use that they have approved is for a warehouse use.
Okay, for warehouse use.
Mm-hmm.
Do we have some, okay, it's warehouse use.
Mm-hmm.
Okay. Could it be ballistics or fireworks or?
Fireworks would most likely fall under the definition of heavy industry. We have a definition of, and that would be a different type of use,
So
which
light
wouldn't be
indus-
allowed here.
Light
It
industrial
has to be light industrial
could
uses.
be,
Like like a contractor that sells tile, or a plumbing
plumbing.
contractor, or somebody that wants to just store their
Stuff.
their s- yeah, their things that they're going to sell. Yeah.
If I
Okay,
could,
thank you.
maybe perhaps ask, how much are we actually allowed to know what a warehouse is, or
I just want to bring a
Legally.
little bit of clarification. When these warehouses, if they were developed in the future, and they come in and they do sometimes the shell contractor will do a shell, and then they'll do tenant fit outs for the interiors of those. And then when they actually go into business, they'll come for a business tax receipt. Those business tax receipts tell us what they're going to be doing within those bays. We have to sign off on those in the zoning division. So that isn't a way of us confirming what they're doing and that it meets the rules and regulations within that land use.
Are they required to disclose that while they're doing this application?
No, they are not.
Thank you.
but that's a much later stage in
Much
this.
later,
that's,
much later,
For
yes.
which business would go into that, but there's still a process for it, it's just not a part of this particular.
Correct, that's part of the checks and balances, but this is big picture. That is definitely at the
so the
building
big
permits.
picture, and let me go ahead and respond to you. The big picture is that today, do we know what's going to be in those warehouses?
No,
No.
we do not.
Thank you.
Commissioner Flores?
Just yes or no's.
Okay.
Could they then come back and ask to do a change of use
Yes.
by administrative right,
If the use was administrative, yes.
which we highlighted earlier that they were administrative?
There's
Okay.
several, yes.
Is there currently an application, because there's another partner in this,
Yep.
asking for 1.2 million of data center?
Yes.
Okay, thank you.
Commissioner Weiss, your light was on, or you? No, okay, Commissioner Marino?
Just for clarification, we don't approve users. That is why the process of getting their business tax receipt and permitting is in place. We do not approve the end user.
Not in this situation.
Not here.
Not in this
up here.
situation, and unless it was a fast food restaurant or something like that.
If
You'd
it's
be-
within the permitted use, we here do not approve the user.
Right.
Correct. Okay, I just wanted clarification because we're dancing around it, but that's not what we're doing here today, and that's not what we do here anyway if it's a permitted use.
Right.
And then they go through the whole process of permitting and business tax receipts and make sure that they fall under the categories that are permitted.
Correct.
Okay, thank you.
Okay.
Okay, so to go along with what Commissioner Flores was asking, DRO application 2026-966, we have this application in. So you can see in blue, that didn't change, 1,200,000 square feet of warehouse. So PBA has made this application. And I had shown the current approval, which on the bottom side of the screen, which is west, had 206,000 square feet of data information and processing. The applicant has a request in to convert and add square footage for the data information and processing to add it up to the total 820,000 square feet. That brings you to 2,020,000 square feet. That's contemplated in the master plan. That is the current development order. So that is an application that's under review that was submitted by PBA, the applicant before us today. We also have another application in, and that was submitted by the other property owner. And you can see in yellow that they've requested to convert their 1.2 million square feet of warehouse to roughly 1.2 million square feet of data information and processing. They are not touching what the current site plan is, because you can see it still says 206,000, because they don't have the authority to edit that portion of the site plan. But they're proposing to edit their portion of the site plan, and that's still under the 2,020,000 square feet.
Hold on, Commissioner Weiss?
Just to clarify, this is not in front of us.
No, I'm just showing you what the
I
potentials are.
just want to make sure that everybody understands this is not in front of us.
No.
Can I ask for clarification on the application that is not before us? How much of that application is a part of the 2.02 million original square feet? Are they pulling part of the original 2 million?
The current application that's before you, right? That's what you're asking?
The other application? Are they not part of the overall MUPD?
They are. These are all part of the overall MUPD.
Okay.
My
math isn't mathing, I'm sorry. If they're applying for 1.2,
Right.
that only leaves 800,000 for our application that we're voting on.
Your application is to increase the square footage 1,500,000 ...
Almost
Yeah.
1.6?
That's
Okay.
above the 2,020,000 already approved.
So then if this were not to pass, that would leave the current applicant with
If
500,000 square feet?
If you didn't move forward, or the applicant withdrew, or the decision was not to approve the increase in square footage, they still have 2,020,000 square feet approved.
Okay, there's where my math is having problems. If they still have 2 million, how do we also have another application for 1.2?
We don't. The 2,020,000 that's approved encompasses the 1.2 million. That's part of the 2,020,000 square feet. What I have on the screen right here is part of the 2,020,000 square feet that's already approved.
Okay, keep going.
Sorry.
Oh, I'm sorry. Commissioner Powell?
Thank you for that. Wendy, just go back to where I was earlier. When they added the 64 acres
Yes.
to the GAPO, or to the, is it the GAPO or is it EDC that they added it to?
They modified the future land use
Yes,
for that property too, and it was added into the GAPO.
okay. If this was done concurrently, let's just say the 1 million square feet that we're talking about, because we're here, it's a development order amendment because it's over the 5% that they're requesting an increase of or change. If at that time they had, and this didn't happen, but I'm saying, requested an additional 1 million square feet of EDC uses while adding 64 acres to this EDC to this
To this development.
development, would we be here today? Because they would have been able to do that Am I wrong in thinking that with the additional 1 million square feet, it would have been an administrative approval because they added an additional 64 acres to what was, I think, 142 acres or 138 acres?
The addition of land area for this development required them to rezone and change their land use. It was
Yes.
a public hearing application. If they wanted to add 1 million square feet at that time, it would have been a development order amendment in addition to the rezoning to add 1 million square feet to the 2 million that they already have. And they would have 3,020,000 square feet
Okay.
proposed and at the will of the board.
It would have still been a development order amendment, but it
Yes.
probably would have run concurrently.
Yes, it
Okay.
would have run concurrently.
Thank you.
Commissioner Flores?
Yeah, I wanted to piggyback on Commissioner Weiss's comments regarding that second application, the converting the 1,200, which is by the WPB Logistics. It's not what we're reviewing
Nope.
today. That's not what we're looking to approve. However, it is public record that this application is currently in our queue,
Yes.
and they are looking to convert that into data
Information
center,
processing.
information
Yep.
center. So there's implications to what we approve here today. Is that true or false? Because if we approve 3.5 and we approve PBA Holdings at 1,032,000 data information processing, and then that other applicant wants to convert their 1.2 million into data warehouse, that implies that it could be up to 2 million and some change.
Yes,
2,332,000.
yes.
Okay.
So while the master plan that's before you is showing 1,032,000 square feet, we do have this application in for 1,200,000 that they would administratively modify the master plan to be the 2 million
Right.
square feet
Okay. So the information that we're discussing today,
is the increase in square footage.
right? But it's all public information. It's
Yes.
coming down. Your team will be reviewing because this is administratively correct?
Yes.
Okay. Thank you.
Commissioner Weiss?
Sorry, but I'm getting confused because of what Commissioner Flores just said. There's another application for PBA to convert some of their warehouse over.
PBA currently only has 206,000 square feet of data information and processing site planned.
But they have, but then they have they have the 614,000 future phase.
So they're coming in to site plan that 100% on their property as data information and processing, 820,000.
Right, but that's not in front of us.
No.
But
Because all those
It
numbers are
almost-
part
but
of the 2
It
million.
sort of sounded like when Commissioner Flores was asking that's somehow part of this application.
No, I mean, it's part of the overall 2 million square feet that's currently approved. This site plan, the 820,000 that they have proposed administratively, the 1.2 million conversion of uses that's being processed administratively is all under the 2,020,000 square feet that the board has approved already.
Okay, when those applications go in?
When? When did they come in? We had one come in earlier this year and one that's pending
say
sufficiency.
earlier this year?
Like January or February, right?
Is there
January
a
or
reason why
February?
that one hasn't been processed?
They're being processed.
But I mean, why it hasn't been moved?
Approved yet?
Yeah.
They're still addressing outstanding issues from staff.
Oh, okay.
Yeah.
No more lights? Go ahead.
Okay. I might as well skip over this one, but I just, this was just showing you what the 2 million square feet, if both of those applications went through, 2,020,000 square feet for WPA's 1.2 million, and the PBA's 820,000 square feet would be 2,020,000 square feet of data information and processing. None of it is built. And let's say they get this approval, and in 2 years they say, I don't have a market for data information and processing, and they can come back administratively and switch the use out for something they can deal with market-wise. Okay, so this one I was just trying to relay. The areas in yellow ultimately are the 2,020,000 square feet. The areas that I have in blue, purple, and orange is the 1.5 million square feet that's being requested to be added to the development, okay? So roughly 1.14 million of warehouse is on the master plan, and 280,000 for data information processing, and 144,000 for minor utility. So I tried to color code it, hoping that make it a little bit more visually, but that's what we have. So included in the backup, staff have included a numerous number of conditions of approval that the applicant has agreed to, and we're not working in, closed, your staff that we have work alongside with me. Land development is here, traffic's here, planning's here, we have water utilities here, fire's here. We've all evaluated this application, is as well. So I can't thank any of them enough on all of their work and expertise that they've provided. But we've included conditions of approval as it relates to any potential adverse impacts, because we need to make sure that whatever uses go on here, regardless of the use, because it's an economic development center, future land use, that those adverse impacts don't go beyond the property line. So that's why you have all of our proposed conditions that include noise, landscaping, berming, wall conditions, setbacks for the use for data information processing, setbacks for generators, testing of generators, if they propose to have generators, that they're testing them at certain times of the day. What else do I have in there? We have modifications to the noise. We actually have conditions for the batteries and where the batteries are placed to make sure that they comply with our fire and environmental standards. Let's see, building, architectural, we've included architectural conditions as it relates to maximum height within 100 feet of the property line to ensure that any of those potential uses that could be there, not just data information and processing, but there is a maximum height along that eastern property line that is in the closest proximity to the Arden residence. We've included conditions, engineering conditions that talk about releasing of easements, ensuring the stormwater drainage, that there's traffic requirements and turn lanes that are provided, updates to their noise studies. We have lighting conditions. Typical industrial uses have 40-foot high lights and large spillover. We've reduced the heights down and the foot candles at the property line to make sure that there is no intrusive lights. What else? Lighting, water. We have the water conditions that was previously discussed in coordination with our water utilities department, and conditions on removal of the dirty water or the water that needs to go off-site. So with that, staff is recommending approval of the increase with all of our conditions that are included in the backup.
Okay, we have a number of lights. Commissioner Weiss, I think you were first.
Thank you. Do these conditions, do they apply to the entire site?
So we have in the add delete, we've split them apart. because we know that there is a question on ownership and people that don't have consent for this application. So we have conditions that apply to the overall site as it relates to landscaping. And then we have conditions that relate to the 1.5 million that's proposed, which relates to the noise, the water capacity, updates to the noise studies. That's going to apply specifically for the 1.5, which is what I
The
did
addition.
as, yeah, the addition of the 1.5 million square feet. So that's the B, C1B list of conditions of approval. Now,
But that's only, I just want to be clear, that's only assigned to this
One-
application that's in front of us.
Mhm.
The previously approved applications, other than this landscaping that you talked about,
Mm-hmm.
this does not apply to.
It doesn't, to some extent. We are evaluating
I
those
understand,
applications,
but I'm just,
so
I
yes,
want to just clarify
Yes.
for myself.
yes.
This, what we're talking about is what's on this application
Mhm.
that is in front of us. And those conditions do not apply to the rest of the property, except you said the landscaping. Okay. And if we don't pass this, then
If we don't pass this, none of those,
none of those conditions carry on. Okay,
just the conditions that are in the current development order from 2025.
okay, thank you.
Commissioner Flores?
All right, I want to talk about the legal issues that these individuals are having, right? There are two
Okay?
parties that own property in the master plan, is that correct?
There's a PBA, the Master Association, and WPB Logistics.
So there's three entities that own,
You wanna
Yeah, there's
respond?
In the
a
master plan.
property owners association in
Yes.
there that would own like common elements, the roadway.
got it. And in regarding this particular application today, because we're talking about a master plan, correct?
Correct.
Could one of the applicants, by our definition, change a master plan without consent of the other?
Yes.
Why? Or because, what's the verbiage or why?
Because there is no requirement in our ULDC to obtain the consent of the other owners of a planned development to make changes to the planned development. It's a
So you, technically today, our actions will carry forward.
Your actions would carry forward, yes.
And could those be challenged?
Whatever decision we make today,
Regarding the master plan,
yes.
because that second group, WPB Logistics, did not consent to this master plan application submittal,
Right.
could that be challenged in court?
Sure. In fact, we are currently being sued by them.
So we are named in that, okay, that's what I wanted to
Right,
get to.
so I would caution what we discuss concerning.
Got it.
Can I clarify, though? Even though we don't have consent from them, zoning staff is responsible to make sure that we're not taking away their rights. They have 1.2 million square feet of warehouse. They have a development order for that 1.2 million square feet of warehouse. We are not changing the 1.2 million square feet of warehouse. It's still part of the proposed application. So they didn't. Very similar to another application that came through up in the northern county that eliminated a racetrack. That particular development was an MUPD, and there was one parcel that held out consent. And we had to make sure that the intensity and density on that site remained, and they didn't edit it. So that was still part of the overall, even though they didn't have consent. So.
Was that challenged?
that,
Oh, yes. But yeah, for other reasons. It was, but it, yes, that was.
not from that
was
owner,
fun.
though. And then a regular MUPD that comes through for a shopping plaza, and a fast food restaurant wants to add square footage. We will get consent from them. We have asked the applicant to attempt to get consent from the rest of the shopping plaza, but as long as they're not changing any aspects beyond what they own, we process that application, and you
As
see
long as
them
they're not
regularly.
limiting that other applicant, we can.
Yeah.
Okay, thank you.
Commissioner Sacks?
Thank you, Vice Mayor. And this is for the attorney. So if there's a pending lawsuit, is there a motion, has there been an order of injunction against the Board of County Commissioners, sir?
No, there is a order denying a motion for a temporary injunction against us and against PBA basically trying to stop the hearing or get them to withdraw their application. And the court denied that.
And our county attorney's office is defending the issues of going forward on this.
Of course, yes, we will be. We were just added on Friday afternoon, and then I believe we were served on Monday, and the judge entered their order denying the injunction on Tuesday. I think it was Tuesday. Or maybe it was Monday evening. It was the 13th.
Okay. Is there any reason why we needed to move forward on this application today rather than waiting until these legal issues were resolved? And when you said, be careful what you say, and I think you said that, did you not?
I did, yes.
Okay. Why, as a county commissioner, should I be careful of what I say when I'm resolving an issue before this county commission because there's a pending lawsuit? I find that is it really is an effort to silence some of us. I don't even know.
Commissioner, I would never dream of silencing you.
Thank you.
I
Smart
don't
man.
even think I could.
But
There will be no comments,
But there
please.
will be, but you see, representing 225,000 constituents, and each one of us do, it's almost a chilling effect on where we are proceeding on this application, because I'm sure this lawsuit is public record, but should we not have, and I'm asking you, should we not have paused this application and our discussion, a free, transparent discussion, until all the litigation has been completed so we can speak freely?
No. I mean, you can speak freely about this application. Nothing is stopping you from speaking freely about the application. We should not have paused it. In fact, the court agrees that we should not have paused it. And so I don't
Okay.
see, and
Okay,
plus,
so-
we have a statutory deadline to process the application.
What is the statutory deadline?
180 days.
Okay, so when is that date, so we know on the record? What is the date of the, maybe I should ask Wendy, what is
So-
the drop date for
So
this?
the statutory deadline was April. And then the statute also allows to do extensions if both parties agree. Both parties agree to an extension to today's hearing.
Okay, so today's a drop dead date?
Yes.
On terms, okay.
Unless
Okay, and the
they
court
agree.
did say, go right ahead, you can speak freely, right?
I mean, the
I
court.
mean, maybe he or she didn't say speak
Right.
freely, but we can proceed without prejudice to any of us.
Well, we can proceed, yes. I mean, ultimately, the case will go on. This is just a preliminary injunction, but the court denied their preliminary injunction, which was a request to stop this hearing today.
Thank you. I appreciate it, thank you. Now, Ms. Hernandez, well, let's look at, the applicant has some very good experts. Who are our experts on behalf of the county for water, for noise, for all the issues that were brought up by the applicant?
Your,
Looking at him, right?
Your
Looking at her. Okay.
myself, land development, planning division, we have several along the wall in the back, fire,
And have they, and I know you submitted appendixes late last night.
Yes.
Which we received again today, thank you for that. But do we have those expert reports that will substantiate the issues of water, heat, noise, electrical output and things like that contained for us to review before we make a final decision?
We have the documentation submitted by the applicant. That's what we have.
Okay, and we are relying on that as a county?
Yes.
Okay, thank you.
Okay, there's no other lights on, so I think I'll go. Or Commissioner Powell, did you? Okay, he's going to wait. I'm going to go. First, you kind of ran through a long list of conditions. How many conditions are we putting on this?
Oh, I didn't
Don't have
count
a count.
them. I'm sorry, I'll have to count them.
It was
Yeah.
pages of conditions. And I understand that they have agreed to them. I guess this sort of brings me to wanting to ask the question, why all the conditions? We don't have to do this for this category anywhere else, but we're having to add a lot of conditions. It would appear to me because this doesn't actually fit in the category, or we wouldn't have to condition it so heavily. So, no. It's just, again, I'm bumping up on what are we building versus what the category was when this was approved 2016. When was this category actually created?
Data information, I couldn't tell you when data information, it's been in the code at least since I've been here, since 1998.
You said that was in the 30-year mark or so?
98.
Okay.
But it was in 2016 when the zoning director at that time said a data center fell under data information and processing. We haven't done amendments to the Unified Land Development Code to ultimately codify and clarify this specific use in the code.
Okay, because, and I would say that's because we haven't had to. We haven't had this yet. This is the first one that this is coming along, and now that it's here, we've had to heavily condition it. We're trying to fit this square peg in a round hole, but way different even than that. At what point do we have the ability to say if we have to heavily condition something so much that it's not actually in our comp plan? We need a new category. This doesn't fit. I know we're arguing light industrial, heavy industrial. This is like tech industrial. It doesn't exist yet. So at what point do we have the ability to address that? Because it's new. When do we get that opportunity? And is our only chance to get it right just to heavily condition it to the point where we're trying to make it fit?
Well, we get that opportunity now with the moratorium, and we'll work on, staff will work on.
Well, the moratorium doesn't have anything to do with this
That's right.
application.
Right.
So at what point are you telling us that we do not have the opportunity to say that this is not what this is not that? We are going to create that, but right now there is no that. And I'm sorry I'm using simple terms here, but I don't want to get hyper technical here because one is not like the other. Obviously, we're having to, you don't even know how many conditions. One is not like the other. And we have to create the other because it does exist and we have to acknowledge that. There has to be some sort of option here. This cannot be the first time in the code where something has come in that didn't really exist before. At freestanding emergency rooms. It was medical offices, and then they were coming in under that, and then we realized, you know what, it is a medical office, but it's not that. We had to change it. How does this work? Anyone?
I'll take a stab. And Vice Mayor, directly to your point, yes, if you take freestanding medical, they evolved. We did have to pigeonhole them into previous uses, recognized it was an evolving area of development, changed our code to match it. recognize the point on data centers. What may be built today does not match what might have been intended umpteen years ago, but you did give that direction yesterday, as Darren indicated, begun the process with the moratorium and the code changes, but applications that are in are bound by the code that's in place at the time they submit. The ones that are in now are bound by the code that they have. Future ones, though, would be subject to what this board may change.
Could I ask staff, would you recommend approval without all of the conditions that you've put on this property?
No.
So then we are not approving what was in the code, because if you are telling me that you would recommend denial based on what's in the code, except now you've added all these conditions that make it acceptable to the code, then it's not in the code. No, please.
Probably two different things. Do not disagree necessarily on the evolution of the concept of this use. No disagreement whatsoever. Your words about the conditions in general, I would say that gets to site specificity as well. So any given one might need different conditions than another. Totally understand your point on the general concept of the use, but the number of conditions and their application of them, while it does reflect the uniqueness of the category, it also reflects the site specificity and fitting the different uses. Data center's not the only use on there, knowing that there's residential to the east, a different power center to the west, things like that. Any site presents uniquely.
Okay, Commissioner Powell, I think you wanted to weigh in on this. He's our resident planner here too, so.
I think so, Madam Mayor, Vice Mayor. I think we have a little bit of a difference of opinion on this. When the young lady from Wantman earlier came up and spoke, and she talked about the categories, and she showed something under NAICS, the different uses under that classification. And NAICS would be the North American Industrial Classification System, where the different uses are broken out, and it would have either been NAICS or SIC codes. And those uses, even today, if they were to in my opinion, and I'm just my opinion, to reorder, data centers probably would still fall under those same categories. I think, and this might be a question for the applicant, I could be wrong, I was able to pull up one of the staff reports from an application that was submitted back in 2016. And the staff report, and things have changed, the staff report here indicates that the applicant proposes the development of 2,020,000 square feet of uses, of permitted uses permitted within the EDC MUPD zoning district. Now, this development would include 1,200,000 square feet of what is considered data information processing center use. I think at the time, even if you look at historically some of the justification statements, some of the staff reports, the requests at the time even indicated requests to eliminate parking because of the amount of parking spaces that wouldn't be needed. So without us being in the shoes of the applicant to holistically say that the intent was never to do data center, maybe AI wasn't around at the time, but I do believe, and the applicant can speak to this, that it was probably the intent to make sure that data centers or this particular type of use was moving in this direction. AI wasn't around, but the idea was they were eliminating parking. It's in the EDC, which is an economic development center. There's no residential uses that can be west of Arden. There's a 400-foot wildlife corridor, a 500-foot canal, and then the 250-foot barrier between Arden and the residential properties. And the conditions of approval that Wendy had started to talk about, and I'm just thinking if I were a planner for the county, what you're looking at, you asked the question if we would have allowed this by right without conditions of approval. I think staff's intent with conditions, and it's not just data centers, with conditions on any project, especially, we ask all the time for additional conditions because of the concern for the residents who we serve. Our goal is to make sure that we're putting protections in place for the individuals who will either be residents in the area or those of us who live in Palm Beach County. And I'm looking at the enhanced conditions, and there's a lot of conditions inclusive of the distance in terms of where batteries can be, lighting, the maximum luminaire height shall be 25 feet. The maximum illumination level shall be a maximum illumination of 10, maximum illumination of 1.0. We're talking about the decibels and even the metrics of how we did a sound test earlier, but that would have to be measured between the hours of 10 and 2 p.m. Those are in the conditions of approval. Another issue that I see, all buildings with a data information and processing use, and this is specifically for the property that we're looking at, the subject site that's owned by the applicant today, shall be set back a minimum of 850 feet from the east property line. If it's set back a minimum of 850 feet from the east property line, you're then even looking at an additional 400 feet between that and the wildlife corridor, and then another 500 feet from that and the L8 canal that's sitting there. That's kind of holistically why I asked the question about the 64 acres that was brought into the site. The challenge is, when you look at this, and our challenge as the board is, our staff has recommended approval. Our challenge is to test or realistically challenge what we see here in writing against what staff has presented, and also what, I think there's some experts that will be presenting on behalf of the residents later to look at all of that holistically and make a decision. But we're looking at information that's presented before us, and a lot of it, there's a lot of questions that I have that are either clarified or are still questions after reading the staff report as well as the conditions of approval. So the reason I wasn't going to ask that question is, I wasn't going to speak, is because I still want to hear from the residents, and I also wanted to get clarification in terms of data information processing and the data center use. The state legislature, of which I used to be a part of, that's another story. The legislature has decided that data centers are large load users, which is completely different from the NAICS or the SIC codes or uses that are even identified in the ULDC. So we've got a lot of challenges to kind of iron out. I think there's more experts that will testify on behalf of the residents. We've listened to our staff who, many of our staff are certified in either planning or zoning or or their certification. So we're testing our staff against some of the best. So our challenge is to look at the evidence that's way before us today, but there's some, I'll put it like this. I don't think our staff has not done a comprehensive job in terms of looking at everything that's been presented before them and putting together a staff report, if that's as clear as mud.
I think also, as uses evolve, and I'm not just saying data center, but a lot of our uses evolve, and we have to look at what the applicant is requesting, and we add conditions in order to deal with the evolution of those uses that the code doesn't catch up with. So, just like us talking about fitness centers yesterday, the fitness center being a broad use, the fitness center encompasses pickleball or ballet studios, and when they ask for it, we're evaluating it and asking the questions, what exactly are you doing? Is it a HITS or is it a pickleball court? And a pickleball court might have different ramifications than the ballet studio. So we pivot and move, we evaluate, and research and review all land codes around the country and the impacts that everybody is facing, so.
Okay, well, I don't see any other lights from board members. Would it be appropriate if the applicant wanted to do a rebuttal at this point? Or we have expert testimonies coming. Are you guys good to keep going?
So there's a point I'd like to clarify with Wendy, because I was a little confused with the question from Commissioner Flores, but the rebuttal would be, I would wait till after all of the other comment.
Okay, did you want to confirm this now, or do you want to
I
wait?
could.
Sure.
So the only question, there was the conversion of warehouse, and the 1.2 million that's approved can be converted, but because things get conflated, it's the 850-foot setback condition that's being imposed today would mean that the warehouses that are within that 850 feet could not be converted in the future without a vote of this board.
Converted to
I'm sorry, to data and information processing.
that use, correct, but they
Okay.
could
I just
change
wanted
to
that
other
clarity.
uses, yes.
Get it?
Can you pull that DRO and explain this to me visually?
Okay, I think this is probably the site plan you want to see. So the top of the screen is the east property line. The 5 blue buildings that are along that property line are the proposed warehouses as part of this increase in square footage. Staff has included a condition of approval that limits data information and processing uses, has to be set back 850 feet from that east property line, which is at the top of the screen. That would still allow the buildings in yellow and purple to be data information and processing. But the
But not the
buildings
blue.
in blue
Not
are
the blue.
within that 850 foot. So those would be other EDC uses. Warehouse, manufacturing, yeah.
I agree. I 100% agree with what you're just saying.
It was the low hum of a baby.
The 3 buildings on the north side of the site, which are warehouses, like about where is the 850? Is it halfway through? Is it a quarter in? Is it a third?
I would say that it's roughly on the bottom side of the blue buildings, the 3 buildings.
The long ones.
On the west side,
The west side of the blue buildings
that
is
would be the
roughly
cutoff?
the 850 feet,
So sort of between the blue and the yellow?
between the blue and the yellow, yes,
That's 850.
correct. The property line of,
Could the purples and orange be, they're not within the 850, correct?
Those are proposed as
those
data
are
information.
proposed,
Right.
but they are more than 850
But
feet.
could those go within the 850?
No.
No, you wouldn't be able to.
I know, but they can change the site plan later.
Oh.
That's my question.
Right,
Could-
but
could-
ultimately, the line is drawn 850 feet, so no data information and processing would be in that
I know,
850
but
feet.
we're talking, I guess I'm referring to minor utilities. Could minor utilities be within that 850?
Yes. Minor utilities could,
Could.
because the condition I drafted is specific to data information and processing.
But at this point, it's interchangeable.
No, not the
Yes,
use.
because it's administratively.
No, not if there's a condition of approval. Just like if you were to put a condition, that says you cannot have any manufacturing and warehousing, that condition is what we go by, and there would be no manufacturing and warehousing on the site, if that was a condition. If you said in the
So could I
1
potentially
point,
say, in this condition of approval,
Mm-hmm.
that there won't be any more data information processing any more than 2,020,000 square feet?
if the evidence was presented to say no more than 2,020,000 square, , 1 point, that of the, new- the, 1 point that of the, new- the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 square, the 1 point that of the, 2 million 20,000 if it's at the board's will to allow the increase in square footage and prohibit data information and processing in the 1.5 million based on the testimony, then that would be the condition that would be included in the resolution.
Okay, thank you.
Okay, Commissioner Powell?
Wendy, clarification. Brian Seymour asked a question with regard to the other owner not being able to have a data center within 850 feet of the property line. Let me ask this question. I'm looking at the conditions of approval, and the conditions specifically state for the following conditions apply only to the properties owned by PBA Holdings, Inc., or assigns, which does not include properties owned by WPB Logistics, owner LLC, and Central Park Commerce Center Master Association, Inc. So if it applies only to those, could potentially the other property come in and do a data center within 850 feet of the east
No,
property?
because
Okay.
right now, the other owner doesn't own that land.
Thank you.
And if they were to purchase it, they are the assigns.
Got you. Understood.
Just because of the litigation, I want to be very clear. I did not say anything about WPB Logistics, nor am I saying anything about WPB Logistics. All of the property that we're talking about is owned by PBA Holdings. And I know it could get a little confusing, but all of it that we're talking about today, which we showed in green, when we did our presentation, is owned by PBA Holdings.
Thank you, Mr. Seymour. And for the record, neither did I. I just read it. I read a line that is in the condition of approval. So I don't want to be subpoenaed. Okay?
I don't either. Understood.
Thank you.
Okay, we have no more lights at this time. I think Commissioner Flores has the public cards, beginning with, we had groups that organized together and asked for a block of time, and then we have a group of experts, and then we will get on, I think we have people at Vista Center as well, but we'll get through the group and the experts first.
Okay, we have a,
Oh, I'm sorry, hold on, Commissioner Sachs?
Hi, I just want to, maybe I missed it in the very beginning of the meeting, but what is the time for the public to speak? And then for certified experts, if there are, what are the requirements or restrictions on their speaking?
Thank you. We are giving this first group 30 minutes. It's two different groups combined with their experts they requested, and they're going to just go one together with the PowerPoint. I'll set 30 minutes on the clock for them. The others get 5 minutes, and then we advertise to the general public minute 30.
Very
We
good.
have 81 cards for
So we're
general
going to
public.
start with these two groups, 30 minutes each.
No, 30 minutes total. They get 15 minutes, but they're combining
Oh, I
together.
see, okay.
Yes.
And then we go on to the experts, and then we go to
And
the
we have
public.
did you say 4?
we have the one group that has the 30 minutes. We have one expert, and then we have, I believe it's 4 groups.
Oh, 4 groups. Okay, so
So you have
groups,
some HOAs, associations.
Okay, so the expert gets 5 minutes, the associations get 3, general public get a minute 30.
Thank
And then we have 81 cards of the minute 30.
Okay. Thank
Okay.
you, okay.
All right. I just want to remind everybody there will be no speaking out of place and no clapping. I'd like to invite John Eubanks, Janice Ridnour, Cecilia Ward, Santiago Aranzio, and Reynaldo Diaz. This is the first group that has 30 minutes.
And I'm actually going to have to do 2 15 minutes because that's the best our clock will do, so.
Just had one quick question there. Got to find our PowerPoint.
Oh, okay, we have a PowerPoint.
Pull up their PowerPoint, so if you wanted to take.
Actually, we could take the expert first then, if we could do
All right.
the other,
We
while
have
we're getting the PowerPoint.
Brandon Tucker.
Is he up? Here we go. And please identify yourself and your expertise.
I didn't actually know I was an expert, but I'm with the Florida Landowners Association, so do you want me to speak now, Commissioner, or do you want me to wait?
Wait, what?
It just says expert. I don't know. I didn't do this.
I was
so
prepared to speak for 90 seconds, so.
Okay, well, Then you can take your 90 now while we're getting their PowerPoint presentation. Go ahead and take your 90 seconds.
Very good. Thank you, Madam Vice Chair. Thank you, Commissioners and staff. My name is Brandon Tucker, and I'm a Palm Beach County native born in Pahokee. I'm the Executive Director of the Florida Landowners Association, and I formerly served as the Vice Chair of the South Florida Water Management District Governing Board under Governor Rick Scott's term. I'm here today to speak in support of this application from a private property rights perspective. At its core, this case is about whether a property owner can pursue a lawful use of their land through the public process established by Palm Beach County. Property rights are a fundamental principle of our economy and our way of life. They provide certainty for landowners, investors, businesses, and communities. The applicant has followed the rules, invested substantial resources, and subjected this proposal to extensive public review and technical analysis. Importantly, Palm Beach County's professional planning staff has reviewed the application and recommended approval based on the county's adopted standards and policies. Whether one supports this specific project or not, we should all support a fair, predictable, and consistent process. When applications that satisfy adopted criteria are denied for reasons outside those standards, it creates uncertainty for every property owner and investor in Palm Beach County. I respectfully ask that you evaluate this request based on the facts in the record, the recommendations of your professional staff, and the property rights of the landowner, and vote in favor of the application. Thank you, Madam Vice Chair.
Thank you. Are we ready with the PowerPoint? Nope. All right, keep going.
Okay. We have some HOAs. Kathleen Williams. We have the group from WPB Logistics, Tara Duhy, is it Duhy? Dewey, sorry, and Matthew Prince. I got Adina Kerr and Debbie Murphy from Cobra. 3 minutes.
Good afternoon. Just to be clear, I was expecting to have 15 minutes. Is that confirmed?
I'm sorry, why were you expecting 15?
Because we represent a party, an owner of the property subject to the MPUD.
It's your discretion, but yeah, it's up to you.
To be clear, are we allowed to cross-examine this person?
So the board can ask whatever questions they want. The applicant can certainly cross-examine them.
I only ask because this is the attorney that is suing us.
That is correct.
Anything that we should know?
She's suing us, and I mean, I don't know what she's going to say. She's going to talk about this case, but I will certainly be able to answer any questions that you guys may have as a result. But I mean,
I would prefer giving you 10 minutes since we're not recommended to interact, and we'd have to go through our attorney for the interaction. So if you wouldn't mind keeping your comments to 10 minutes, please.
Okay. And to be clear, the lawsuit that was filed is about the property that is subject to part of the application that you're considering the square footage. Our attempt to get a temporary injunction was understanding that you have competing legal mandates, and in order to, if we were successful in getting an emergency temporary injunction, which is what we requested, that would apply to you and you would not have to balance on your own those issues. We have not made allegations otherwise in that case. What we're here today to do is protect in a public hearing, a quasi-judicial hearing about a MPUD that includes property that we own. And to be clear, I represent WPB Logistics Owners, LLC, who owns property outright subject to this MPUD. You've had quite a bit of discussion about our property, notwithstanding that apparently our participation in this application is not required. Similarly, I represent the Central Park Commerce Center Master Association, and they have also not consented to this application, and they own property outright. In addition, as I just mentioned, WPB Logistics is a contract purchaser of a portion of the property. I have, first of all, would like to submit for the record of this hearing a number of exhibits that I have provided at the advance of the meeting, and I do apologize, that's when they were. I can read them by name, or I can just submit the binder for the record, whichever you prefer. So if I may submit them for the record, I am submitting Central Park, June 30th, 2026, notice to board members of association action and lobbying. Central Park, June 30th, 2026, written consent authorizing association engagement of Tara Dewey. Letter dated July 13th, 2026, to the Board of County Commissioners from Tara Dewey on behalf of both the association and WPB Logistics. An email to your staff, who I do want to thank for working with us cooperatively during this process. A withdrawal of consent letter sent to Wendy Hernandez, PBC, zoning from Joe Verdone of Carlton Fields on April 3rd, 2026. A June 1st, 2026 Bloom Parham letter to David Oddie removing the consent of WPB Logistics to this application. A June 1st, 2026 correspondence, Central Park Commerce letter to David Oddie removing consent for this application on their behalf. A June 11th, 2026 letter from Central Park Commerce letter to the county removing consent. Palm Beach County Attorney email responding to the Central Association's notice. 3 letters from Jack Scarola to representatives of PBA Holdings, one dated March 19th, 2026, one dated March 31st, 2026, one dated May 1st, 2026. A copy of our amended and verified complaint, which includes a copy of the purchase and sale agreement, copies of the current approvals, master plan approvals, and a final site plan approval governing the property, Resolution R 2025-0122, Resolution R 2025-0123, and the final site plan. Association governing documents for the association, including bylaws, declarations of covenants, and a certificate of amendment to the declaration of covenants. Ownership documents demonstrating the ownership of WPB Logistics and the association. Sunbiz annual reports filed on behalf of WPB Logistics for 2026 and demonstrated that Matthew Prince is an authorized agent. And also annual report 2026 for the association, demonstrating that Matthew Prince is president of the association. We have a draft plain complaint consent form and the July 2nd, 2026 Palm Beach County Zoning Commission transcript. So I'm sure that took up most of my time. We're here today because, unlike the advice that you've received, your code does actually require consent from all impacted parties of this application. We are clearly impacted. I understand that as of late last night that we weren't provided copies, so I haven't seen them, so I cannot speak to them. We have not seen the conditions of approval. Initially, in the published staff report before last night, there were conditions of approval that applied to our property by property number. We don't know and do not believe that we have had a correct opportunity to participate in this hearing and that we're being deprived due process by not being treated as a party to these proceedings. To be clear, and you can put up any one of the staff's graphics, this is an application on the face of the staff report amending the MPUD, assigning additional square footage, and assigning square footage that already exists as approved, and assigning it to this particular property. That impacts us. Any change to the condition of approval impacts us. And that was made clear by the fact that you've had at least a half an hour of discussion about our property without our voice, without our ability to present how that impacts us. And it's a violation of due process, and it's a violation of your code. So I understand that you have had your counsel advise you that there is no code requiring owner consent. I'm going to take you through the code that requires owner consent. Okay, let's start at Article 2A3, which requires that only 3 people can file an application: a property owner, an owner's agent, or a party, a contract purchaser. There is nothing demonstrating 2 property owners consent to this, and it impacts us. I don't know how you can say changing any conditions of approval or anything about the overall master plan doesn't impact us. This is not an out parcel at McDonald's that you're turning into a Chick-fil-A. This is not a residential development where you have the master developer changing a gate feature where you don't need the consent of the individual lot owners. They're not impacted. They're not paying for it. Their rights aren't going to be impacted. They won't have financial damages. We will, by the decision today if it moves forward. If you do not do what we're asking, which is postpone your consideration of this. We're not asking you to deny it. We're asking you to postpone it so this can properly come before you and our rights can be protected. And that was the subject of the emergency temporary injunction, is just to protect our ability to participate. So I think what has been said is that nowhere in the code regarding MPUDs does it say you have to have an owner's consent. It's silent because it's already covered in Article 2. What it does say in Article 2, sorry, my notes are getting, I'm rushing, so I'm getting a little unorganized. I apologize. Article 2A3 requires consent. It says applications may be submitted by the zoning division by the following authorities: the owner, agent, and a person having contractual interest. This application is not sufficient without it. That's pursuant to Article 2A3A. Zoning application requirements. Applications shall be submitted in the manner and forms established by the zoning division unless otherwise stated herein. 2A3 requires consent, sorry, this is hard to do in 10 minutes. 2B, 2A, sufficiency. The DRO shall ensure that all applications meet all submittal requirements and their requests are consistent with Article 2A, general. That includes the consent requirement. Staff is limited to reviewing applications that are deemed sufficient. Article 2B, A4B. There is no article in the ULDC that's contrary. Article 3E1A makes clear that all other articles in the code shall apply to MPUDs unless otherwise stated. Silence does not eliminate a requirement in another section of the code. So, funny enough, in the initial processing of this application, the county attorney, in the initial review of sufficiency, as a comment issued, and it's attached to my letter, which I've submitted for the record, required the consent of WP Logistics and the association. That consent was provided by the applicant. There was no complaint. We withdrew it. It came out in April. We sent letters. Why? Why is it no longer required? The impact hasn't changed. The request hasn't changed that greatly, but yet our consent is no longer required. So our request, and I've covered the impacted area. We're impacted. The allocation of square footage under property that's governed by the comprehensive plan of an overall total and the allocation of existing approved square footage impacts every owner of the property within the master plan.
If you have closing thoughts to finish, go ahead.
Yes, our request is that you would postpone this. We do not agree that you are under any clock under Chapter 125.022. This application was resubmitted, and that's why it started over at the applicant's request. So at most, it started in April, and it's not sufficient anyway, therefore that clock doesn't start to toll if you don't have a complete application as the statute requires. So you are authorized, you do have the discretion to do the right thing and give all the property owners within this association the opportunity to understand the impacts that this is going to have and participate in a meaningful way, which we have not had a chance to do.
Okay, we have several lights. If you'd stay up here, please. Commissioner Sachs, you were first. Oh, hold on.
County Attorney Adi would like to speak.
Oh, sir. I didn't see you there.
Good afternoon, members of the board. So I just want to first emphasize to you that the representations of Ms. Dewey should not be considered with respect to her request for a postponement. She had her opportunity to represent her client through the courts, which she did, that was considered by a circuit court judge and was denied. So that as to a basis, all the arguments that she's making to you, she had the opportunity to make it to the court saw it differently.
May I respond? Because that's a misrepresentation.
And before we talk about misrepresentations, I also want to point out, and I think this is a proper forum to do it, that Ms. Dewey, she was very quick to point out the letters that she referenced that she sent to me. What she did not send to me, which she is required to under the Florida bar rules, was after they added us to the lawsuit last Friday, that she met with our clients without the consent of the attorneys, which is quite inappropriate. So I just wanted to add that to the record as well.
I notified Mr. Audi and Mr. Leiser that I was organizing meetings and I was not told to stop. I did indeed.
That was way before you sued us.
Yeah, it makes a difference, and it's a first year in law school course where you're taught about the basic ethical requirements of an attorney. So saying that you notified us that you were speaking with the board, which was permissible, was not the same after you filed a lawsuit against the county, and you know that. So
I disagree. We notified them. I see what's
Ma'am,
happening.
with all due respect, you had a meeting with me at 10:30 Monday morning and did not tell me that we had been party to a lawsuit on Friday.
I indeed did. I said that we
You
had
said that
just
you were-
added you
No,
to
you
the
told me
lawsuit.
you were trying to get an emergency injunction to stop this. That was known at the zoning hearing.
And that is exactly what I said. I said we
You
have
should not
added
have met
you.
with me without my attorney present.
Okay. Fair enough.
Commissioner Sachs, your light was on first.
This case is complicated enough that we have to have this legal issue. My question really is to Ms. Dewey, but stay right there, Mr. Adi. I'm sure you knew that today was the drop-dead day for this application to go through, but we didn't get a lawsuit from your office until a couple of days before. So it really puts everybody at prejudice, because if we postpone, that's prejudice to the applicant. If your client had filed the lawsuit, or at least a motion for injunctive relief, a week or 2 or 3 or a month before, this thing might have been ironed out or could have been postponed. Today, we really can't postpone anything, according to our attorney, because it's the last day statutorily for them to proceed on their application. Is there a reason why your firm did not file a lawsuit or at least a motion to postpone before the date that you did?
We were hired in June. A previous law firm did file the lawsuit. We
Is
amended.
that where Jack Scarola comes in? I heard you mention.
No, that was Mr. Dave Ehrenberg's firm was previously representing my clients. They filed the initial lawsuit, which did include a motion for injunction.
Okay.
It did not, when they filed it, the emergency button was not clicked, so we refiled and amended and felt that the county should be a party in order to be subject to it if it was issued. On that purpose, it was denied on the emergency basis. It was denied. It was not a ruling on the merits of our claims in any way. It was just too soon, too quick to get this resolved. And we didn't expect it. We did our best, to your point, having been just recently retained.
Have you tried to negotiate with the applicant at all?
Yes. My client has had several conversations, issued several letters, but did not understand the impacts or what was being proposed as conditions of approval initially until the Zoning Commission staff report was issued.
So the conditions of approval were not public record until just recently?
We did not have copies of them, no. We were not aware that those were in play. They were public record. Had we been involved, we probably would have asked you for them, but we didn't know they existed, so.
If this application is approved today, would that prove prejudicial to your client?
Yes.
Attorney, you have your light on?
Yeah, so This idea that somehow this order denying their motion for injunction is not on the merits is incorrect. The order is clear. The court considered the file and the motion with the memorandum of law that was filed with it and denied it. It's an unqualified denial, and one of the elements of getting a temporary injunction is likelihood of success on the merits. So that necessarily means the judge had to decide that they were not likely to succeed on the merits.
So there's
There also could be an appeal, so it may not be completely, I mean, motions like this are not necessarily always complied with by the court, so there's always, look, I don't want to get into the merits of this, and nor should we. Okay, I find that we are in a very uncomfortable position. We have to take care of an applicant, we have to take care of, communities that are impacted by the applicant's petition. So I would only hope that in the future this doesn't occur at this 11th hour. Unfortunately, we can't, help you and to protect your client. I don't know any of the facts, except that I do know that we cannot postpone today. I wish we could have. But I just hope that in the future, look, this is Palm Beach County. We're going to get into some really complicated issues in the future. So I would hope that from now, we have a little, sit down and try to resolve these issues, or try to find a policy to resolve these issues with staff and our county attorney's office, so that we're not placed in this position. And I know the vice mayor feels uncomfortable. The only thing I can say is, I'm sorry that your client has come to this, and I would hope that that we in the county resolve this type of issue so it doesn't happen in the future, because this should not be happening right now as we're going through an application process and representing the people in the county. So with that in mind,
Just want to make it clear for the record.
No, I want to make it clear to you, Mr. Adi, that probably not was your fault, but I think that we need to telecast. This is not going to be the last of these issues where we have
Commissioner,
lawsuits.
the county followed its process.
Of course
They
we did.
chose
Maybe
to-
we need to review our process. If people cannot file an application, there's only so many people can file an application per our process, maybe we need to review. There's nothing wrong with reviewing our processes, Mr. Adi, in light of what is going to come in the future, what has occurred today.
I agreed. I just want to put it on the record that the position we're in now has nothing to do with anything that staff or the county attorney's
No, of
office
course
did.
not.
That
Of
was
course
their
not.
choice.
It's a process. Our
They didn't do
process
their
is
due
old.
diligence.
Our process is old. We need to review it so this doesn't occur again. And you don't have any objection to that, I'm sure.
Oh.
We're going to sit down, we're going to work on these processes and make sure that we're not in this position again. Thank you.
You're welcome. And just respectfully, we did do our due process. We did do our due diligence. That's why we're here at the 11th hour. And so I need to defend myself against comments that are untrue. So thank you.
Commissioner Flores? Ma'am, you're not done.
I want to echo the vice mayor's comments. I mean, you requested an emergency meeting with me on Monday. I didn't know that you named us in a lawsuit. When we got into the conversation, you said at that point, you did very briefly said, which we named the county. And you kept going. "Rrr." And it sounds like my attorney's right now telling me that you did not notify him like you're supposed to. I don't need an answer. I'm just putting it out for the record.
And just to
that
clarify,
what was
Commissioner.
done shouldn't have been done.
And just to
And
clarify.
I have a policy, personal policy. If the county is named in a lawsuit, I do not meet with anyone without an attorney. Because anything I say to you could be used against me later or against the county. Luckily, at that meeting, I didn't say a word. I just listened to what you had to say. But what you did shouldn't have been done.
I just wanted to clarify, she has a greater obligation, not just to notify us, but to request permission. So just want to put that on the record.
Okay. Regarding two questions, the injunction, that was my original question. Our attorney already kind of highlighted it, but it's based on merit, correct?
Yes, the judge didn't say it was because it was untimely or anything. The judge considered what was in it. There's also a motion to defend, to dismiss the complaint that was on the record filed by the applicant, and the judge said he reviewed the entire file and made a decision that denial was appropriate. Okay. So all things were considered by the judge.
Thank you. And then there was an allegation that this quote-unquote application is not complete. Attorney, would you say that this application is complete?
Well, I mean, staff has certified it for public hearing, so it's complete.
It was complete.
So there's no misinterpretation in our process to say that this is not complete?
No.
Okay, thank you.
Commissioner Marino?
I'm going to jump on a little bit. I scheduled a meeting at your request on Friday at 10:55. At 12:55 is when the amended documentation was in court. There was no discussion about your firm adding the Board of County Commissioners to that lawsuit. Secondly, on Monday at 11:09, in a STET article, and Joel, thank you very much for adding the link to the claim, that was how I found out that the Board of County Commissioners was served. That's why I canceled my meeting with you, because at no point in time did you tell me I had to have representation in the room. And our attorney did not even get the papers yet that we had been served. And meantime, you had meetings with 2 other commissioners. I find that horribly inappropriate and putting all of us at risk. I'm done.
Thank you, Commissioner Marino. Commissioner Weiss?
I don't mean to pile on, but you met with me as well. We had I thought, a very productive discussion, but I had no idea that we were being sued or were party to a lawsuit. And I think my colleagues, I would insist on, if I was going to meet with somebody that we are party of a lawsuit against, to have my counsel with me. And so I don't appreciate it. There was nothing said, but still, it is important to know, and it is our right to be represented by counsel when we are in that situation. So, but I do have a question. So, if this does not move forward today, this new additional square footage, you do have an application also in your client has an application in also for approval to convert their warehouse use to information and data processing. Is that accurate?
Yes, I am not the agent on that application,
But
that's accurate.
that is accurate, okay. So your client also potentially can build, they have I think there, if I recall correctly, is 1.2 million?
Correct.
1.2 million square feet of data and information processing use.
They have 1.2 square feet currently of warehouse, yes.
Okay. And that if in fact this were to be approved, and there were no, and maybe this I don't know if you can answer this question, but my understanding is the conditions that are being promulgated by staff specifically does not include your client's property.
That is what has been testified to today, except I did hear Ms. Hernandez say there are some changes to the general petition regarding landscaping that will impact us. We haven't seen them, so we can't analyze whether or not that's true.
Okay, well, hopefully we can get you a copy of that.
Commissioner Powell?
Thank you, Madam Mayor. And Tara, of course, you and I are friends, so we did meet as well. And of course, information I didn't know, but understanding is best for me. I heard what my colleague said, but I did hear what Attorney Audi said. He indicated that you should have, and can you clarify this for me? you should have requested permission prior to meeting with us. He also indicated that was something you learned in the first year of law school. I know law school is 3 years. I think it is. I'm not an attorney, but I know a lot of them. Is that something that you learned in the first year of law school, and did you not know that, or what happened?
I believed that I had complied. My integrity is very important to me, and I am very upset about all of this. I did my best. I thought I was being as forthright as I could. If I've made a mistake, I've made a mistake. I would never do that knowingly. There was no lawsuit when I spoke with you, Mr. Commissioner Powell. And I did describe and explain the situation that we may have to bring you in for the reasons we needed to, but I would never knowingly violate any sort of ethical rule.
Okay, so you just weren't sure of the county's process with regard to requesting permission and overlooked it?
I thought I had I had thought that letting them know was sufficient.
Okay. Additionally, you indicated that, now this is puzzling to me, that Dave Ehrenberg's law firm, or Dave Ehrenberg's firm, was working on the case. Dave Ehrenberg is with Capital City Consulting. Is that correct?
Sorry, it's Ehrenberg's law firm. There's the firm. I don't remember the name of the firm. I'm sorry.
He has two. So, because Capital City Consulting is working on this case, I mean, is a consultant for the case, maybe? I'm confused.
I can't speak to any of that. That was before I was, I can't speak to that.
Is Dave Ehrenberg involved in this on one side or the other?
No, not on our side any further.
Okay, so, but he was.
I will have to, I don't know the answer to that question. If he personally was involved, I don't know the answer to that question. I apologize. I was not their counsel at that time.
Okay, I'm trying to get clarification only because you said it. I didn't say it. I heard you say Dave Ehrenberg.
The Ehrenberg firm.
Okay,
what I
and
said.
sometimes I'll ask questions for clarification because there's a lot of moving parts.
Yes.
And I don't like being confused, so I just needed to, maybe also the applicant can clear where I'm confused at. So those two things confused me a little bit, and I'm sure that we've got a lot of time. It's only 3:08. We've got a lot of time for clarification. I'll be here all day. All right. Thanks, Terry. Those are my questions.
Okay, I think I'll just bring this to a close, but I just would like to say it was disappointing to find out 3 hours after our meeting that I should have had my attorney present. And to be clear, this is not a county policy, is it? This is good legal practice to let someone who's being sued know that they should have their attorney present.
It's the Florida
not?
bar rules.
I'm sorry?
It's the Florida bar rules.
The
that
Florida bar sets
If you're
this
in
rule.
litigation and you want to speak to the other person's client, you must get the attorney's permission.
So, and it is important for us to know because I can't speak for all of my commissioners, but I'm pretty sure because there's a lot of activity on the 12th floor, we book meetings almost every 30 minutes. And we can't be responsible for having to ask every person that comes in, are you suing us and should I have my attorney present? I don't want to make that a part of my scheduling in the future. So I think that knowing that's part of the bar, we should still be able to do our jobs and take as many meetings as possible without fear of something like this. So that's all I have to say. Commissioner Sykes?
The Vice Mayor, and I think that I saw the lawsuit, and so when I was called, I said, I'm not going to meet with you. But that's because I saw the lawsuit, and you can't meet with her. But the bottom line is that this is what I was talking about, Mr. Adi. I didn't mean to get heavy on you, but maybe I will. We need to have processes here. So this is
We
not
do
the
have processes,
this is not
do
the
we not?
we need to know these things.
He didn't
on the
even
12th.
know.
Well,
We had
did
not been
you
served
did
yet.
not know that there was a
No.
lawsuit?
No, we only know if we're served. She sent a letter to me asking to meet with commissioners on Tuesday.
How did I know there
So-
was,
so-
I saw it
so-
online, there was a lawsuit. And so maybe we need to get our actions together here so that the process, so we're protected because, you know, Mr. Adi, you can't know everything. But
No.
they've got to be able to notify you as county attorney when there's a lawsuit against us.
Well, the media, news media combs the court's docket. That's not something we do on a daily basis.
Well,
We
but don't
get-
they serve us?
We weren't served until Monday afternoon at 4 o'clock. So it was only through the media that we learned that a lawsuit had been filed on Friday afternoon. And at that time, we did the necessary things to protect our clients.
So on Monday morning, you found out that we were served?
No, at Monday might have been sometime after 1 p.m., and we acted immediately.
I called him as soon as I found out, but that was 3 hours after my meeting.
Okay, so you were visited before we got notice,
Before
or
we were served, after it was
All right,
filed.
we need to, yeah.
The moment we found out, and it was
And you
before we were
notified.
served, yes.
Okay.
Because that's our process.
Okay, no, that's good. And we need to, heck, if the media's finding out before us, maybe we better get.
They always do.
Always. So, okay, like I said, this is a good beginning of a review of our processes. So, okay, very good.
Commissioner
Thank you,
Marino?
Thank you, everybody.
Just to be clear, it was a news article at 11:09 that I read with the attachments of the complaint that I then called Darren and said, have we been served? And we had not. And my appointment was for, I don't even know what time. And I specifically walked down to your office and asked if you had met yet. I didn't talk to you, but you had. So again, consent and notification and representation were not what happened. So I just want to, and I think we can close this and move on. Thank you.
Do we have the PowerPoint presentation ready?
Thank you.
Thank you, Attorney Gotti.
All right, we're going to have people introduce themselves as they come up, and we'll try to do this all within the 30 minutes.
And just so you know, it's 15 minutes at a time, but I will reset it at the 15-minute mark.
Oh, okay, not a problem. All right, thank you.
Reset, okay. Good afternoon, Commissioners. My name is Janice Ridenauer, and I am the president of the Western Palm Beach Community Alliance. The Alliance was formed for one purpose: to ensure Project Tango receives the public scrutiny it deserves, and that decisions of this magnitude are made with transparency and sound planning. Today, our team will present information for your consideration regarding the proper classification of Project Tango and why we believe it should not be considered a light industrial use. We respectfully ask that you consider the project's scale, infrastructure, demands, operational impacts, and effects beyond its property lines. It's important to note that we are not opposed to technology or economic growth. We support responsible development, and responsible development requires projects to be classified based on what they are, not simply what they are called. Our presentation today, in the spirit of processes, we do have 3 experts that are included in our presentation. So we have an order that's to our PowerPoint. So we can address ourselves when we come up, so you can remove our cards instead of calling us out of order, if you don't mind. Thank you. And with that, it's my privilege to introduce Attorney Christina Reichart with Earth Justice, who will begin our presentation. Thank you.
Thank you, Janice. And good afternoon, Commissioners. Thank you so much for giving us time to speak today. I want to start off just by saying clearly that this board has never considered and decided what use category should be attributed to an AI data center. Back in 2016, the board heard in the staff report that they would be reviewing an economic development center that included a data center or computer server farm and warehouses. In January, they added to the overall square footage, and now in this new application, what we're seeing is an attempt to conflate a traditional server farm data center with the new technology in AI data center facilities. I also want to flag that there is an ocean between what we are hearing today in terms of the makeup of this site and what can happen with this board's approval, considering the conditions that are in place. based on the conditions, there's not a clear restriction to the square footage of the data center. There's not a restriction to the amount of electricity that the data center could use. There is no restriction that says that the cooling facility needs to be a closed-loop liquid system with air cooling, and there is no requirement or condition that restricts them to battery backup either. And I think the board should really sit carefully with this question, because there is a significant difference between a traditional data center or server farm and an AI data center. So AI data centers are very new. They've only really started coming online in the 2020s. They conduct completely different services using different technology. A traditional server farm will store data on external servers that can then be accessed externally and turned on and off. They do not operate all the time. They do require power up to less than 50 megawatts. I think actually 50 megawatts is about the largest we have in Florida existing. And they also use completely different computer chips. Now, because of these different services, an AI data center, by contrast, is operating 24 hours a day, 7 days a week, 365 days a year. They are using a very high-powered computer chip, and they are manufacturing images, text, videos using AI technology. And so because of that processing power, they require about 17 to 35 times the amount of power that a traditional server farm would require. They require an advanced cooling system. What we see here is that the applicant is proposing to use a closed loop, which we've heard a lot about. But what we haven't talked a lot about is the cooling system that removes the heat from that closed loop, right? So that loop could just go on and continue to circulate heat. The problem and the impacts come from how you remove the heat from the closed loop system. And so all of that leads to impacts beyond the property line, because when you remove the heat from that closed loop, it has to go somewhere. It doesn't just disappear. And so if they use a water cooling system, which they currently are not saying they will do, then it is released into the atmosphere through evaporation and discharges of wastewater. If they use an air-cooled system, that heat is released into the atmosphere through the fans in the ceilings of the buildings. The other thing that comes with hyperscale AI data centers, as we've heard, is that there is very limited economic opportunity. There's very few jobs on site, and most of the construction jobs are specialized and provided by people who come in from out of state. So when the board is deciding on this application, it is also deciding whether an AI data center qualifies as data and information processing, and this is the definition from the ULDC. An establishment for business offices of an industrial nature, corporate centers, a light industrial use. So, when you're assessing the information that you're hearing from the applicant, from our experts, ask yourselves whether this is a business office with a light industrial use. Is it a corporate center? Or is this a heavy industrial facility that requires incredible amounts of power and incredibly advanced cooling technologies, unlike any other industry currently in existence? And then part two of this question is an AI data center a light industrial use? And this question really comes down to, are there impacts beyond the property line? If there are impacts beyond the property line, an AI data center cannot qualify as a light industrial use, and it cannot qualify as data and information processing. Importantly, this decision does set a precedent. And I know that this board has voted on starting the process for an AI moratorium, and that's wonderful. We agree with that approach because we agree that an AI data center is a unique use that requires special regulation. Now, under the ULDC, this is on page 91, the red highlighted portions here are permitted as of right, and the orange highlighted portions here are administrative approvals. So if you approve this application and the board decides that an AI data center is light industrial is data and information processing. You could be creating vested property interests for any property owner that owns any of those designated categories. And so I think there would be restrictions in what the board could do with that AI moratorium. And so I want to make sure the board is aware of that.
Hold on one moment. I'll pause your time. Commissioner Powell has a question.
Can you go back to that last slide? The one with the use chart, use matrix.
Hold on, it's going forward, okay.
It is going forward.
I think we're getting there.
Expediting the presentation, I like it.
I'm giving you sneak previews.
Can you, all right, the board's decision will set a precedent. Here, this is an industrial use matrix that's part of our ULDC right now. And you have data, information and processing, and you show the uses that require Class A or a different use. So what you're saying here is any of these particular zoning districts this would set a precedent where these zoning districts would potentially allow for a data center. Is that what you're indicating?
Yes.
Tell me why I disagree, because this is now in an EDC, in an economic development center, which is a little bit different from these traditional uses here. Why do you believe, and I'll let you finish your presentation, but why do you believe that will set a precedent which would just allow these to be approved without any additional scrutiny?
Right, so one of the parts of your approving this application in an EDC is that you would be assigning data and information processing as the use that is approved in the EDC. And so that is what this chart shows, is where data and information processing uses are permitted as right, are approved through DRO processes, and which have to come before the board. And so I think there would be a very strong argument for a landowner to say, if you've approved data and information processing as a use for an AI data center here, there is no reason that you could not do it in these other areas, because you've defined the use to include AI data center.
So, but again, it would be approved in an EDC, or MUP EDC, with conditions, right? And here, I don't know if I'm looking at anything by right. I see subject to BCC approval, DRO, maybe.
All of the red are permitted by right.
So they'd be permitted by right, without conditions.
Correct. I believe that's the definition of permitted by right.
Right.
And staff can correct that.
Wouldn't, if it's a data center permitted in an EDC, wouldn't that be different than just a data center permitted in industrial? Doesn't it still have to have additional conditions, maybe even setbacks, or am I wrong for thinking that?
So what you would be doing is deciding whether the category of data and information processing as defined in your ULDC, which is not specific to EDC or MUPD or any particular use, that's any data and information processing in any type of zoning, whether an AI data center comes in under that use category. And so I hear you that this application is for an EDC and an MUPD, and so maybe you could try to limit it to those areas, which is still a significant section of Palm Beach County. But the use category, the board would have decided, includes an AI data center, which we argue it does not, because it is a data center by definition or a data information and processing has to be a light industrial use. It's in the definition of data and information processing. So even though there's two slides and two questions here, they are interrelated.
Thank you. Even if something is permitted by right, and this is where I'm getting a little confused, doesn't it still have to have criteria? And the second question is, if we put a moratorium in place last week, then wouldn't that make this moot, even if we approved this today or didn't approve it? we would still now, this is under the process of being reviewed and will be revitalized under a different zoning in progress and probably come back with new regulations. So, and I know you probably put this presentation together prior to the moratorium, but wouldn't that kind of make this obsolete?
So I think that this brings a big question into what the board can do with the moratorium. My understanding is that what you have directed is for staff to create an ordinance to bring back in the August meeting, starting with zoning and then coming to the full board, to actually create a moratorium. Right now, what you have is a permitting in progress or zoning in progress designation. And so you don't actually have a moratorium in place. The board has not issued a moratorium for AI data center use. And so I think there is a big open question on what that means, but I think a landowner would have quite a lot of basis if you're saying here today, after issuing this moratorium, that you think an AI data center qualifies as data and information processing.
Our attorney wishes to weigh in.
Okay, because if we're under a ZIP,
Yeah, the ZIP, you're right. The ZIP prohibits anybody from filing the application right now.
so that means nobody can file a new application today.
That's
Okay,
right.
I just wanted to make sure. Thank you. You're good. I appreciate
Hold on, I
it.
have a couple more lights on. Commissioner Weiss, you were next. And then Commissioner Marino?
Yeah, thank you, Christine. So I just want to clarify, Project Tango, the whole project is not in front of us.
Well, so this is, I think, a very interesting point that I'd love to make.
Okay.
So
Then make it.
the 2016 approval and rights that were provided to the property owner were for data and information processing. The board has never actually decided what that means. Staff is saying that at the staff level, they have found that data center qualifies as data and information processing. I don't know that they have decided that AI data center use qualifies as data and information processing. And part of what is happening is because the applicant is conflating data centers generally as one category that fits under data and information processing, they are claiming that they have this entitlement to build a 1.2 million square foot AI data center, but we would say they do not, because that has not been decided by this board.
So just to understand, well, two questions. Where does cloud computing fit in?
Cloud computing comes in a traditional server farm.
But no, it isn't, because it runs 24/7. It's computers running, and actually, it's not a server farm. It's actually processing. That's where the processing takes place.
But people are not accessing their external servers
how
and
do you-
clouds
how-
constantly.
hey, Okay, so cloud computing today, and how are you going to, you want us to try and sort this out, but understand, most cloud computing products now have AI built into them.
Right, but we do not have those facilities as data centers in Palm Beach County.
But you made the point of what a data center is, but it's not true. It's not accurate. There's a lot of different things that can be a data center. And what you're describing versus what you're saying is a hyperscale data center, there is just a tremendous amount that goes in between that. And so I think it's important, we don't know what they're planning to do, what kind of computing they're planning to have in there.
Right.
So I think it's a little, it's a reach on that, but I wanted to see where you thought that, where cloud computing came in. I mean, I see everybody here with their phones all going, sending videos and doing all that. That's all being handled in the cloud. That's all cloud computing that's happening.
Right,
It's
and what
not-
Palm Beach
and
County
all of it
has two data centers.
And all of it has AI in it.
So there's a difference between the program that you're using on your phone and the facility of the AI data, of the data center
No, this is
that.
going to a facility somewhere.
Right.
That is managing this, that's running these programs are not running on my phone. They're not running locally. They're running up in the cloud, and that information's going back and forth. That's how it happens.
Okay.
So you can't, we don't know. And for you to speculate onto what it is.
Well,
is
the
not-
applicant said that they were building a hyperscale AI data center in their initial application. That's
We
in
don't
their
know what that
application.
is. So the last thing I'll ask you about is,
I'm also just on
Hang on.
the distinction, I
This
want to
is-
flag that we have an engineer who's happy to answer questions about the
well,
distinction.
okay, I would be happy to talk to your engineer, but you presented yourself as an expert on this.
Well, I'm presenting this information, and you're welcome to also talk with him about this, yes.
And so the last thing I would say is in a closed loop system, are you aware there's something called a geothermal loop?
Can you explain what a geothermal loop is?
So you're not aware. So that's where they take the loop, and instead of cooling it either in HVAC or they cool it up on air, they run it underground, and they cool it in the ground, and the ground absorbs the heat.
Okay, so that's a third option, I guess, for removing heat from the cycle. It's not what the applicant is proposing here, though.
I don't know.
The applicant is currently proposing a chiller, an air-cooled system that would remove the heat and put it into the atmosphere.
Sir, in the back of the room, please. Commissioner Marino?
Christina, your presentation right now is putting you in the position of being an expert, which you are obviously not. So I think we should move on from this and get the expert, because you're not doing a really good job. So I'm sorry, she's not the expert, and that's where I'm not arguing with anybody in the audience. And you have laid out your case, but questions need to be answered by an expert, of which you are not.
Yes, and if it's possible for me to finish the legal presentation aspect of my presentation.
But
I
again,
also-
the legal presentation is different than the expert presentation, and I want the board to understand that. That's just my takeaway from this.
Correct.
Thank you.
So the other thing I would want to flag is that this would not be the only jurisdiction in Florida, or more broadly, who has distinguished AI data center uses from other types of uses. There's multiple different jurisdictions across Florida that have issued moratorium because they believe they need to create specific categories for AI data centers. There's also support from the South Florida Regional Planning Council, who sent a letter to Miami-Dade in their comprehensive plan amendment to also create a special category for AI data center use. There's also a great deal of opposition that is provided specific to this application from a broad coalition that would support this denial, and then we will present substantial and adequate evidence, as we have already in the record, and today we'll have our experts presenting to show that this application is due to be denied because it is not a light industrial use and has impacts beyond the property line, and so it fails many of the factors in the ULDC. Thank you.
Oh, I'm sorry, Commissioner Flores?
What's your name?
Christina.
Okay, in the packet that I got from your group, I do not have a card for you, so I need you to fill one out, please.
Okay, I will. Thank you.
And then as we keep going, these are expert witnesses, right?
The rest are supposed to be experts, yes?
So whoever comes forward, can you please tell us your expertise?
Absolutely.
Thank you.
Good afternoon, Commissioners, Madam Vice Mayor. My name is Dr. Santiago Latancio. I'll be speaking on behalf of LM Engineering Inspections and Consulting. My expertise is in engineering. I've been an aerospace engineer for the last 15 years, specifically focused in gas turbine engines. My expertise related to this as well extend into the acoustics, and I will be providing a review of the information that was submitted by the developer related to their acoustics and noise conclusions. So just to give you a little bit more background about the company, I have a partner as part of my firm. We both hold advanced degrees in engineering as well as 2 master's degrees each. We have 8 patents, 23 published papers, 45 years of engineering combined. and my partner is certified by the Institute of Noise Control in the United States. So the reason I wanted to talk to you today, and I'll give you the conclusions first just because of the short time that we have, is that you are being here asked to make a decision about a project that does not have the complete evidence submitted for any kind of independent conclusions to be made. This is a project that is not of light industrial category, and the developer did not submit clear and sufficient evidence in order to prove that. Their reliance on DBA measurements is a great starting point, but other measurements such as DBC and DBZ need to be accounted for, especially because of the nature of this project, where most of the noise is coming from mechanical equipment which produces noise in the low frequency spectrum. Additionally, in the packet that was submitted to you, and I'll show you some samples of simulations, they did not include the full build out of the project. Your lawyer, or the lawyer for West Palm Beach Logistics came out, and the developer came out, and none of those additional build outs, phase 2 or any other transformations of the infrastructure within the development plan have been included as part of the result. So that does not allow me to make conclusive or to verify the conclusions that are presented by their experts. So you've all seen this picture in the past. This is what the developer has been presented as a graph or their noise bands around their property. And I don't know how I can point here, but if you look at the top right corner of that diagram or that picture, you do not see any of the West Palm Beach Logistics warehouses or the other 3 warehouses that were built next to it, nor do you see the potential sound implications that would cause if the transformation does get administratively approved. The developer has promised that there's no impact to the neighboring properties, and unfortunately I do not have the information to independently verify that, even though we have reached out to the developer on several occasions to get these questions answered. What do we know today? Today we know it's a 600 megawatt.
One moment, sorry, Commissioner Flores.
I'm sorry, I just want to compare apples to apples here, right?
Yes, sir.
Can we go back to that image? That is, the image that you're displaying here is based on your studies?
No, sir, this has been presented by the developer. This is from the developer.
Okay, but that's not what he presented here today.
I'm not sure if...
Okay, I'm telling you, the numbers and the image does not look like what he presented here today. And I believe we also said 850 feet from, and I don't think that's displayed here. So I'm just telling you that you're giving expert witnesses. You're an expert witness.
Yes, sir.
And you're giving a testimony on an image or a study that is not what they presented here today. And I would like to look at Brian and say, would you agree that that image is not the same thing that you presented here today?
It can't be. It doesn't go past. I mean, everything you see is on the PBA property. That 50 that's on the right is PBA's property. What we showed you, what went all the way to the Arden property line, so it can't be.
Okay, I just want to make a note for the record that that image, I don't know where it came from.
This is on the developer's website. I got it.
Please.
I got it.
One more, and you will have to leave the room.
So I understand and I accept your point, Commissioner Flores. I want to highlight that this image was not produced by me. It is available in the Park of Commerce website, as well as has been presented at the zoning hearings and previous Board of Commissioner hearings by the developer. That is the information that I have.
I just want to clarify the record.
Fair.
That at least this image is not the same that was presented to us today. So.
Understood.
And I don't know if that changes your your data and considering the 850, the condition of approval of 850 feet. So,
So this image does not impact the rest of the testimony I will be providing. The data that was used for the rest of the testimony that I will be providing came from the reports, both the preliminary Jacobs report as well as the report that was submitted to you that included the experts that presented their point of view here today.
If I could ask for clarification from legal, is he allowed to present evidence that was from a previous public hearing? And this, it can be submitted today, right?
Sure,
Okay.
absolutely. I mean, technically, that previous hearing is part of the record of this hearing anyway, so.
Yeah, just to clarify, even though it wasn't presented in this public hearing, it was presented in a previous public hearing.
I do recall seeing this image at the zoning commission.
Okay, I just want to make sure we're still all legal. Okay, go ahead.
Any other questions?
No lights,
Okay.
please continue.
Thank
Oh, wait,
you.
hold on. Commissioner Powell?
I do have a question. Thank you for that. Here, in the conditions, it says that processing shall, so the maximum noise levels using the A weighting at the receiving residential development to the east shall be a maximum of fixed mechanical equipment, anytime maximum is 60 dB. And the question I have, and that doesn't go on to the adjacent properties in Arden, but do you question or are you concerned with the noise level testing? Do you believe it won't be accurate, or do you dispute that?
So there's a couple of things that I'm here to bring to light for you to make an informed decision. My point here today is I reviewed the information that is made available to you and that has been made available to me, and I do not believe that you have been given the full picture, nor have we, in order to examine and independently verify that everything that was incorporated into their conclusions or into their predictions is accurate. So I'm just here to give you more information or things to ask out of the developer in order so you can make an informed decision rather than rely on conclusions prepared by a single party.
Absolutely. Thank you for that. But with the understanding that you don't believe the information that's presented today is completely accurate and that they're indicating that this is the noise level testing or the dBs, decibels that are shown there are prior to the full development, do you believe that in the event that the full development is completed, that the testing will be accurate? Or do you believe, are you indicating that you think, or you believe, that the sound will be louder? And what fact are you basing your opinion or your thought process off of?
Okay, so that's a lot of questions. I'll try to piece them out.
I'll be clear. Why do you think it'll be louder why do you think they haven't shown us the full development? And if the full development is there, what makes you think it will be louder than what they're showing?
Okay, so first point, and it actually, I have a slide on that particularly. So why do I think that this will be louder? So as part of the expert report that was submitted last, they indicate that they only need a single fan bay per data center as well as a single chiller as part of the equipment. However, that contradicts their original report where they show that each single bay includes 36 fans and also communication from the developer that they're going to need roughly 600 individual fans as part of their cooling operation to cool or to reject 600 megawatts of heat. So to put that in other words, the equipment that they've at least listed on, I believe it's page 14 or page 17 of the last report, the cooling equipment that they're listing there is not sufficient in order to fulfill a 600 megawatt data center operation. So that's one of the things why I think it's going to be louder. I don't think it's going to be 5 fans and 5 chillers. I believe it's going to be in the order of 180 modules at 3 fans each. So in layman's terms, for comparison, it's about 2.5 football fields filled with fans in order to cool the 5 different buildings that they're planning on developing.
If I need to ask you a question, because we've had a lot of conversation about water cooling. This is both. Are we doing air cooling and water cooling, and are they required to be separate? It's like you're talking about cooling 2 football fields worth of fans
Yes.
to cool the building?
To cool so they talk about, I am making the assumption that they are going with the closed loop cooling, right? That is built into my assumptions. With data centers, you have 2 ways of cooling, as the developer explained. You can either have water-based cooling or you can have air-based cooling. In engineering, something gives when you go from one to the other. So if you select water cooling, your noise signature goes down because you're using that water in order to remove as much heat as possible from your closed loop circuit. If you go to air, you reduce your water consumption, but you have to figure out a way in order to push the heat out of your closed loop system somewhere, and pushing that heat with you have to do it with fans. You have to similar to an air conditioner in your home. What's happening is you have a closed loop circuit with your air conditioner that's moving freon, and when it comes outside, if you put your hand far away from the blades above it, you'll feel that the air is much hotter than the surrounding air. So that's what the closed loop system is actually doing. That's why you need a substantial amount of fans, because the heat has to go somewhere. These computer chips, and I will paraphrase that, or I will clarify, thank you, that I am not an AI expert, but the evolution of chips or processors have gone from CPUs to GPUs, graphic processing units. When that happened, it opened the world of possibilities in parallel computing. You can now compute a significant amount of tasks simultaneously rather than a series of operations. So when
If I could, I'm sorry to interrupt, but just to clarify on this slide, so it's almost like an air conditioning for the closed loop system. Like it's where you're air cooling, using fans to air cool the water.
Yes.
Or the steam, or
Yeah.
what?
You're using liquid to cool your processors. That liquid comes out hot, and then you use a fan to push that heat into the air, and then the colder liquid comes back, goes through your processors, gets heat up again, and that's your closed loop.
And it becomes cooler because it goes through these fans.
Because the liquid that's in your system is much hotter than the environment that you have outside. So you are, since heat is transferred to everything in your surroundings, that's why if you get into a car or into under the covers, eventually it becomes hot. The heat is irradiated into your surroundings. That's what's happening with the fans. It's helping push the heat that's within that glycol water mixture that they stated, and it's returning a cooler liquid than what it was when it came out.
Okay, thank you. I'm sorry, Commissioner Sachs?
Thank you for your explanations, and thank you, Vice Mayor. So it does run like a air conditioner, sucks in the hot air, and the hot air goes out through fans. But about how much heat is going to be generated from what the applicant has requested? Do we know, or do we have an idea?
I don't have the calculation with me. I can certainly get you a number, and I do have an expert that follows me that'll speak about the heat island or the heat rejection into the environment. my presentation was purely focused on the acoustics.
On the sound?
Correct.
Okay.
Correct.
And did you, and I may want to wait to the end of your presentation, but I'd like for you to think about this question. We have heard from an expert, from the applicant. I would like for you, by the end of your presentation, to tell us if the applicant's expert's testimony was straightforward and correct for this particular application.
Understood.
Okay?
I
And then
hope that
would
by,
be-
I hope that by the end of the presentation, you'll be able to see just the doubts that I have with the information that was presented and whether that data should be validly interpreted by your commission.
And the one other question is, do you have a water expert there as well? Okay,
Yes,
I'll
we
wait.
do.
So that's what I would like for you to respond to with regard to sound.
Thank you.
I think you heard me. Thanks.
You're back on the clock.
Ah.
Go ahead.
Thank you. So I jumped through a lot of slides, but just to summarize the two that I skipped. So we do have some basic information as to what the plan is related to the data center developer, which is they do have some cooling equipment. Again, page 17 is where they list 1 dry cooler and 1 chiller per building, the magnitude of the building, and the fact that they are assuming that their points will make no noise because they're inside buildings. Everything that we need, you can't read that page. I mean, it's part of the report that was submitted, but there is a significant amount of information that you need in order to independently verify a study of this magnitude and to quantify the impacts to the neighboring communities. Things like calibration records. We saw the effort that was made when we took the sound measurements here in these chambers, but we received no calibration records related to the baseline measurements that Jacobs conducted. We did not receive any of the equipment type, the quantities, or the specifications for that equipment. And more importantly, we did not receive any of the assumptions, because in engineering, your results from a model are 100% reliant on your assumptions. If you have good assumptions, you get a good model. If you have bad assumptions, you get a bad model. And we can't verify what it is, whether it was a good or a bad model based on the information we have. So again, I mentioned this is not little equipment. This is 14-foot fans. Your house ceiling is usually about 10 to 11 feet tall. So you can see how big these fans are, and there's going to be 180 modules of 3 fans each. Unfortunately, the developer was not able to further substantiate the quiet equipment that they were going to use, or these fans. They only listed a brand, and they did not explain. They kept talking about how the ambient sound it's already loud because there's traffic and there's the wind's blowing, and that's going to mask the data center noise. Well, it doesn't quite work that way. If someone is playing a really high-pitched noise in here, and you have someone talking as loud as that high-pitched noise, they're different frequencies, and unless they are relatively close within the same frequency range, they don't mask each other. So just that by saying that there's cars coming around, which is cyclic also, it's not a car driving every single minute or every second of the day in front of the community. It happens in periods, especially at night. It's much less than during the day. Data centers are 24 hours a day, 7 days a week of noise. So a little bit of images. So just to show you as far as where I'm basing the fact that there's not enough evidence to make conclusions. So we took some measurements, my firm took some measurements to replicate the same data that was gathered by Jacobs, and that's on the left, and then we have the Jacobs data on the right. And first thing we notice is there's a 10 decibel or dBA difference. Well, that's normal, right? You get results, you try to verify them. Unfortunately, I don't have the data to verify why it is that my results are different than theirs. I don't know their calibration data. I don't know what type of equipment they use. I don't have their basic assumptions when they went and measured those locations. So I can't verify my data. Additionally, we talk about low frequency and dBA. As you can see from the map, if you take into account dBA instead of dBZ, you're leaving out the major component, which is the low frequency noise, which is what these mechanical equipments produce. It's great to understand what dBA is because we perceive it as loudness, but dBz is important because it presents itself to our body in vibrations. Talking about build-out. So their study does not have any of the warehouse build-out that is currently in the plan or in the latest plan submitted. Okay. Okay. What we showed is that with their warehouses, the sound is funneled in a different way because now you have buildings that are obscuring a direct movement of those sound waves into the community. So now you have an additional or you have additional sound being funneled or honed into the school area. Something else that we were able to demonstrate is that even with the warehouse built, the developer has claimed multiple times that warehouses will shield the noise from the community. We demonstrated that from a low frequency perspective, there's no impact in putting buildings between data centers as much as they want to make.
We need to wrap up. We're on 10 minutes for 3 people.
All right. Sorry, I ran out of time, but if you have any questions, I'll be more than happy to answer.
Thank you. So my name is Ronaldo Diaz. You all know me as former Lake Worth Beach Commissioner, but before then, well over a decade ago, I've been involved in nonprofit advocacy, especially for the Lake Worth Lagoon and for the Greater Everglades ecosystem. Started Lake Worth Waterkeeper, a member of Waterkeeper Alliance, where I built the first and very unique water quality monitoring laboratory that looked at different bacterias throughout the watershed, basically Palm Beach County. I also sat on the board of Everglades Coalition, also sat on the board of directors for Florida Wildlife Federation, and currently the nonprofit work, shocker, doesn't pay all the bills, so I also work at South Florida Engineering and Consulting, which is a environmental engineering and sciences service firm that specializes in water resource engineering and water quality, biological services, that sort of thing. One of the main things that we do is basically Everglades restoration. And so I'm here to talk about the potential impacts to environment that this project can be. And there's certain things that have been mentioned, but certain things have really been glossed over. And those things that have been glossed over are the things that I, as a watershed expert, am most concerned about. So we've irrevocably altered the Greater Everglades ecosystem and how water moves. Specifically to our watershed, that's really important because our watershed is very complex. It's not like the Caloosahatchee River where it's going from one spillway to the next. It's really easy to follow, right? Our water has multiple pathways of where it can go. This is determined by humans, right? The South Florida Water Management District, the Corps of Engineers. We decide how to move this water throughout our watershed. And that's an important distinction to understand because where Project Tango is being proposed is right there where it's labeled 20-mile bend from on the map, right to the left of that number 4, that white spot there. And that's important to understand because so much is connected to this that's really important, right? So starting with Lake Okeechobee, that water can go down to LA L10 predominantly. What we want it to do is we want to be able to send that south to the rest of the Everglades. Those 2 triangles, those are stormwater treatment areas. Basically, those are man-made wetlands. They clean the water to get it to a point where we can send it south to the Everglades. I'm getting it. Yeah. Right, and then the other connections is due east to C51 to the Lake Worth Lagoon and also up the M Canal to Grassy Waters to Clear Lake, which is the surface water source for West Palm Beach's drinking water. Similar to the M Canal and the L8 Basin, those are the headwaters of the Loxahatchee, the northwest fork of the Loxahatchee River, the protected part, right? And so keep that in mind as this water can go in any of those directions. The heat island effect, the thing that we're concerned about is heat. So this talk of a closed loop system, it's a really good term of art because it's a bit of a distractor. Of course, the water that is in the system is not going to be discharged into the environment, right? It's like, as using the applicant's own example of a car, we're not driving around and the coolant is not being sprayed on a road, right? Unless you have a really bad car. You want to keep that self-contained in the system. Why? Because that coolant needs to be clean. You're not using river water to cool down computers that's filled with plants and fish. It needs to be absolutely clean. It's probably not even going to be distilled water. I'm sure it'll be some other chemical that needs water that's going to make it a lot more effective at cooling these computers. What that does is that closed loop water needs to then be sent somewhere. This isn't. Let me rephrase that. So the main purpose of these cooling systems is not to move water. We're not talking about the water use. We're talking about moving heat. And that's the concern. So you're going to cool off these computers with the closed circuit water. Well, that heat needs to go somewhere. And there's several avenues. And I think Commissioner Weiss correctly pointed out that we just don't know because depending on the technology. If financially, it would make more sense for them to discharge it directly into the water because water is a lot more effective at cooling. That is obviously a bad idea for the environment. Geothermal is a possibility, but we need that soil health because that's how we clean our water to get to our aquifer. And the most obvious in what they're proposing is releasing this heat into the atmosphere. There's data centers of this scale haven't existed for that long. But they're a very novel thing. We've never had, up until recently, facilities where we have 600 megawatts of water being pumped, of electricity being pumped into a single building. That heat needs to go somewhere. And if it goes into the atmosphere, that warmth is going to affect the surrounding waters, which can drive things like cyanobacteria blooms, the other bacteria blooms, all the other water quality concerns that we are worried about. And because of the system moving it elsewhere, that's how the far-reaching effects are going to impact beyond the boundaries of this project. Yeah.
Oh, she moved. I was going to ask for a quick question if we could get a couple more minutes, considering how long the applicant took this morning. So, yeah, you had questions too. But I'll trade you. I won't speak. She will. So we were just asking if we could get a couple more minutes on the clock to like get to 5 for our.
Is it the pleasure of the board to give a little extra time?
Yeah.
Okay, sure.
And then I'll skip. So she gets to go.
Oh, boy. Thank you, John. Okay, can I push this down? Cecilia Ward, president of JC Consulting, an urban planning firm located in Hobe Sound, Florida. I have 45 years of planning experience. I've been certified as a professional planner, American Institute of Certified Planners, for 30 years. I've worked with both the private and public industry. I was the planning, zoning, building director for the city of Fort Lauderdale, at which time I was required to lead the update of the city's entire comprehensive plan and all of its Unified Land Development Code regulations. I was also responsible to ensure that any application that came before that city was both in compliance with its comprehensive plan and its land development code. I've represented numerous private and public agencies from Nova Scotia all the way down to Key West as a private consultant and have been retained as an expert witness in both litigation as well as before boards such as yourselves on such matters. So what I'd like to do is first give you my professional planning opinion regarding this application, which is that based on my review of the public record, based on my review of the county's comprehensive plan and the review of the land development regulations and the application submitted by the applicant, it is my professional planning opinion that this application is not in compliance with the county's land development code regulations for how you review development order amendments, and also that it is not in compliance with the county's comprehensive plan. And I'm going to give you specifics, but I want to generalize some of the things that we've heard this afternoon because I think it's important and it'll form a basis for my opinion as well. First of all, you don't go outside. It's not typical planning industry tactics to go outside and use other people's definition of what defines a use, such as light industrial or heavy industrial. when you have a local government provide you that information. So I'm going to point to Future Land Use Policy 2.2.4D of the Comprehensive Plan, which does provide definitions for how the county is to determine what's a light industrial use and what's a heavy industrial use. And there are two key significant components. Light industrial does not cause, and typically does not cause, adverse impacts on adjoining properties and adjacent uses, whereas heavy industrial does. The word typical is very important here. Also, even though a use may be within a confined building, as long as it causes those impacts on adjoining properties or adjacent properties, it is not a light industrial use. That's what the county wrote in its comprehensive plan. Which makes this so critical is that Future Land Use Policy 2.2.4C is what states that you can only have a light industrial use in an EDC future land use. So if you cause impacts on adjoining properties, you're heavy industrial, you're not light industrial, that's for sure, and that you're not permitted in the EDC land use. The next point I'd just like to make is that as a professional, I am required to take into account the technical information that's provided by the industry on both sides, and also then look at what the industry is and talks about in the planning profession. There's numerous studies going on right now because of this issue. I can point to Urban Land Institute studies, I can point to zoning practice studies with the American Planning Association, all of which state that a hyperscale AI data center use is very distinct from what a traditional data center use is, and it's because of this impact issue. It's not size. You can have a really large data center that's traditional. It's how they function differently. Traditional, it's sequential. We do processing of information sequential. That only requires a certain level of electricity and power, so forth. Whereas hyperscale AI is simultaneous. So you have a lot of machines working all the time, producing all this information simultaneous, which generates the heat that you heard about, which generates the noise that you heard about, and that which generates the impacts potentially off-site, which you've heard about. So the industry in planning does recognize this very different, and in fact, the recommendation is what's happening across the country, not just here in South Florida, is you're getting warehouse uses that are coming in piecemeal for amendments, and that what's happening, it's like death by 1,000 cuts. You're getting, okay, a little bit more data center, a little bit more data center, a little bit more data center. And when you combine it all into this hyperscale AI use, it is now something that is such a different, significant magnitude on the community and the adjoining properties, and the impacts and the issues have not properly been addressed by the codes. So what the industry is recommending, the planning industry, is you need to come up with distinct regulations for these uses, because otherwise what's going to happen is you're just going to have this incremental change in character and not really know the ultimate ramifications. They know some of what's going to happen, but as you heard today, there's conflicting in professional technical industry, but they do know that there's definitely a difference between the two.
Okay, hold on one moment. I have a number of lights on. Commissioner Sachs?
Thank you. I know you're going pretty fast, so I wanted to catch it right there.
I have to.
No, it's okay. It's an important point what you said, and I want to make sure that I heard it correctly. Light industrial for data processing or data servers would be identified as a process that does not affect neighborhoods or a neighbor or contiguous community. But heavy industrial is defined as a process that does affect other communities.
It does affect adjoining properties or nearby
Adjoining
properties.
properties, that's
Yes,
even better.
absolutely.
Okay. Okay, thank you. I wanted to make sure. Thank you.
Thank you.
Commissioner Flores?
I want to talk to our attorney real quick regarding definitions that have been thrown around, whether how is information processing or data processing defined. This was originally approved back in 2016. Was that the definition of that ever challenged?
The definition, data and information processing?
Correct.
So that has been in the code for a long time. So I'm not aware of any challenge to that term.
So I understand that the administration determined that this is the proper use, I guess, data processing. Could you go over that again? Because I keep hearing that our definition is improper or whatever.
When this application was before the board back in 2016, data information and processing was the use that the zoning director at that time determined data center would fall under.
And is the definition up here what our ULDC defines it as?
I believe it does. Says an establishment for business offices of an industrial nature, including corporate centers associated with uses such as manufacturing and processing plants or similar industrial complexes, mass bulk mailing processing, and telemarketing centers. The use is often integrated into a campus-style development and not frequented by the general public. This term does not include such uses as business or professional offices, computer-related retail establishments, and personal services and medical dental offices.
And
So
at
it's
that
not
time,
complete on the screen.
okay. So at that time, the administration determined that the proper use for that application would be this.
Yes.
Okay. And that is my question. To you, are you challenging
No.
that decision in 2016?
No, absolutely not. In fact, I'm in 100% agreement with that decision in 2016 because that is what a traditional data center was. What it-
Okay, hold on. That is currently what they are approved for,
Correct.
and that's currently what they can build. So you're not
Correct.
challenging that.
No, correct. They can build a traditional data center. What happens is,
Hold on, how you define
Okay.
traditional
I
and how data centers have transformed over time are two different things.
yes, I can distinguish between the two based on planning literature. Okay?
Okay, but you're not challenging that the decision in 2016
No.
based on this definition?
No, absolutely
Okay.
not. Absolutely not.
And could they have challenged that definition, attorney?
Yeah, there is, if
What's the
the-
statute of limitation on that challenge?
Probably 4 or 5 years.
4 to 5 years. So that time has passed to challenge that definition?
Yes.
Okay, thank you. I think the definition point is mute.
Okay, so can I just continue on that point? So on that point, when you have a definition in your comprehensive plan, everything else that you have in your land development code, however, must be consistent. So in 2016, yes, the data center that existed at the time, which was not hyperscale AI because it did not exist, you can look in the industry, it didn't exist till the 2020s, would have fit that definition. What happens is that your comprehensive plan still says you cannot define a data center that causes environmental impacts, typically on adjoining properties or adjacent properties. So you can't just transform that action and that definition from your ULDR, from your ULDCs into saying, well, just because we call it a data center, it's still a data center. It's the impacts that are associated with it that make it different. So I just want to be clear on that.
Okay, hold on, we have Commissioner Weiss.
Thank you. So, in following up on Commissioner Flores's comment, what I want to get into, we've already granted that use. It's already been granted.
Yes.
They've got 2 million square feet
Yes.
that they can build whatever data center they want to build.
They can build a data center that comports with the definition of light industrial.
That means, so in my understanding is staff has put conditions on there that eliminate their ability to impact any off-site, or what do they call it?
adverse impacts?
Adverse impacts, that was the word I was thinking of.
Well, in reading the staff's conditions, I did not see where it says it eliminates it. I believe what they're attempting to do is minimize, which the comprehensive plan does not say that's sufficient. It says you cannot cause these impacts on adjoining properties.
Okay, so, but then would you say that there is a way to condition it so that it doesn't impact, I mean, just by writing such language?
I would not be able to say that, and I don't believe the experts have said that.
I think you're misunderstanding what I'm saying.
Okay, sorry.
That you actually just condition it to say that you cannot do that, right? There's such a condition.
You would have to base that on technical evidence to say that. You can't just say you cannot cause an environmental impact when it's known already and admitted by the applicant that you are going to cause noise that goes beyond your property line.
So, I guess I'm getting confused. So if I have a facility that makes noise, and one of the ways I can say then that you cannot impact your neighbors with that noise, right? So you can either figure out how to do it, or you can't build it, correct?
I can only answer it this way, if I
Okay.
can.
Go ahead.
That you can condition it, but if the industry shows that this is what this typically does, this use, it typically creates these environment, and it's not just noise, it's heat, it's water
I'm
supply,
just
et cetera.
using noise as an
Yeah,
example.
but let's use noise as an example. The applicant would have to prove that a hyperscale AI data center
We're not talking, I'm just talking about generalities.
could not. And you could put a condition on it, but there would have to be evidence to show that that condition could be withstood.
Okay.
Okay.
Commissioner Sachs?
Oh, wait.
Oh, I'm sorry, Commissioner
And
Weiss was
and
not
the other
finished.
thing is, and I think that the proper term that we want to be using for what these are, they are large load customers. It's a function of the amount of electricity that they're using. Because the chips don't make noise. Chips are, electrons, last I checked, were 100% quiet. But, so the chips don't make noise. It's the ancillary things to cool them down that make the noise. It's the, potentially if you're using water, it's the water. It is not a function of what they're doing, what they're processing. It's the amount of electricity that they're consuming and how fast they're consuming it that's creating the various impacts. So the proper term really should be large load customers, is what the state of Florida has put in their legislation, which I have also asked that we put in our ordinance that we're moving forward on, because I think it's going to we don't know what the changes are going to be with how technology and what it does. So to try and define this with the type of computer, the type of chip, the type of anything, it's a large load user, period.
May I respond to that, just based on my industry research? There is a difference between what type of processing units they each use. Traditional uses CPUs. AI databases uses graphic processing units and tensor processing units. Those things...
They don't make noise.
Okay, those things, because they're operating 24/7 simultaneously, is what makes it different. It's,
No,
I'll
it's the
say it
amount of
this way.
electricity that they utilize, ma'am.
Well, it does. It puts up a significant amount, it demand of a significant amount of
It's
more
not,
electricity.
trust me, it is not the chip.
Well, and size, I'll say it this way, size doesn't matter because I'm tiny, so I could say that. Size...
Closer to the microphone.
So Commissioner, you're correct. The chips do not generate, or they do not generate sound, but you're also correct about the large consumption of electricity. However, everything is connected. If you have these graphic processing units, you consume more electricity and you need to
That's
cool
not
it.
what I'm saying, sir. You're missing my point. Because people want to talk about AI this or, hyperscale that. It's missing the point. These are large load users. It's the fact that they're using a lot of electricity that creates these other impacts. If they didn't, it would be like running, an 8088.
We agree.
Right.
We agree.
Thank you.
Commissioner Sacks?
This is a very important point, and I just want to follow through what I had asked you before. A data center under light industrial does not have impact on adjoining property. A data center that is heavy industrial does have impact on adjoining property. Why did not, and I'm asking Ms. Hernandez, why did not this applicant come in under heavy industrial? I mean, you know what, Ms. Hernandez, you don't know, because that's up to them to respond to. But let me just ask you this. The applicant came in today, in their application, under light industrial. Could they not have come in under the classification of heavy industrial because the way that the definition differs between light and heavy?
They could have.
Okay, but they did not.
They did not.
Thank you.
Commissioner Powell?
EDC and MUPD and that.
Thank you, Madam Mayor. Earlier, you indicated that in order for a development, let me put these on, a development cannot have an impact on an adjacent property, and you indicated that the noise impacts the adjacent property, and you indicated that was from the comp plan, and they show 50 dBs, but that's what, am I wrong? Am I saying something?
No, what I was saying is the definition is contained within the comprehensive plan, and no matter how you frame the zoning regulations, they must first comport with the definition contained with the comprehensive plan, which says you cannot create negative impacts on adjoining properties and still be considered a light industrial use.
A light industrial.
One moment, our attorney wanted to also respond.
Yeah, so Commissioner Powell, I just wanted to read this light industrial definition from the comprehensive plan. So, light industrial development's typical operation is not likely to cause undesirable effects, danger or disturbance upon nearby areas, and typically does not create negative impacts on immediately adjoining uses. And then it goes on, these uses typically do not cause or result in the dissemination of dust, smoke, fumes, odor, noise, vibration, light, or other potentially objectionable effects beyond the boundaries of the lot on which the use is conducted. Examples of light industrial uses include storage, warehouse, research labs, dispatch, landscaping, flex space, media production, and light manufacture and processing. So it's not necessarily a total prohibition. It says light industrial development's typical operation is not likely to cause undesirable effects. And it's not just effects, it's undesirable effects.
Thank you for that, Darren. So, and at the same token, in full disclosure, of course, we all went out there, well, some of us went to look at this site, and currently it's active as rock mining. They're in a concrete batch mixing. They're doing concrete out there. Is that, and of course, again, it's a 400-foot wildlife corridor and a 500-foot canal and a 250-foot additional buffer and berms. Would you agree, or rock mining is heavy industrial, right? So would you agree that if there's any impact, that currently has an impact on and this is, and it said, Darren, our attorney said adjacent properties. This is not even directly adjacent, but would you agree that that would have more of an impact or less of an impact?
Well, if I could answer it this way, I believe that the concrete plant that's there is heavy industrial, but I also know from the county's definition that And from the code, you can't replace a use that is not permitted, which if it is heavy industrial, what's being proposed, with a use that's not permitted. So you can't have a heavy industrial use replaced by another heavy industrial use. The operation may be different, totally different impacts, but in my professional planning opinion, they would both be heavy industrial. And just to go back to that point, the reason why I believe the applicant did not come in and this be couched as a heavy industrial use on the definition is because it would not be permitted. Policy 2.2.4C of the future land use element says you cannot have anything other than a light industrial use if it's going to be an industrial use in the EDC. And so it would not be permitted. That's why they couldn't ask for that.
Understood. And in this opinion, I think staff has reviewed it in detail. And, you know, in your professional planning opinion, you would believe that the use would be heavy industrial. Staff's professional opinion has come up with it's light industrial. So it's just a matter of two different professional opinions. The weight of staff's professional opinion is applied through the ULDC. And as I indicated earlier, we talked about the SIC or the NAICS code, the North American Industrial Classification System, and I'm falling back on that as opposed to looking at the APA, the American Planning Association, and I understand where you're coming from, and even as planners, there's always, it's subjective. Attorneys can be subjective in terms of thoughts and opinions. I think in this particular situation, it's my professional opinion that based on the backup that's provided here and what I've read, I think staff is well within its right to believe that the definition that it has classified this particular use under is accurate. Not to knock your skills as a planner or your practice or your opinion. It's just a difference of opinion and subjective based on this particular subject site and subject application in front of us today.
And if I may just add to that, I give staff a lot of credit. I've been in that situation, so I know how difficult it is to do their job. What I was saying is that they defined it as a light industrial use because they called it a data and processing center. What I'm saying is that the function, we could talk about whether it's large or whatever, but the function is definitely different from that, based on industry standards, based on planning journals, based on studies. And that's why the planning industry is saying you need to take a look at these as a very distinct, different use. And because of I don't believe they're arguing against the fact that there are impacts that are going beyond the property line. I think that's why they're dealing with the pages and pages of conditions, but that's not what the comp plan says. The comp plan says, once you do that, you're not a light industrial use. I didn't write that language, the county wrote that language, that's all I was saying. And just to...
hold on.
Oh, sorry.
Did you have any more questions?
Madam Mayor, I think I'm good. It's just a difference of opinion in terms of light industrial, heavy industrial. And even when I think of heavy industrial, y'all, I do think of rock mining as heavy industrial, car crushing, contractor storage yard, junkyards, some of those uses that are, and it's a difference of opinion, and that doesn't make anybody a bad person. It's just what I'm looking at is a little bit different. Thanks.
And I think the concrete plan is non-conforming.
We've already given you a significant amount of extra time, so I think at that
Do you want me
point,
to just-
thank you, and you will still be here if you were to come back up.
Would you
But
want me
I
to
did
just-
have some questions for staff, because Commissioner Powell brought up the existing use right now that is very much heavy industrial. And then she had mentioned the EDC, that it's not allowed. So is the current use sort of grandfathered into this current property?
Yes.
You're
Okay,
good, thank you.
Yes. So when the 64 acres was added, We had presented with the land use amendment and the zoning application that that use was existing and that it could remain there until they redevelop it.
So does any redevelopment then has to be a lower category of industrial or a?
If that use goes away and the site is redeveloped, it would be redeveloping with the uses that are allowed in the EDC flow.
Okay, that provides a little clarity because it is very much a heavy industrial site now, but the opportunity for redevelopment means it has to
Conform
downgrade. Okay, and I think with that, I heard someone mention having FPL come up to speak, and we do have Amy.
Can I beg 2 minutes from you on
You can
something
put in,
that?
you can put in a comment card and get it 90 seconds. Like, did you put in a comment card?
Yes, and all I was gonna tell you is that I was gonna talk about the EDC is,
Are you an expert? And please identify yourself.
Okay. John Eubanks, 605 North Olive Avenue, here on the Arden Association. So one of the things, okay, well,
Okay. If it is not the will of the board, I'm sorry. No.
okay, otherwise, just a couple.
Okay, it is the will of the board. Please, if you could just identify yourself and you have
Sure.
2 minutes.
Okay, I'll do this quickly, and I'll try to stay out of things you've already talked about, and that's part of it. John Eubanks, 605 North Olive Avenue. I'm here on behalf of the Arden Homeowners Association. One of the things that we haven't talked about today is that it's really almost impossible for an AI center to actually be in an economic development center. The problem you have is an economic development center is just that. It's supposed to be for economic development. That's the opposite of what happens with AI, right? When this was first approved in 2016, the pitch wasn't about computers, the pitch was about jobs. We've got Arden coming, we're gonna get all these people coming in here, we're gonna get employment. We're gonna do, this is a quote, development that would allow for job opportunities to service not only forthcoming 2,000 homes with the PUD, but also with opportunities in the Tri-Cities of Belglade, Pahokee, and South Bay to obtain access to jobs. AI doesn't do that. AI is the other way around. When you actually look at it, AI comes out, and other than the people who build AI buildings, which they're specialists and they go from place to place to place, what they do is they take away jobs. So, and how do we know? Because what have we had? We have AIs now that are being run hundreds of thousands of square feet, right, by 1 or 2 people at home on their laptop. They're not out there. We don't have employment. We don't get employment from the AI stuff. So, and that's part and parcel of it. Now, to be in the EDC, you're supposed to be part of an employment center, right? And that's defined, of course, like everything else, which basically is an employment center is a center of economic activity consisting of commerce, industry, or offices, which are intended to generate significant employment opportunities. Well, that's the opposite of what we're doing, significant employment opportunities. Now, how do we know we're losing people? Well, we just did not 1, but 2 type 2 variances, right? And what were they? To get rid of hundreds and hundreds of parking spaces because we don't have people out there. So we have a lot of empty parking spaces. So from that stand, I don't think that an AI center helps you, and it really doesn't match what you have for the EDC. So you shouldn't be approving this. Thank you.
Thank you. I'm sorry, Commissioner Weiss? Mr. Eubanks? Commissioner Weiss had a question for you.
I just want to be clear. So you're saying, so you oppose because they're asking, I think, for 100,000 some odd square feet or 200,000 square feet of data center. So you're opposing that because it doesn't create jobs. But what about the 1 million square feet of warehouses?
Right. Have you looked at the type 2 variances? They're coming out of the warehouses as well.
But I'm just
in
saying.
bigger amounts, in fact.
But I'm asking you.
That's an incorrect statement. There's no variance on warehouses.
Okay, so now that we heard from staff that there is no variance on warehouses. So my question to you, sir, is do you oppose the approval of the warehouses?
I don't think, underneath this argument, I don't think you can, but the EDC and an MUPD and the GAPO all have to be back to light industrial, obviously, when we say they're not. But if the EDC, if it's not an EDC, I don't think that you can do it for any of them unless you can show, again, that you're actually going out and getting jobs. So who's, I mean,
But
this
you
was,
don't think warehouses will create jobs?
well, that's what they were supposed to do in 2016. You approved it underneath
Well,
the
but that's a
theory that
different,
that's
but that's not what's in front of us today.
understood. What happened is times changed, and then
I understand that, but what's in front of us today is this additional, 1.5 million square feet.
right,
Part of it is for a data center use, and part of it is for the warehouse use. And I'm just trying to see if your client that you represent opposes the warehouses. I would assume, we've heard, the types of uses that people might use them for. I think it's a relatively easy question to answer.
well, I don't know if it's relatively easy, because I think it's part and parcel of the EDC is more than just the computer, data, information people. It's also the warehouses as well.
All right.
So if you're in an EDC, you're supposed to be employing and
It
adding
isn't-
jobs.
Okay, but
I don't think they are.
Sir, if I
All right,
could,
fair enough.
that was a pretty straightforward question.
I'm sorry?
Would they, that was a pretty straightforward question he asked. I would like the answer too.
Okay.
Do they oppose the warehouses as well?
In all honesty, I've never talked to them on that issue, because that hasn't been the issue that we're talking about. So that's the straightforward answer then.
Okay,
I'll
Commissioner
let one of
Flores?
them talk about it later.
Hold on, wait, you're not done. Commissioner Flores?
Darren. Is this a quasi judicial hearing?
Yes, it is.
And in order for us to reject, what do we need?
Competent, substantial evidence.
Which means,
Evidence that is likely to prove a fact and issue. It's got to be factual testimony, expert testimony relevant to the issue before the board.
thank you. I think Commissioner Weiss just mentioned that that's not before us. You guys are sticking to definition that was defined already in 2016. Economic development, whatever, was decided in 2016. That's not what's before us today.
Okay?
That's not what's before us today.
Right.
It got pigeonholed into that. It got put in there back in, and that decision was
Well, it
made
was
in
asked for.
in
It was asked for.
2016, sir.
It's correct. In
Right?
2016,
You don't disagree with that?
yeah, in 2016, it was asked for. It wasn't pigeonholed in there. The applicant you have
It
today.
doesn't matter.
went
The
back
decision has already been made. It is 10 years later. My point is, you guys are better off sticking to environmental, water, sound, noise issues than
Okay.
something that's already been determined in 2016. If you guys had an argument against that definition,
Right.
you should have gone to court
But, okay,
to
I agree in
defend that.
2016.
So my point
but
is.
what about today?
I'm trying to help.
Okay.
I'm trying to help you. I don't know how much clearer you want me to say it. You stick to what we can do. That is not before us. It has been defined. It has been put into that category.
But it would be something that you would have to look at.
We
when
are
you
looking at that. We
when
put a
you do that.
moratorium
So you're
already.
looking at whether or not there's an EDC portion of this, that it's not an EDC right now. In 2016, you're right, when you did it in 2016, I can't do anything about that. Today, you're still doing this again under the EDC. Now, the other thing is, I did get a note that the warehouses, we're not opposing the warehouses, right? But here's the part that we're always working about, and this is something we talked about before, right? What happens if warehouses can get,
I didn't ask that.
turn into
so
data centers?
If another commissioner wants to ask about that, let them. Thank you so much.
All right, thank you.
Commissioner Marino?
Not for you.
Hold on, Commissioner Sachs, your light was on. Was your question for Mr. Eubanks?
No.
Okay, then you're done, sir. Commissioner Marino?
Thank you. Yes, earlier I referenced FP&L, and I believe there's someone. Come on up and identify yourselves, please. I have a couple of electric questions, or I should say power questions.
Good afternoon. Amy Kemp, External Affairs with Florida Power and Light Company. Thank you for having me.
Thank you. I know a big question is, what kind of impact to the neighbors will there be? Will there be a rate increase to any of the neighbors? Can you answer that question?
Absolutely. Thank you for the question. So last year, FPL put in place a large load rate structure, a tariff, that would essentially require any commercial user of this large scale size, meaning 50 megawatts or larger, to actually bear the entire cost of the infrastructure that would be required to support that specific facility. So we do have a process in place so that we can understand the specific power needs that would be required to support that type of facility and require that data center, as we're talking about it today, to actually bear the cost.
So I'm glad you said it the way you said it. They're regulating the utility. You have to be able to meet the existing customer needs before it occurs. Is that correct?
Yes, as a regulated utility, we have the responsibility and duty to serve all of the customers within our service territory. That is why this large load rate tariff is a very, it's one of the strongest customer protection approaches that I can say, to be able to expect the demand that's going to come and protect residential customers, to make sure that the large load users essentially are bearing the cost.
Can you tell us a little bit about the facility right next to where this is scheduled to be?
The West County Energy Center?
Yes.
So the West County Energy Center is one of our natural gas facilities, one of many within Palm Beach County and within our service territory. I believe there was a reference of about 38,000 megawatts, which is accurate. It is one of our larger facilities and supports the electrical needs for many customers within Palm Beach County, but within our service territory as well.
And the Riviera Beach had a facility that you tore down and built a new facility. The reason I'm asking this question is, what is the useful life of that facility? And as we go forward with new regulations and new modifications, you obviously put out some sound with the facility that's there. Does that change in the future as you improve?
I'm not too comfortable answering that. I can certainly get back to you on that.
But I mean, that's basically what happened in Riviera Beach. You tore the old system down, put a brand new system in with a lot more efficiencies. Is that correct?
That's correct. Yeah, we have some of the cleanest and most reliable facilities within the state.
And those facilities, are they similar to the ones next to this property?
West County Energy Center?
Yeah.
Each facility is slightly different in their structure, generation, setup, but Riviera Beach and West County Energy Center do have similar structure in terms of being natural gas facilities, yes.
And what are the requirements from the Public Services Commission?
In terms of what?
Having a data center and the customers and I guess the utility that they're going to use. What other requirements are there that you haven't listed?
Sure. So I think there was a comment earlier about, just proximity and the power plant and all that. So as a regulated utility, all of our structures and how we serve our customers are overseen by the Florida Public Service Commission. And so the large load rate tariff actually requires for there to be multiple steps from the initial tariff being signed to a system study that would essentially try to understand what interconnection requirements, what generation requirements would essentially be needed, right, for these types of facilities, and then be able to provide that time and cost to that developer. So that is the process that stands in place. I will say that we have so many different generation facilities within Palm Beach County and within the entire service territory. Our facilities are not committed to a specific customer or a specific area. They serve our entire customer base.
So basically, what you're saying is that the user, in this case, the large load user, has to be able to, they will pay a tariff, they will pay for all of it, and at the same time, there will be no additional burden put on any other user in the area.
That's correct. The large load user would have to sign on to our tariff, would have to undergo a study on what incremental power needs and infrastructure would be required, and they will be required to pay for those costs. So in essence, it protects the residential customers to make sure that it's not an impact to the residents.
But again, you have to know the needs of the customer, the large load customer, before they even start to make sure you can meet those needs. Is that correct?
So maybe if I can put it in this perspective, our entire generation facility, as FPL as a whole, our entire portfolio is about 36 gigawatts. A gigawatt is about 1,000 megawatts. A large load user is about 50 megawatts. So our entire generation capability as a utility is significantly larger, right, than the large load user. However, even though we do have the capacity, right, to be able to support that, out of a protection, right, to our residents, that large load rate tariff was established last year as a forward-looking protection for our residents to be able to ensure that any large load user would be responsible for the cost for their incremental power needs. And I will say that that is also consistent with the latest legislation, SB 484.
Thank you, I appreciate that.
I had some questions for you, but Commissioner Sachs, your light was on. Was it for Mrs. Kemp?
Yeah, thank you so much. Hi. Always a pleasure to see you.
You as well, Commissioner.
The West County Energy Center is what this FP&L plant is at the Palm Beach Aggregates. Is that what it's called? It's huge.
West County Energy Center
Yeah,
is
the
out west.
Right. And that's the one that we're dealing with today. Are there others like this or similar to this in the county?
We've got Riviera Beach Energy Center in Riviera Beach.
Okay. So there is another one in Vero Beach.
In Riviera Beach.
Oh, Riviera Beach.
Yes,
Oh, okay.
Yeah.
Okay. Are there others like this particular center in other places in the state of Florida?
We do have multiple generation facilities. So you've got Riviera Beach, you've got West County Energy Center, we've got the Martin plant around Indiantown. We've got 2 different nuclear facilities. I don't want to say that they're all the same, right? But they are generation facilities that service our entire service territory.
Large energy centers
Generation
from
facilities.
FP&L. Okay. It's not the only one.
That's correct.
Okay. Good to see you. Thank you for
You
being
as well,
here.
Commissioner. Thank you.
Thank you. Okay, I had a couple of questions on the large load user. So how does that work? Is there a cap that's put on like a certain facility where you're generating power? Do you have like a certain amount where you can say, we can afford to give this much to a large load user, and then we keep the rest for consumers?
So like I said, the way the large load rate tariff works is that a large load user would essentially sign that tariff. We would undergo a study to understand what their needs and what their essentially usage would be, and they would actually be responsible for paying for that infrastructure and that usage. So we essentially separate, right, the current generation and the use of our residents and make sure that the large load users are responsible for their incremental power needs.
Well, I understand that they would be responsible. I'm just wanting to make sure that there is, how do we balance? I mean, and this isn't something that we can even regulate. This is outside of our
Public
purview.
Service Commission, right.
However, to make sure and to reassure people that there is someone making sure that there's a limited amount that's going to be going to whatever large load user there will be. And, these 100 of these pop up, and we get a lot of questions. How are you going to make sure that our residents and our businesses that are here now have electricity well into the future?
Yeah. By really relying on the large load rate tariff. So we define a large load user as 50 megawatts and above. So any large load user that would potentially come into our service territory would have to abide by that. And that would be our protection to residents. We have, I believe, a 20-year minimum term for the large load rate tariff to make sure that that's also an additional protection. And that way customers are not essentially having the burden of that cost.
You said 50 megawatts. Is that what is expected to be for this property?
I can't speak to the property. I'm only here to speak about the large load tariff on behalf of FPL.
So do we know what the... Hi.
Good afternoon, Ernie Cox again. Yes, we do know this is projected to be a 600 megawatt facility at build out, and we've worked very closely with FPL, particularly the engineering department, to make sure that they have plenty of power that's available to us after they serve not only the existing customers, but the projected customers.
Okay, so as far as that is, that, he mentioned 600 megawatts for that property, so then is there, I'm just trying to figure out if there is a cap. Is there going to be a rush to the finish line that there's only this many megawatts that can go to a large load user? And who's the first one that gets it?
So if I'm understanding your question, you want to make sure that there is enough generation capacity
Yes.
in our system to be able to support that. So as of right now, like I mentioned, our entire generation as a utility is 36 gigawatts, which is equivalent to around 36,000 megawatts, which is still significantly larger, right, than the average size of a potential data center. But still, to be able to make sure that we can service our residential customers and any commercial customers that come, that is why the large load rate structure was established, to make sure that if there is any incremental power needs that are needed, that they are essentially built, right, and enacted, but that commercial customer essentially bears the cost.
So is this
in
something
essence,
that is
yes,
being
we
done
will-
state, or not state, because I know you're not the whole state, but your entire coverage area, you would have to abide by that, so, because I know that there's a number of these lined up in other parts of the state, so, and they're also FPL customers.
Yes, because we are a regulated utility here in the state of Florida, if there is a commercial customer of that 50 megawatt size or larger, if it were to come into our service territory, they would have to abide by that tariff.
And you said you are 36 gigawatts.
That's correct.
And a gigawatt is 1,000 megawatts,
Megawatts,
right?
that's
Okay,
correct.
thank you. Commissioner Powell, you're in.
Thank you, Madam Vice Mayor. Amy, thank you for coming. Quick question, and it's in line with what Vice Mayor Woodward was asking. Just the capacity question, that people have been concerned that, you know, these large load users come online. It was this question about, will their electric rates go up? Will this draw so much electricity? Because there's a real concern that these will draw so much electricity that other people, traditional customers, may not, electricity may not be there for them. What's the potential for, I've heard people ask questions about blackouts and power delays. Is that a real possibility, or does this Western facility have the capacity to take a 50,000 megawatt?
600 megawatts.
Thank you for the question. So just to make sure I also re-clarify again, we have not committed and do not commit any specific power plants to any customer or any specific area. Now, when it comes to the generation of our entire fleet, for perspective, we have been thinking that battery storage would actually be a potential first use for these types of customers. Battery storage, just to explain it, essentially allows us to capture and have that additional electricity for when there is peak demand and be able to release it at use. So we have significant generation capacity. We have one of the world's largest battery storage systems, so we are prepared to be able to meet those demands with our current system and also be able to ensure that we use that large load tariff so that when there is that interconnection into our greater electrical grid, our current structure and any incremental one is there to support the peak demand.
Thank you.
Thank you.
Okay, I don't see any other questions. Fine, so we're good? No more questions for FPL? Thank you. Oh, yes, could you please just fill out a card so that we can have you for the record? Thank you. All right, so we have people at Vista Center. I think that number's gone way down. How many are there?
It's actually gone up.
Oh, it's, Vista Center's gone up. Okay.
No, but it's because two individuals from downstairs went over there. We still have 3 organizations. I have Debbie Murphy from Cobra. I got Adina Kerr
It's okay with him.
from the Teachers Association and Kathleen Williams from Fox Trail HOA. I also know, Madam Mayor, that we have a few parents with little ones. I was hoping to see if you would be okay
I would be
with
happy for them to
asking
come
them
up and
to.
speak. Yes.
Yeah, so if you have a little one and you want to get them home, please come see me over here and I will advance your card. So I know I see a couple little ones over here, some outside.
Actually,
I think we have a
do
baby.
we have a staff member that can maybe do that for you, or?
Yeah, babies
Got
are
it?
good.
Okay,
Yeah,
yeah,
otherwise.
come see,
Gonna go home with
over here.
fluorescence.
Ms. Murphy?
Yeah, he's going to take him home.
Good afternoon, Vice Mayor, Commissioners. Debbie Murphy, 10262 St. Andrews Road. First, I'd like to thank you for your in-depth questions. I know that you've been having a number of marathon meetings these days, and so I really appreciate the questions that you've been asking all day today. So I am also First Vice President of COBRA, and as part of the Coalition of Boynton West Residential Associations, I want to share that we oppose the Project Tango Data Center as proposed at the current site. Ordinarily, COBRA does not take a position on issues outside of our 55 square mile area, but Project Tango introduces a data center larger than those already in Palm Beach County and on a site in proximity of a school. COBRA shares the concerns of the Palm Beach County School District that this location and hyperscale of the proposed Project Tango facility pose health and environmental risks to the students and area residents. In addition, allowing Project Tango to go forward would set a dangerous precedent for a potential future hyperscale project in other parts of Palm Beach County. We respectfully ask that you deny the application, Project Tango. Thank you.
Thank you. Is there anyone at the microphone?
Any moms, little ones, parents? No? And
You
then
can make your way up to the microphone. We'll help find.
we also have Adina Kerr and Kathleen Williams. I have not heard from them. I'm only going to call you twice. If you don't come up, I'm going to move on. We have way too many cards.
You want to go ahead and call about 5 or 6 cards? You can go ahead and call another 5 or 6 so we can line them up.
So if we can, Nicole? Yeah, come on down. And then if we can get patched through to Vista Center so that we can get those individuals, get them lined up and ready to go at Vista Center, please.
Okay.
Please state your name.
Okay, yeah, my name is Nicole Kazmierski. Good afternoon. I'm a homeschool mom of 3, former teacher in Broward County, and a resident of West Palm Beach. So there are many health concerns related to the modern hyperscale data centers. There's one particular study, nationwide study, 5.1 million adults found that for every 10 decibel increase in average road traffic noise outside the home, suicide risk rose by 4%. Data centers have been reported to generate community noise levels over 60 decibels, 60 to 80. Just today in the room, it was like 43. So from 40 to 60, that's a 20 decibel increase. That actually, it represents like a 100-fold increase, 4 times as loud to the human ear. So it's actually, it's not linear the way that you would expect. And also research links chronic environmental noise to sleep disturbances, anxiety, depression, high blood pressure, cardiovascular disease, and many other things. Clayton Tucker is the Texas candidate for Agriculture Commissioner, and he was mentioning that there was one farmer particularly that they built a data center next to his farm, and all of the cows were having stillborn calves, all of them. So if that's what's happening with animals, there's no telling really what would be happening with humans as well. So yeah.
Thank you, ma'am. And thank you for bringing your beautiful children.
Thank you.
Are we
All
going to
right,
load
I'm
up
gonna
Vista
call
Center?
up.
Are we doing Vista?
We're going to go to Vista, but I'm going to call up a few people from the first floor so that they can start making their way up. We have Kayla Connolly, Anthony Reyes, Maria Crivanos, Nicole Tollison, Diane Rice, and Hillary Rizzi. And then are we patched into the Vista Center? Ma'am, if you're ready, come on.
Sure. My name is John Dilbert. I am an Arden resident. I'm at 19243 Woodstorth Way. And I'm here representing myself in Arden. I know that it was mentioned multiple times before about the closed loop system. I just wanted to mention, based on my research from Yale University, talking about the Arizona closed-loop system, there's 3 different data centers over there. They talk about the heat that comes off of that data center, that it could increase the temperature up to 4% while increasing the ground temperature up to 16 degrees. And, Florida is hot as is, just like Arizona is a desert. Imagine having 108-degree weather, having that increase by 16 degrees, and being a child right next to it. I mean, just imagine that for a second. It's detrimental. And talking about having outside impact, there's nothing more. Additionally, we're talking about our children here. The choice today will support our future children, encourage them to develop and allow them to grow, maybe into a county commissioner, who knows? Or you could trap them into a relentless bombardment of data center problems. Think about this, all the children in Southview live in Arden, so they're constantly gonna be exposed to all the negative aspects Tango has to offer. Noise, sleep deprivation, especially with those that are neurodivergent. They already have a problem learning. Imagine being completely bombarded by sounds constantly. You not be able to sleep, not be able to focus. I mean, there's nothing worse. And if whatever Ernie Cox has to say as far as having merit as any sort of potential positivity to this project, it's the worst possible occasion. It's like he threw a dart at the board and...
Sir, your time's up.
I understand, but it's in a horrible location. It has to be somewhere else.
Thank you.
My name is Patricia Curry. I live at 12390 59th Street North in the acreage. I am opposed to this project. I keep trying to understand how a project such as this can proceed without even knowing who the developer is. One thing I know for certain is that a hyperscale AI data facility isn't light industrial. I actually believe it's beyond heavy industrial. How the county could ever consider a project as simply a modification of a prior light industrial zoning approval is beyond me. This project is a major land use change of a scale beyond the original approvals and something our ULDC never contemplated for consideration under code. In fact, it should be considered under state and federal requirements for projects that may cause huge harm to the public and to the environment. Your process for administrative changes actually scares me because I know that other property owner is going to be coming in looking for a modification for them too. And the staff will just be able to approve it without it ever coming before the board. That's wrong. I hope that you honor your responsibilities to the public and say no. Thank you.
Ma'am, could you repeat your name again? I missed it.
It's Patricia Curry.
Thank you. Go ahead.
Hello, my name is Carolyn Davey. I live in Deer Run. I don't have anybody that has said anything about the Eagle's Nest that's up on the L8 Canal. I've ridden my horses up there. There's a 400-foot wildlife easement that is supposed to be protected. And it's a federal law. I will read. The term disturb explicitly prohibits actions that agitate an eagle to a degree that causes injury, decreases productivity by substantially interfering with normal breeding, feeding, or sheltering, or nest abandonment. It is less than a half a mile away, and there's another one in White Fences. So that is something that should be at least looked at. As far as the person talking about the noise, animals can sense the vibration of the electricity. So that is another huge thing that needs to be looked at. Property values, my father has tried to sell his house in Arden. He's taken a $250,000 loss and he still can't sell it. If this passes, he's out. And as far as, again, what she said, once this one passes, is the next door neighbor going to add another AI system? And we were talking about the warehouses. I just Googled it. There's 100 empty warehouses in Palm Beach County right now. Do we really need another one? What's going to be put into it? I mean, everybody's making all these general assumptions, but
Ma'am,
nobody's...
that's your time. Could you please repeat your name? We missed it.
Carolyn Davey.
Thank you.
Hi, my name is Christine DeSutter. I'm a resident of Fox Trail in Loxahatchee. A simple Google search says that a hyperscale AI data center is classified as heavy industrial. Large load users are classified by definition as heavy industrial. I have a question about our FPL rates because we all know that this heat from these fans they're using has to go somewhere. It's not always going to blow to the west. So wherever it blows, we have to turn up our air conditioners. So how is our electric bill not going to go up? Maybe we're not paying their cost, but they're still affecting our costs. A lot of us in my neighborhood have livestock. And like she said earlier, they're very sensitive to vibrations and noises and heat and everything. So, you're not really keeping our best interests in mind by allowing data centers in our neighborhoods. Property values, excuse me, we have a lot of houses for sale in our neighborhood and they can't sell. Can't say for sure it's because of the data center, but they were selling like hotcakes before this became a hot subject. Also, I'd like for you to remind you that the zoning and planning, they voted 6-0 to deny this or not recommend it. So I hope that you'll take that into consideration. And, I don't know what I can say that everybody else hasn't said already. Thank you.
Thank you. Marjorie Perry, 5351 St. Armand's Way. I appreciate all of you with all of your questions. It just seems like it's a little too late. Where were these questions a year ago? Why did the residents have to beg you and go out and resource their own data? You should have asked these things a long time ago, 2025, when you tried to pass it through on a consent agenda. What is in the warehouses? And they can be turned into data centers at will. So it's all going to be a data center, and it's just not appropriate for the site. Thank you.
Hello, my name is Diane Rice. I live at 14909 Horseshoe Trace, Wellington, Florida. A1 is coming, and it's only going to get more requests for A1. They're thinking about bringing robots to school, and that's an A1 issue. And the issue of heat and vibration, whether it's in the ground, whether it's in the air, is an issue in its own right. It will not be good. The noise will be high. Unfortunately, Palm Beach County didn't have another person for an expert, and you rely on the only source who's given it. I am so thankful for you people on the board to be asking the questions. I'm thankful for you give us the time to talk, and I'm thankful for Arden and other people coming in with their experts. Thank you very much.
Hi, my name is Jamie Ball, and I'm a resident of Arden. I stand before you today with the same reason so many of us are here, because we love our community and because we want our voices to matter. This is a historical vote, and it's going to affect generations to come. There's a reason that states are banning AI centers. There's a reason you put forth a moratorium. You were elected by us, by the people who live here, by the families who raise children here, by the people who trusted you to represent our best interests when difficult decisions come before you. Today, I ask you to remember who you represent. We are the people of Arden. We are your neighbors. We are constitutes. We are the families who invested our savings in our homes because we believed in this community would remain a safe, healthy place to raise our children. This project's not just another development on the map. It's a decision that will affect real families, neighborhoods, and innocent children for years to come. Our children did not choose this fight. They have no voice in this room today. As parents, we are here to be that voice. For our children, school should be a place of learning, growth, and security. Every child deserves that sense of security. Today, you have the opportunity to do the right thing. Listen to the surrounding communities, to our residents. There's no coming back from this vote, from the health impacts that this can cause on innocent children. Please stand with the families who call this community home. Stand with the parents who want to protect the place where they raise their children. Stand with the children who cannot stand here and speak for themselves. I respectfully ask you to vote no on Project Tango. Thank you for your time.
Hi, my name's Keith Albertson. I'm a resident of Lake Worth, Florida. I've been a resident of Palm Beach County for 21 years. And this is one of the most egregious things I think I've ever seen in this county right now. We had people testify earlier about the noise level and everything else, and he says he's never actually been, this is for the builder, never actually been to one of the AI data center sites in order to measure the actual output of these things. So somebody else testified that the number of fans that are going to be running and all the noise generated is going to be just way higher than what they're actually saying. Also, we had the testimony from one of the zoning board, I guess our planning board. She actually read the code, and the city attorney read the code also, and it said if it impacts other neighboring neighborhoods or properties, then it can't be considered light industrial. So this seems to be a misapplication of the law, and it should be overturned. The board should vote against it, and I'm hoping that you actually do the right thing. Vote against it. Let them reapply as heavy industrial, because it's not going to be on this site. If they want to build it, they need to do it right and not try and cheat the codes that we have going on right now.
Yes, my name is Jane Justice. This has been a real brutal experience, listening to definitions over and over and over. The fact is that the experts that spoke in the afternoon that were not representing the company were really giving great testimony, and they were kind of picked apart. You heard this testimony at the last meeting, the big meeting, and we went over this, and why drag the people through this? The purpose of the government is to protect the people. That's what it's for. And it seems to be like it's a weapon against the people now. This is all about Agenda 2030. We're fighting big money. That's what we're fighting. And the bottom line is all the water will come from the aquifer, and it is pretty hot here as it is. So really, we don't need it. We don't need this kind of thing here. The zoning board ruled correctly, and we expect that the commissioners would do the same. You've asked the same questions over and over. You've heard great testimony from great people. As far as FP&L is concerned, recently in Santa Rosa, Florida, they were spraying chemicals on wires, and big birds and chickens died and everything else. So, do I trust FP&L? No, I don't. I could give you more information. But also, I would like to say about experts, you know what? I'm an expert of we the people. This really has to stop. We have to do the right thing.
No.
Say, what about the bees? What about the bees? There's not going to be any food for people. The bees have a right to live, and we don't want to live without the birds, okay? So the government is supposed to be for the people. Let's get it right this time, okay?
Thank you, ma'am. Your time is up. Thank you. That's the last warning I'm going to give. Please, it's been a long day. We really want to hear the testimony of everybody. Thank you. Go ahead, sir.
Good afternoon.
Please state your name.
Hours. That's we the people testimony.
Good afternoon. My name is Braden Joyce. I am a Jupiter and Loxahatchee, Florida local. I have lived here my entire life. I have seen the development of my home. My elementary school used to be on the road. I also understand the struggle of proposing development and property changes through the county commissioning process. Development is going to happen whether our county wants it or not. We, the people, and the representatives of the people need to make a decision on whether or not this is the development we want in our community. We aren't talking about a commerce park that would at least promote business. We're talking about a data processing facility, if not more than that. A facility that's being built less than 900 feet from a school, from people's homes. These are permanent effects on the community, permanent noise, permanent vibration, permanent risk to the local community, and that's after the facility is built. Who knows the effects on the community during construction, including noise pollution, construction debris, dust and runoff into the canal that runs through Corbett and Dupuis wildlife management areas. When is enough enough? These lawyers and experts don't have to live here with the effects of this project. The locals do not want the risk. The locals do not want the annoyance. The locals do not want the data center and what it brings. Consider the public outraged. If they want a data center, they can build it next to their homes and their children's schools. Thank you.
That's all we have here at Vista.
Okay, thank you.
All right, if I can get Kayla Valiquette, and ma'am, you can go ahead.
Hi, I'm going to speak about a different industry that is...
Please state your name.
Oh, I'm sorry. Hillary Rizzi, and I'm a Loxahatchee resident. The industry I'm going to talk about is the equestrian industry. I have 51 years experience with horses. So first, the concern obviously is the sound and the low frequency. Horses are already fight or flight animals. When they see or hear something that disturbs them, they don't have a rational part in their brain. It goes straight into the motor cortex of their brain, and they buck, they rear, they run, and then they rationalize. If we have low frequencies, these animals have sensors in their jaws, in their teeth, in their hooves, and that's part of their prey makeup. So a low frequency, they're already kind of hearing, but they're probably not hearing what we may have in this situation. So we then are going to be putting riders, child riders, we're going to be putting farriers at risk. Farriers don't like to work with jumpy horses because it puts them at injury risk. Vets have the sedation tools, but they still have to get the sedation into the horse. This is a huge concern with the industry that comes in every season. Polo ponies, dressage horses, jumpers. I mean, anyway, we don't want it. Please deny it.
And thank you for your patience in waiting here. Thank you. Yes, ma'am.
Good afternoon. I don't
Can you get closer to the, thank you.
I don't have comments. I have questions. Is that still only 90 seconds, or?
You can ask your questions, and we can determine to do cross-examine, so.
So, anecdotally in Arden.
Could you state your name too, please?
I am so sorry. Kayla Valiquette, an Arden resident. We have a lot of issues with our power. I can guarantee when it rains, we're gonna have a blackout. It might be momentary. My generator kicks on. Our routers have burnt out. My pool pump has burnt out because of the amount that we have had. Now, how can this facility withstand generating enough electricity for our neighbor and everybody else that's supposed to be getting it? That's the statement, one question. The other component is, sorry, he's very distracting. Post-hurricane, we go without electricity for days, sometimes. Who's going to be the priority? Is it going to be the computers or the people? And then, when we say this is built, and we start having the symptoms of thickening arteries that happens with the high decibels or even the low DBCs, we start having thickened arteries and cardiovascular disease, and stillborns and miscarriages. Who is the authority to stop them? Because it will be linked. Because I can tell you, several weeks ago, we had an issue where FPL, something broke, and it was so loud. So can I continue going, please? It was so loud, and many of us called and made noise complaints, and nobody could stop it. And yes, it was something that had to get repaired, and then it was rectified, but there's nothing we can do. So their noise will be allowed to be above the levels. Their water usage could be beyond.
Thank you, ma'am. I have taken note of your questions, and I will make sure to ask them at the end.
Okay, thank you.
Thank you.
Hi, my name is Nicole Tolleson. I grew up in the acreage. I currently live there now. I have a private water well, and I grow fruit trees. I'm disappointed that you would vote on this project without having an independent environmental impact study, and that you would just take the word of the developer and his expert witnesses. That is my opinion. I read that closed loop data centers use PFAS as their coolants. That's their cooling liquid, and we do not have a guarantee that this data center will not use PFAS as their coolant, as their cooling liquid. 3M stopped making the certain coolants that were PFAS because of all the lawsuits. Different states sued them. So in January 31st of 2027, all data centers have to admit in public if they do use PFAS as their coolant. That's going to be a requirement come January 31st, 2027. I'm also concerned about the heat. I'm concerned about the vibrations. When we get to have certain temperatures, certain plants don't bloom, their pollen becomes sterile. So there are a lot of farms also in the western communities. So if the heat continues to rise, we're gonna have a lot of crops that fail. I think it's very important that we preserve farmland in Florida. That's my statement, thanks.
Thank you. Do we? I think we need some more
I went
names.
to check to see if there were people in the atrium. The atrium is now empty. So we have last call for Kayla Connolly, Anthony Reyes, Maria Krinovos, and Diane Rice. Diane Rice? Oh, yeah, because she's one of the ones that went from here to there. Yep. Sean Strawbridge, Elizabeth Acamundo, Sal Faso. I have not seen Sal. Jamie Bracker? Bracky?
Can line up on both sides, please?
Deborah Anderson.
Madam Chair, Commissioners, my name is Sean Strawbridge. I'm a District 3 homeowner and I'm a business owner. Today, you're not simply deciding another development application. You're confronting a fiscal looming reality, and your vote today will determine if you are fulfilling your fiduciary duty to Palm Beach County. Your responsibility is to weigh the evidence, apply the comprehensive plan fairly, and protect the county's long-term fiscal stability, especially in the face of potential revenue loss from decisions made in Tallahassee. If the state legislature moves forward with the homestead property tax moratorium initiative, this county could face a significant and recurring budget shortfall. That means real consequences, pressures on school funding, strain on public safety services, and increased burden on residential taxpayers. Rarely does a local government have the opportunity to get ahead of a fiscal challenge of this magnitude, but today, you certainly do. I understand why nearby residents raise questions. When a project like Project Tango is proposed near homes and a school, those concerns deserve answers, and these fine people deserve to hear those answers. And those answers have been appropriately provided. The independent health and safety assessment found no adverse public health impacts. Sound levels remain below recognized classroom standards. Air emissions are effectively zero. Electromagnetic fields are within everyday household levels. And the closed-loop cooling system uses only an infinitesimal amount of water in comparison to the consumption by surrounding residential developments. In return,
Thank you, sir.
Palm
That's your
Beach
time.
County gains approximately $561 million
Sir,
annually in property
you.
tax.
Thank you. We have
Therefore, I
this,
respectfully
sir.
ask that you
Thank
seize the opportunity to vote yes on Project Tango.
One more and you can leave the room. Thank you.
Jamie Bracken, Arden resident, and thank you for everybody for being here for the discussion. And like so many stated, my primary concern is really the health and safety of our Arden community. Just to set a few points, right? We've talked about it a lot, but we've had, I think, 11,000 residents sign a petition voting no on Project Tango. That's a pretty good message to what your constituents thinks. Also, we had several other committees and local organizations not support this. We got the Everglades Commission concerned about the heat bubble and the effects that are going to roll over into the Everglades next door. The school board, of course, doesn't support it. Your zoning commission rejected the application. And now, more importantly, we're imposing a moratorium except for this project. We all know there's a problem. We have to do something about it. Lastly, on the zoning applications, and we're talking about variances, I've been in commercial real estate for 20 plus years. when there's a variance, there's usually a financial hardship. I don't know why we can't require the parking that's needed. We just reduced their square footage. I don't see a good reason why they should shrink their footprint. Last but not least, we're talking about a building that's 70 feet high. Where in the light industrial zone are 70-foot buildings allowed? And
Thank
what
you,
is
sir.
the study, the sound studies on a 70-foot building?
Sir,
Thank you so much.
Thank you.
Appreciate it.
Thank you. Good evening, Vice Mayor, Commissioners, staff. Elizabeth Accomando, I'm the Board President for Indian Trail Improvement District. As you know, I am running for County Commission, but I stand before you today as a resident, not as an elected official, and I'm standing with my neighbors. It's unfortunate that our own commissioner had to recuse and left us with no representation. You now are the representation for the people of District 6. And I understand that you all cannot prejudge a quasi-judicial hearing, and this is why this testimony was, brought to you today. And there was good information from both sides. But had this come to us a couple of years ago, I don't think we'd all be standing here right now. I think a lot of this could have been addressed and resolved in advance. So transparency is really important. All I'm going to say is that the residents here are highly concerned about the loss of their quality of life and the potential loss of property values. This is what we've heard today, and it's not why the people moved out here. So I implore you, hear all the testimony and judge as you must in a legal manner. So thank you very much for listening to everyone today. Thank you.
Good evening, Commissioners, and thank you for giving me the opportunity to speak today. My name is Deborah Anderson. I've been an Arden homeowner for the past 8 years and was one of the very first residents to move into this beautiful community. I'm also a realtor with over 30 years of experience, and I'm passionate about not only helping families find a home, but about protecting the community that so many of us proudly call home. Over the past 8 months, since we first learned about Project Tango, I have watched fear and uncertainty spread throughout Arden. As a real estate professional, I've also seen the negative impact this proposal has had on our housing market. Buyers are asking questions, homeowners are worried, and confidence in our community has been shaken. We chose Arden because of its quality of life, its open spaces, peaceful surroundings, family atmosphere, and our beautiful new Saddle View Elementary, which is now A-rated, by the way. These are the reasons families invested their savings here. Placing a massive data center in our backyard threatens everything that drew us here. We are deeply concerned about the potential impacts on our health, our children's well-being, our quality of life, and the value of our homes. Today, I'm asking you to please stand with the families who live here. Please protect our community. Thank you.
Kirsten Lee, Jim Riley, Mark Bondamonte, Gerald Roth, Bill Fogel. I apologize in advance if I mispronounce your name. Dave Zita, Addison Tyus, Joni Riley, and we have 2 podiums. Please line up one behind the other so that we can make this a little bit more expeditedly. I don't see anybody moving. John Williams and Natalie Frazier.
Good afternoon. My name is Bill Spilfogel, and I'm an Arden resident speaking today on behalf of the many Palm Beach County residents who share these concerns. Today's decision is no longer about disagreement between residents and the developer. It's about consistency. After hearing testimony from the county staff, the applicant, experts, and the public, your own zoning commission unanimously voted 6-0 to recommend denial of this application. The zoning commission repeatedly questioned whether a hyperscale AI data center of this size and intensity belongs in the light industrial designation at all. This is not the project your predecessors approved in 2016. What began as a light industrial economic development center has evolved in what could become a 3.6 million square foot hyperscaled AI data center campus at a location now surrounded by approximately 2,400 homes and Saddleview Elementary School. Just last week, this board voted to place a moratorium on future hyperscale AI data centers because new standards are needed. Yet today, you're being asked to approve Project Tango when the very standards this board has already recognized should be reconsidered. When the rules no longer fit the project, the answer is not to stretch the rules. The answer is to write the right rules first. I respectfully ask you to be consistent with your Zoning Commission's unanimous recommendation and vote no. Thank you.
Sir?
John Williams, 1482 Stockbridge in Arden. I've been a resident for 4 years. 45 years in the water spot, working 40 countries. I've seen these plants. I've worked at Microsoft. I know them intimately, we'll say. But one of our biggest problems, we talked about power, we haven't really talked about water. And Joe, you mentioned Jupiter earlier today. They lost their permits and they're deep well injecting the brine from their RO plant. Our location is off lime softening. That plant's got to be retrofitted. That's going membranes just like Wellington. Are we going to pay more for water? Are we going to have to pay for the plant expansions? And, you know, we're talking about 35 MGD annually for both phases. Phase 1 is 17 MGD annually. We got to look at the water situation. I don't want my water going up with power and everything else. Thank you very much.
Okay. Hello, my name is Natalie Frazier, and I'm a resident of the Arden community. Before my current career, I worked in the Florida homeowners insurance industry, and from the time of Hurricane Katrina and Wilma until my daughter was born in 2009. During those years, I witnessed firsthand how catastrophic events changed Florida's insurance market. I saw insurance companies tighten underwriting guidelines, homeowners struggle to obtain and keep coverage, premiums increase, and certain carriers become far more selective about the risks that they were willing to insure. That experience is exactly why I come here before you today. I didn't find any analysis addressing homeowners insurance or whether this project could affect the availability, the affordability of coverage for the surrounding residential communities, or if the county sought input from homeowners insurance industry, insurance actuaries, or professionals who evaluate price and risk, or the Florida Office of Insurance Regulation regarding whether this project could have insurance implications for nearby homeowners. So I respectfully ask, has Palm Beach County consulted with homeowners insurance industries, insurance actuaries, or the Florida Office of Insurance Regulation? If that analysis has not been completed, where can the public review it? And if not, why not? Why wasn't this considered before, this recommendation for approval of this magnitude? So if this project were proposed next to your home, next to your children, school, would you feel comfortable approving it today without knowing the answers to these questions? I just have one more thing. I'm not asking you to have all the answers today. I'm just simply asking you to make sure that these questions are answered before making a decision that will affect this community for generations. Thank you for your time and your consideration.
All right, calling Kirsten Lee, Jim Riley, Mark Bondamonte, Gerald Roth, Dave Zeta, Addison Tice, Joni Riley for the last time. Calling Layla Frazier, David Jamison, Scott Moss, Gail Ladd, Larry Frazier, Maria Blake, and Shalon Bull.
You can come forward in the order. So,
Once again, we got 2 podiums. Please line up.
go ahead.
Hello, my name is Layla Frazier, and I'm a resident at Arden and a junior at Wellington High School. When people hear data center, they often think about technology. But for those of us who live nearby, this is about our homes and our quality of life. Florida is already extremely hot, especially during the summer. I enjoy being outside, whether I'm playing sports or simply going on a walk, but the heat already can make that difficult. The thought of adding a large AI data center that could contribute even more heat to the surrounding area is concerning to me. I also am concerned about the water. I try to stay healthy by drinking plenty of water every day, like many families, and we rely on water for everyday life. I don't want to worry about additional strain on our local water resources. Another concern is noise. Home should be a place where families can relax, study, and enjoy some peace. Consistent construction and ongoing industrial noise can change the quiet community that so many of us chose to live in. My parents don't want to leave the neighborhood we've built our lives in, and neither do I. I hope that you will carefully consider the people who have already called this community home before making your decision. Thank you for your time.
Good afternoon, commissioners. My name is Maria Blake, and I am an Arden resident. I truly believe that, where there is a will, there is a way. Today, you're not voting on whether data centers should exist. You're voting on whether this Project Tango belongs here next to our homes, families, and elementary school. I am fully aware that there is a moratorium for a new application, but what about us? Does this fit next to us? My husband not to tell me, but I'm gonna say it. What are we, chopped liver? Elected officials across America believed data center was what in the wrong directions. They voted no. Naperville, Illinois, San Marcos, Texas, Tucson, Arizona, Allen Park, Michigan, City Council unanimously rejected the projects. Just because a project can be approved, it doesn't mean it should be approved. If there is a reasonable doubt that this application was approved a decade ago when we did not have all the AI data center, and now we have brand new residential area and a brand new elementary school, is this still a right place for heavy industrial scale infrastructure? Vote no. And I have a question for
Thank you, ma'am.
Mr. Cox.
Thank
Why
you,
is
ma'am.
it taking 6 to 7 years to
Thank you,
build
ma'am.
a data center?
That's your
Our
time.
school was built in less than a year.
Sir.
Go ahead, sir. Please state your name.
Thank you. My name is Dave Zita. In addition to being an Arden resident, I'm also the president of the Arden Homeowners Association. So thank you very much for having us and having an opportunity to speak today. I'm here on behalf of the 2,300 homes in the community, unified in opposition to the project. It stands to reason, and I'd love to be proven wrong, but there's no discernible benefit for the Arden community by this project. We already have a series of concerns, environmental and otherwise. We talked today about heat generation, dissipation into the atmosphere. General proximity to this school is of the utmost concern. And I also want to state for the record the water consumption of the community. I think that needs to be looked at. I think that number is much too high based on our knowledge. I think it has to do with hydrant flushing. Could be wrong on that. So against conventional wisdom would be to put this data center so close to the school, especially hearing as much detail today as we did about no reliance on the nearby aquifer. How much land does Florida have? Where else could this be put? And how easy and seamless would it be? What's the driving force to locate it next to Arden? What's the driving force to locate it at this specific location? Money? Convenience? Not sure. I leave with two asks. One, I have a unanimous consent signed by our board, opposition to the project that I'd like to distribute. The other ask is, in your time this evening, 55 decibels, white noise. Listen to that and see how long you can tolerate it, and then ask if we in Arden should do the same. Thank you very much.
You can submit your record to the clerk.
Hello, my name is Larry Frazier. I'm an Arden resident, and I've just been seeing all day long these guys over here have been trying to make this seem like it's a light industrial project. I mean, common sense. First, they came in and said they were only going to use 5,000 gallons of water. That's what they submitted. Then they went up to 100,000 last week. Now today, it's over 200,000. Doesn't make sense to me. You guys keep talking about the definition of light industrial, heavy industrial. We know this is not light industrial. You guys know this is not light industrial. Let's stop kidding ourselves and get straight to the point with this. If it's about the money, then just tell us that. You guys want to do that to us because of the money? Tell us that. But do not come up in here and make you guys think that we're stupid, that we don't understand what light industrial and heavy industrial is. We know what it is. This is heavy industrial all day long. So if it doesn't fit, don't do it. That's it. If a triangle's a triangle, a square's a square. Don't make a square a triangle when it's not. And that's what you guys are trying to do today. I mean, I listened to all of this, and like I said, I don't even know why we were voting on this. I don't even know why it's gotten this far. It should have been stopped from the beginning. Why are you guys doing this to us? I just want to know why.
All right, I have Rob Sava, so I can't read the writing. Savannah, Larry Frazier, which I think that was just you, right? Smart. Simone Grasso, Stanley Prover, Howard Richmond, Monique Costner, Julie Germana, Michael Ortiz.
Go ahead, ma'am.
Good afternoon, Simone Grosso, and I live in Arden. I'm here today to oppose the addition of space that will be used for a hyperscale AI data center in an area that is zoned for light industrial use. The applicant is trying to change our perception of a hyperscale AI data center just to fit the approved zoning. He has a whole room of experts with studies based on the current definition of a data center, which is obviously outdated. He has a noise expert that doesn't have any real-life examples of the actual noise level at an AI data center. And we have a second owner that's applying to convert their warehouse space to data and information processing. Like someone else said, death by 1,000 cuts. You're probably familiar with the saying, you cannot fit a square peg into a round hole. How about this? You cannot fit a question mark into a round hole. As mentioned by the zoning board on July 2nd, technology evolves quicker than laws. And they will be working, from what I understand, on updates to the code, and you're already working on updates to the code. And the state of Florida has already passed a moratorium. Unfortunately, all of this doesn't seem to apply to our situation here. But based on what we're looking at today, I ask you to please deny this application due to the current uncertainty surrounding this project. And not just for our sake, but to avoid setting a terrible precedent for AI data center approvals in, for example, empty warehouse lots all over Palm Beach County. Thank you so much for
What's your name again, ma'am?
My name is Simone Grosso, and I live in Arden.
Go ahead, sir.
Good evening. My name is Stanley Prover. I'm a resident of Arden, around the Loxahatchee, and I'm only going to read words that aren't mine. These are your words that I've taken off the Palm Beach County Commission website. Only your words. Our mission: to drive a continuous improvement culture of excellence, and this is the important part, that achieves a measurably high level of public satisfaction. That's the mission, okay? An unwavering commitment. Program our work to improve the quality of life in Palm Beach County, focusing on those efforts which provide the most enduring benefits. Our goals: record and track customer satisfaction trends, modify systems to achieve customer-defined objectives. I believe we're the customers. And putting this thing next to a school, I'm sure is nobody's objective in this room. Strategic priorities. Environmental protection, we've heard experts on all sides of this, so I'm not going to waste any of my time going into it. And the final thing from you guys, our mission, to drive a continuous improvement culture of excellence that achieves a measurably high level of public satisfaction. And we're the public.
Thank you.
Thank you, sir.
You're welcome.
Good evening. My name is Julie Germana. I live in Arden as well. I'm no civil engineer, land use attorney, or sound expert, but as a nurse, I would look at the potential risk versus benefit related to procedures and treatments, and in this case, that's Project Tango. In this case, the risks are many, but the benefits, just one, tax incentive, tax revenue. So let's talk about that. In 2017, the Florida legislature enacted a data center sales tax exemption that required a 15 megawatt critical IT load, which is the portion of electric capacity reserved solely for computer server equipment. Then in August of 2025, the legislature implemented House Bill 7031, which raised the critical IT load to 100 megawatts, effectively limiting the tax exemption to large load or hyperscale facilities. Just after this change, the applicant requested an increase in square footage for a data center, I assume, so they can meet the requirements for the tax exemption, which, just FYI, includes construction materials, infrastructure materials, computer equipment, servers, including all of the updates that will be needed, cooling systems, security systems, and the massive amount of electricity used for the operation, tax exempt. So just think about that for a second. So here's my question for the board. If you were to deny their request today for increase of square footage for data center and keep them to the approved 2,006,000 square feet, will that deter them from building a data center as a whole, since it may not qualify them for the tax exemption? Just a thought. And is the tax revenue benefit enough to the county to risk the whole of the western communities? Thank you.
Monique Costner, Loxahatchee resident for over 20 years and one of over 40,000 residents in the area on well water. I have concerns about the closed loop cooling system. I'd like to play a short audio clip from an expert who testified about closed loop cooling systems at a Michigan House of Representatives hearing in February. Is that okay? Okay.
It's your minute.
Can you play it through the microphone?
Up water. There's really no such thing as a closed loop system. It's still picking up water. That water in a closed loop system is being contaminated. It's picking up anti-corrosives, anti-scaling agents, biocides, and then what is happening is that water gets what's called blowdown. It gets blown back down into the aquifers or the rivers, or like what Ohio EPA is just right now allowing, they just dump it right back into the river. The water treatment facilities are not capable, they do not have the filtering media, and they are not capable of filtering those particular types of corrosives. And so that just makes its way down into our aquifers. And most of these communities are small towns and farming communities that have wells set on aquifers. So this water it's this gray sludge basically is not being cleaned, it's not being filtered, and it's being dumped right into our drinking water, or it's being dumped into a water treatment facility center that cannot handle that kind of load.
There are so many questions still left unanswered. If there is contamination or leakage, our drinking water will be directly impacted. Thank you.
Hello, Commissioners. Howard Richmond, West Delray, also Chair of the Palm Beach County Democratic Party. On April 9th, 2016, the Palm Beach County Democratic Party overwhelmingly passed a resolution 103-3 calling for a moratorium on AI data centers. I'm just reading one paragraph from that. Be it finally resolved that the Democratic Party of Palm Beach County calls on elected officials, candidates, and party leadership to stand with residents and protect communities and safeguard our collective future. Commissioners Powell, Flores, Weiss, Sachs, I hope you'll take that into account when you make your vote. And then putting on my regular person hat, I heard Commissioner Sachs asked about high-tension power lines and noise this morning, and we heard the expert testify on the low decibel. To me, it's almost a no-brainer, okay? If the human body can hear something, noise, power, whatever, there's something in it and cannot be good over a long period of time. So we hope you vote against. Thank you.
All right, making the last call for Rob Savannah, Michael Ortiz, Shalon Bull, Gail Ladd, Scott Moss, David Jamison. See anybody moving? Okay. Samantha Scarth Wood, Jay Bromett, Victoria Doyle, Tammy Jackson Moore, Raymond Penuela, Elizabeth Panditch, Faisal Al-Baldawi, and Andrew Weitzerman.
Hi, my name is Samantha Scarthwood. I live in the acreage, have for 28 years, since July 1998. I'm just confused as to, I thought your obligations were to represent the people of the community, and it doesn't seem like you're doing that at all. If all you've heard for the last year is that nobody here wants a data center, why would you choose to vote yes in general to expand at all, add more footage, or allocate? Semantics, I guess. The applicant has never been clear about anything with this project, has given minimal information of little substance. They're being sued by another applicant on the same project and have been abundantly vague. Simple as the fact that you do not have enough information to approve, saying that this is not going to negatively affect the community. The data center is being built no matter what, and we can't do anything about it, as Ernie and Mayor Baxter have told us 1,000,000 times. So then just say no to this. You said you, as a board, can do nothing about the data center. That's all well and fine. You have the power now to stop them. Why don't you just vote no? You can't do anything about the data center, that's fine. Upwards 2 million square feet isn't enough. If you say yes to this, what isn't to say you won't say yes to them making that warehouse space into computer space in 6 years' time? And then they slip that underneath our noses like in 2016. I hope in the fact that this is 10 plus years in the making and you still don't know the difference from what they applied for and what they are building is ridiculous. You've been asking the same questions for a year and you're getting the same no answers, and it's out of this world that you guys are allowing it to keep on happening.
Thank you. Good. No applause. The next person that applauds will be removed by a deputy. Thank you. Not you. You're fine, ma'am. Go ahead, sir.
I'm not going to clap here. Hello. Hey, my name's Raymond Penuela. I'm on the board for Arden, but I come here today as a resident, a very concerned resident of the county. And to say the same thing that I told the zoning committee last week, you're not voting on Project Tango specifically, although technically you are. You're voting on the precedent to allow a hyperscale AI data center to be built anywhere in the county, from Palm Beach Gardens all the way down to Boca Raton and everything in between. You are allowing it by saying, okay, this AI hyperscale data center is considered light industrial, because by saying yes to this and allowing them to build a hyperscale data center, you're basically saying implicitly, yeah, it's light industrial, and that's now classified as that. And going forward, any other land developer will use that as a playbook to look at anything else. And I want to point out that your own zoning committee unanimously voted 6-0. They saw the same information that you guys saw today and said, you know what, this doesn't make any sense. They said no. You guys, it now goes to you. You're choosing to look at your own committee and say, nah, you know what, we reject your opinion. We're going to now do our own opinion if you guys decide to go against it. You guys also know that this is an issue because you guys decide to do a moratorium, which is great. But why is Project Tango not a part of that? If you want to be equal to everybody, you should pause this, listen to your own. If you don't think it's an issue, you wouldn't have done a moratorium. So clearly you think it is. So please, do what's right. Listen to your own zoning committee. Thank you.
What's your name again, sir?
Raymond Penuela.
Thank you.
Hello, County Commission. Elizabeth Panditch from Wellington, Florida.
Commissioners Flores and Sachs, before the break, I heard you asking some questions about can we hear a sample of the sound. I find it ironic that an AI data company cannot AI you a sample sound. That being said, another term that has not come up is a very basic physics term, which we learn in high school, hertz, not the car rental company, the frequency of sound waves. They are not all built the same. The hertz that are going to come out of a closed loop cooling system data center are two different types. 120 hertz from the transformers, which is described as a low B flat hum that is very distinguishable. And then the lower hertz sounds from another component of cooling in a closed loop are a lower frequency, between 30 and 90 hertz. Those long wavelengths don't behave like voices or birds. They bend around barriers, travel farther with less energy loss, and are much harder to stop with trees, berms, or residential walls. They can even travel through the ground up to miles depending on environmental conditions. I find it interesting that this very basic scientific unit of measure has not been brought up once in this entire day, and it is probably the most important. I think more homework needs to be done on this one component of the science of sound, as you guys were asking about, and you'll get your answer. Thank you.
Good afternoon. I'm Victoria Doyle, Lake Worth Beach, candidate for Congress in FL 22. We are in the midst, nationally, of a massive, intentionally rushed AI data center build-out that is totally unregulated. Congress and the Environmental Protection Agency have abdicated their responsibility to impose any standards on energy use, water use, emissions, noise, or community and wildlife protection. So regulation is being pushed down to localities like you, and understandably, you're overwhelmed. Big tech billionaires, President Trump, drill baby drill, they are pushing this agenda. Projections show global power demand from data centers could rise by 50% in 1 year, 2027. That's fossil fuel consumption, generating air pollution, greenhouse gases, and delaying clean energy transition. The last thing we need at this juncture of global warming, especially in climate vulnerable Florida, require clean energy investments from these big tech billionaires. Meanwhile, we don't know who the big tech billionaire is because Florida law lets them hide behind a non-disclosure agreement. That secrecy violates our right to be informed voters. Who is getting campaign money from this big tech owner? We deserve transparency. Thank you.
Well, I definitely didn't get my 10,000 steps in today, but good evening. My name is Faisal Baldawi, Vice Mayor Woodward, Commissioners. I was raised in this county. I'm a West Boca High graduate, current FAU student. 2 years ago, I was the elected student representative of the county school board, representing over 190,000 students. You heard the experts today, retained by the applicant, testify that there's no health impact. Ask them one question: what long-term study of children learning next to a hyperscale AI facility is there that they're citing? There isn't one anywhere. Not because the answer is known, but because no one has really ever checked. And a prediction is not a study. Our kids would be the study. You've heard tariffs protect your constituents' bills. No one has testified to what protects Palm Beach County's children. The developer promises closed-loop cooling, but your own staff report says that the cooling method has, quote, not been determined. The Water District confirmed last week that there's no permit application and no review. That comes after your vote, which means that every assurance you heard today about water is a promise, not a permit. You're being asked to vote without a settled answer, 2,000 feet by the developer's own revised number from Saddleview Elementary. Your zoning commission voted 6-0. The project has not shown it meets the standard for light industrial. No impact beyond. Not here, not next to a kindergarten classroom. So vote with the people you serve and deny Project Tango. Thank you.
Hello, my name is Andrew Weitzman. I live at 19491 Broad Shore Walk. If Project Tango proceeds, no one will teach at Saddleview Elementary School, And the $42 million this county just spent building this brand new, beautiful school will be wasted. The A rating it just received, the pre-K program being 250% oversubscribed for this coming school year, will all go down the toilet as the school will become a decrepit ghost town. You've seen what these data centers do to drinking water, to pollution, to heat. What happens when it burns down and we have one exit out of Arden? We will be trapped. Will the county be setting aside a reserve fund when Aaron Brockovich comes to town to sue for the cancer cluster that will ensue? If this project goes through, it will cost the county more money in the long run than any kind of lawsuit about which you're concerned from the applicant. By the way, since last Monday's afternoon storm, we've had 4 power bumps. How is there going to be enough power? Despite what FPL had to say, we already have power bumps all the time in Arden. There are serious issues that need to be concerned, and as Commissioner Sachs mentioned earlier, this can be done anywhere. It doesn't need the water at the specific location. Thank you.
All right, last call for Jay Brummett, Tammy Jackson Moore. I don't see Tammy. All right, Jamie Grant, Kurianne Pecorine, Shay Hoffman, Jamie Rodriguez, Julie Sink, Corey Kenterman, Daniel Jackson, Rudolph Tinker, Robert Schaefer, Scott Wiggle. Go ahead, sir.
Thank you, Commissioner. It's an honor to be here today. My name is Jamie Grant. My family's lived in Florida for 100 years. I spent a decade in the Florida legislature, and I spent 3 really long years as the state CIO here in the state of Florida. I'm here in my individual capacity. I have no financial interest in this project, but I'm here for 2 reasons. I believe this issue is the most pressing national security and economic opportunity to confront our country in a lifetime. And secondly, to place the legislative record and intent squarely on the record. In 2017, when I drafted, helped negotiate, and land the tax exemption, I think there's some relevant information. Hyperscalers existed. We knew it. Florida couldn't compete in the hyperscaler market because of the price per kilowatt. This opportunity came up. My first question representing Hillsborough County was, how do we have this for the future workforce of Hillsborough County? The opportunity in West Palm was uniquely situated. It's why we negotiated this legislation the way we did, having no understanding that a decade later I'd be here. I would like to close with maybe 2 things and understanding that in 90 seconds it is impossible to cover the totality of things that have been said today. But squarely on the record, hyperscalers existed. They're companies called Oracle, Microsoft, Google, AWS. They existed then, they exist now. We didn't have to look outside Florida. The legislature, that can't often agree on the time of day across party lines, celebrated UF's Hypergator. It was one of the largest and most powerful supercomputers in the world, gifted in 2021 by the NVIDIA co-founder. So this notion of what an AI or hyperscale data center is propaganda that is benefiting, and I understand the opposition in this room. Nobody's happier than Beijing today.
Thank you, sir.
Good evening, Commissioners. Jamie Rodriguez, Western Palm Beach Community Alliance and Arden resident. This vote will have generational impacts. Why did the Zoning Commission, who knows the ULDC better than anyone, vote unanimously against this project? I'll tell you why. The data server farm and warehouses the county approved back in 2016 was light industrial and a true economic development center, promising to bring jobs to Glades residents, not impact the environment, and be quiet. EDCs require parking spots because hundreds of people actually work there. Meanwhile, AI data centers staff less people than a McDonald's, don't use local construction workers, trash the environment, and are a 24/7 incessant noise nuisance. They generate heat, create low-level infrasound affecting cardiac health for children, such as my daughter with heart issues. Light industrial doesn't affect adjoining uses, whereas heavy industrial has effects beyond. It is undisputed that AI data centers cause sound, heat, and vibration to cross property lines. And if the applicant is telling you different, well, I have a house in Arden to sell you. Commissioner Kennedy, who by trade is a land use attorney and has no dog in this fight, determined the project fails to meet the county standards in 6 ways. It's not consistent with the comp plan and incompatible with residential. Commissioner Vinacore, who helped develop the EDC category, found that this project is something totally different and that the AI data centers do not belong close to people living in homes or schools. And she could not in good conscience approve it. And I ask you to do the same. Thank you.
Good afternoon, Scott Weichel. I want to thank you guys for taking the time to listen to all of us. But after sitting here listening to the applicants for over 2 hours, experts, I had many questions raised in my mind when their experts actually contradicted themselves on at least 2 points that I could pick up on. And I'm not an expert, but I am an expert at Google. So one of their experts had said that there's no effect on the health at 65 decibels. Well, my expert opinion is, yes, a 65 decibel low frequency hum can impact your health. While it is too quiet to damage your ears directly, it often causes sleep problems, high stress, and frustration. The constant buzzing can also lower your ability to focus on hard tasks. Then, another one of their talking points was not clear as far as what was the decibels that we would hear over at Arden. So my Google opinion is, yes, a 50 decibel low frequency hum can impact your health. While it is too quiet to cause immediate hearing damage, long-term exposure can trigger chronic stress. Continuous low noise at this level is linked to sleep problems, high blood pressure, and mild cognitive fatigue. I'm not going to use the approach that you guys are doing anything wrong yet because you haven't voted, but please don't kill us slowly.
Hello, my name is Shay Hoffman. I live at 19191 Croft Mill Crossing in the community of Arden. I am here today to represent my community as well as my 3-year-old and 5-year-old daughters. Next month, my daughter Madeline will be starting kindergarten at Saddleview Elementary. My wife and I are very concerned that this hyperscale AI data center is going to have a negative effect on our children's ability to learn and grow in this environment. It angers us that we have worked so hard for years to be able to move our family to what we thought was going to be a great place for our kids to grow up. When my wife and I researched the area before moving there was no public information about a hyperscale AI data center being approved next door to the community. I also have to say that it's extremely disappointing that our own district commissioner is not in the room today. There is absolutely no excuse for her to not be here. The bottom line is that the bottom line today is what was approved in 2016 was not a hyperscale AI data center, and we should definitely not be approving a bigger version of that. And the last thing I just want to say is that I don't know how familiar you guys are with Arden, but I can't imagine that there's another neighborhood that has a higher density of children than Arden, or a higher density of police officers than Arden, or firefighters. So these are the families that you're representing today, because Sarah's not here to represent us. Thank you.
Good evening. My name is Julie Sink, and I'm a teacher at Saddleview Elementary School, as well as an Arden resident. When I first learned that Project Tango at the time was proposed approximately 1,200 feet from an elementary school, my first thought was simple. What about the kids? As teachers, we work hard every day to create classrooms where students can focus, grow, and thrive. That responsibility is especially meaningful for our students in the ASD units, many of whom experience sensory sensitivities and rely on calm, supportive learning environments. Placing this so close to our school raises concerns about maintaining the conducive learning environment that all of our students deserve. These children, as stated before, won't just spend time, these children won't just spend their school days near this facility, they will constantly be surrounded by it. As a teacher, one of my greatest responsibilities is protecting my students. They don't have a seat at this podium today, so I'm asking you to be their voice. Our children deserve a healthy, safe community where they can learn, grow, play, and dream about their future. Please protect the children of Saddleview Elementary and the families of our Western communities. There are still so many unknowns with this project, and I'm urging you to vote no. Thank you.
Hi, my name's Corey Canterman. I initiated the petition of over 11,000 people against Tango, and it was submitted into record. I've lived at 1369 Wandering Willow Way for 5 years now. It's the westernmost street in Arden, so we are amongst the closest to the Project Tango site. My 2 sons are neurodivergent, dealing with sensory issues, amongst other things. We're thankful we live in what is supposed to be a peaceful, nature-focused community that will not overstimulate them. My wife and I are so proud of our boys. Despite their challenges, my older son has excelled in middle school and was accepted at Dreyfus, where he starts next month. My younger son really hit his stride this past year at Saddleview, which would be even closer to Tango than my house. Tango is a direct threat to my family's health. I fear what the constant low-frequency sound known to cause stress in the body will do to my kids and their sensory issues. What will the air pollution do to my asthma? My older son suffers from anxiety and has been watching this all day on YouTube rather than the World Cup because he's really worried. Hi, Ethan. My younger son has ADHD and often wakes up multiple times a night. The sleep-depriving low-frequency noise will exacerbate that. Hey, Jacob. Arden will be up to 16 degrees hotter due to the heat island that will be created. Between heat, noise, and air pollution, we won't want to go outside. And what happens in that emergency, because as mentioned, we have one exit. This whole thing is absurd. And I can't believe it's even come to this. It should be called Project Whiskey Tango Foxtrot because every detail of this is a WTF moment. Thank you.
All right, last call for Robert Schaefer, Rudolph Tinker, Daniel Jackson, Corey Canterman, Karianne Pakarian, and then calling John Rothberg, Laura Cole, Eric April, Rachel Smith, Jairus Goss, Catherine Waldron.
Go ahead, ma'am.
Hi, Laura Cole. I'm a resident of Arden. I'm also the Senior Vice President of Workforce Strategy and National Operations at the largest staffing company in the world. My teams are tasked with classifying heavy versus light industrial sites nationally. Here's the part that the experts this morning left out. Project Tango is a massive heavy industrial processing plant, not a light industrial warehouse. It is not about your ears or what you can hear. When we're talking about 24/7 low-frequency hum, it bypasses the human ears. It travels for miles and penetrates glass and concrete. You cannot build a wall high enough to stop it. A quick Google search shows that data center low-frequency hum runs closer to 85 dBc, not the 50 that was, or 40 that was talked about earlier this morning. It is radically different drone than an air conditioner, which renders that earlier demonstration completely invalid. Decades of neurobiological research prove that this permanent hum is a toxic stressor, forcing the human nervous system into a continuous fight or flight response, which triggers severe sleep disruption, impaired childhood brain development, immune dysfunction, heart disease, anxiety, cancer, and cognitive decline. Once you know these facts, a no vote is the only defensible path forward. Please do not knowingly condemn our community and our children and our elementary school to disease, suffering, lawsuit with this permanent health hazard. Please vote no.
Rachel Smith, I am a resident of the acreage. Hyperscale AI data centers did not exist in 2016. Your own zoning department just recommended denial because we all know that this is a heavy industrial operation. Today, you've heard a lot of facts about Project Tango, the dangers to our communities, and the detriment that building this hyperscale AI data center will cause to residents, their children, the environment, and so much more, but I want to take this time to speak directly to you all. First, I want to remind everybody that respect is earned and not given. I find it disgusting that the people that were elected to represent us are practically making us beg for your protection. All of these community members you see behind me, including myself, have spent their time, energy, and hard-earned money to put a full force effort into fighting this. You've made us do the research, us educate you guys, us confront the developers, and us fight for ourselves. We've created websites, Facebook pages, held rallies, events, we've called, emailed, met in person with our elected officials, and it still feels like today we're sitting here begging you guys to protect us. If this gets voted yes on, we will take all of this energy over the last few months and make sure that you guys are held accountable for your actions. Our tax dollars are the only reason you're here. You know what the right decision is. It's not about money. It's not about tax revenue. It's not about being afraid of the developers that you guys are allowing to strong arm you into this. The right decision is protecting the people you swore to protect, representing the people who pay you to represent them, listening to what your constituents want, not the developers. The right decision is voting no, and I strongly urge you to do that today. And then I have a question for you, Mr. Weiss. Do you think that 600 fans will be loud? Genuinely, I'm like genuinely asking. I would like your answer.
Ma'am, you cannot direct, you have to address the entire board, please.
Okay, may I ask the commission for answers? Do you guys think that 600 fans will be loud?
Thank you.
I don't get an answer.
I'm putting all questions on the record. Thank you.
Good evening, Madam Vice Mayor and Commissioners. My name is John Rothberg. I'm a West Palm Beach and Palm Beach County resident. This board has worked to diversify our economy by attracting industries like AI, biotechnology, life sciences, advanced manufacturing. We have celebrated new investments in research, innovation, and higher ed. We're welcoming Vanderbilt, expanding research at FAU, and continuing to build on the success of our biosciences industry. Attracting these industries requires more than vision. It requires infrastructure. Just as previous generations invested in roads, ports, airports, and utilities, today's innovative economy depends on digital infrastructure. Data centers are the backbone of AI, medical research, cloud computing, financial services, and virtually every technology company. We want Palm Beach County to compete with the nation's leading innovation hubs. Therefore, we must be willing to build the infrastructure those industries require. This project represents an opportunity to strengthen our commercial tax base, more commercial investment, long-term revenue to support schools, public safety, and libraries. I respectfully ask you to support Project Tango.
Sir, no outbursts, please.
Eric Capel, resident of the Acreage. When it comes to Project Tango, it's like the noisy neighbor nobody wants in their neighborhood. 24/7 noise. The experts over here say 55 decibels. That's what two people talking 3 feet apart are. I want you guys to think about laying in your bed and listening to 2 people outside your bedroom window talking all night long. You're not going to sleep. This is just going to be constant noise, headache, disturbing kids, babies, yet alone the school. Square peg, round hole, it doesn't matter. Tango doesn't fit in this neighborhood, near it, or in Palm Beach County to even start with. You guys have a fiduciary responsibility. Look out for the benefit of us, the people. You are our word. We come, we tell you what we think, we give you our opinions. You sit there, you dictate what happens to our lives. Take a little bit of moral, a little bit of statute, step that up, be professional. You have lawyers that look at, oh, we could get in trouble for this or that, and they have to figure out what's worse. Think about the people. Think about us out here. There's enough of us here. You couldn't get all of us in a room. There's 3 locations for people to be and stand against this. When it comes to voting, this is going to be a mark. It could be a check mark for good or bad on your next decision in the next couple hours. Or it could be really bad for all of you. Just up to you.
Hello, my name's Catherine Waldron, and I live at 11863 Wimbledon Circle in Wellington, Florida. And I'm here today to speak out against Project Tango. Our community does not need a hyperscale AI data center. There are already thousands in the US. They are not regulated, and the environmental and health impacts are not yet fully understood. We are being asked to operate under the trust me, bro theory, which most assuredly will not turn out well for nearby communities such as Arden or the 800 children attending Saddleview Elementary School. Further, the large and furious ramp up of all of these AI data centers is leading us to a large bubble that will lead to a financial meltdown. Built largely via circular financing, the financial model of these AI data centers does not make sense. I would suggest if you decide to allow this hyperscale AI data center to proceed against the wishes of the vast majority of the residents, then you require the owners to put up a performance bond for remediation of the site. So if the data center does not become operational or goes out of business, our residents are not left holding the bag. And one final note, county commissioners need to represent their district. Any commissioner who puts themselves in a position where they must be recused is removing their district's voice on important issues such as this, and that is never okay to do. Thank you.
Hello, good evening. I'm Dr. Rudolph Tinker. I'm a general contractor and Army engineer officer, and I got 5 state licenses in construction, and they're all right here in the state of Florida and not Australia. None of you seem to know, like you don't know what's going on in this project because you didn't do your research before you came here today. This Project Tango has been on the book since December, and a lot of you guys are asking the same repetitive question. What's a closed loop? The size of the building? What's in the building? How does the building get cool? I would think by December, you guys should have been the expert and asking the right questions. Instead of you come here and you asking the client or the applicant these questions, and some of you even Googling it. I mean, you should have already known everything there is to know about this project and don't come here to rely on the client or the applicant to give you answers. Also, this project was supposed to bring a lot of jobs from the Glades. What jobs? We already know that these data centers, a lot of people work remotely. So there's no jobs. Also, one of the biggest questions is the amount of temperature that's going to be exposed on the outside and the temperature that's going to be required to maintain this facility in the inside. Because if we understand what the temperature is, we all know how many condensing units it would take to suck the heat out of this building. So please do your research before you come to these hearings.
Thank you, sir.
Hi, my name is Jairus Goss. I'm standing here to talk about the human side of public process. Individual participation in a system is not the same as public consent to unlimited expansion on every system. It does not remove our responsibility to question its cumulative impacts. At what point does accumulation become part of the evidence? We are told to look at a hyperscale facility in isolation, but communities and ecosystems don't exist in isolation. One decision at this scale ripples through an entire system that sustains our families, our history, our water, our biology, our energy, and our public health. I brought an anchor today. This is a book, a reminder that Florida's history and natural systems are interconnected, and today's decisions become tomorrow's history. My passion is to protect the future resources and safety of all our children, their peers, and their offspring. Whatever your decision today, I ask that it reflects not only the individual studies, but cumulative interaction of all of them, because future generations won't inherit separate reports, they'll inherit the results. I also just want to add into evidence your own flyers about conserving water and, all that fun stuff.
All right, I think we're down to the last 10. We got Ben Brown, we got Carla Bauscher, Lisa Johnson, Patricia Hansen, Tatiana Yakis, Sue Loisel, Neil Bennett, Nick Salanitro, Colton Wilson, and Sergi Kelly.
My name is Pat Hansen, 1801 Marina Isle Way, Jupiter, Florida. I have 36 years of experience working with autistic children, creating classrooms and home environments for them. There are 2 classroom units of autistic children at Saddle View Elementary School and several dozen community members, both adults and children with autism and sound sensitivities. Mr. Cox's experts said these people do not exist. They do, and I am standing up for them right now. Data centers emit persistent low-frequency hums. We've heard it from everyone. Because many autistic individuals experience auditory hypersensitivity, again, auditory hypersensitivity, and sensory processing differences, this consistent sound triggers severe distress, sensory overload, sleep deprivation, and even physical symptoms like anxiety, nausea, and meltdowns. These symptoms are real and cannot be dismissed by Mr. Cox's experts. On July 2nd, Mr. Cox promised me, and I quote, "Nothing will change in Arden," and I told him it's simply impossible. I requested him to give me the address and location of any data center in the United States that would have a hum that wouldn't affect my disabled child. He failed to provide it to me that day, and he told me he would get back to me, and he never did. I was willing to fly anywhere for that. I'm just gonna say one more thing. Currently, Arden sounds like nature. There are peaks and valleys of this sound. Those valleys give the sensory system time to reorganize.
Thank you, ma'am.
Mr. Cox's experts believe only decibel levels count.
Ma'am.
And decibel
Ma'am,
levels are
thank you.
not the full picture.
Thank you.
Thank you. Please put this in the record.
Hello, my name is Lisa Johnson. I respectfully ask that you deny this application. The record contains no competent substantial evidence demonstrating that this project complies with the Unified Land Development Code. My concerns are water and heat. We have 94,000 residents in unincorporated Palm Beach County that rely on private wells. There's no evidence in the record demonstrating this project groundwater demand, cooling operation, and heat will have no adverse effects on our wells. In 2016, the approval was for a data and information processing use. It did not contemplate today's large-scale AI hyperscale load user. Expert research published this year and submitted for the record and documented measurable off-site warming from operating data centers extending beyond facility boundaries. The ULDC prohibits objectionable off-site impacts, including heat. Lion Country Safari is only less than 2 miles away. It's home to endangered species. The potential for off-site thermal impacts, there's no evidence of thermal monitoring or impact studies to ensure wildlife will not be adversely affected. When I previously asked Greg Weiss what the county's plan was for our well, if our wells became unusable, he answered, "There is not one. I guess we'd bring you bottled water." We have no impact independent studies of our well levels or quality. Commissioners, bottled water is not a groundwater protection plan. I wish you good luck on what's to come.
Hello, Commissioners. My name is Sue Loisel. I live in Arden, of which my home is 1,000 feet from Project Tango. I'm a member of the WPBCA, Chairwoman of the Arden HOA Development Impact Committee, and former Vice Mayor of the town of Cutler Bay. I understand what you're going through, and I understand that you need to go with what your community wants and what your residents need. Me and my team secured and submitted for the record formal resolutions from local municipalities stating and recognizing that hyper AI data centers are heavy industrial. These are Village of Wellington, Westlake, Town of Loxahatchee Groves. Additional resolutions that I submitted from community organizations, Acreage Landowners Association, the Arden HOA, Foxtail, Indian Trails, Classroom Teachers Association, Palm Beach County Democratic Party, and the Everglades Coalition, and several letters opposing Tango from Senator Bierman, State Representative Weinberger, Sustainable Palm Beach, the School Board of Palm Beach County, Deer Run's Board of Directors, Sierra Clubs. Additionally, we submitted 300 pages with 11,264 signatures for opposing Project Tango. Commissioner Flores, you asked about sound. Here's 80 hertz of sound. That's low frequency sound. You can't hear it, but your brain can.
Sir?
My name is Nick Salonicho from the Nick and Colton Show. I'm from Port Charlotte, Florida. About 3 months ago, Ben Brown and Rachel came out and wanted to come on our show. We were so intrigued by Project Tango, we drove 3 hours to come out here and speak to people. I speak against data centers. I'm from New Jersey. I watched everybody's bills double. I was sitting in the back of all these gentlemen, and I'm appalled by the amount of corruption that's going on in the system. Right? Mr. Wise, you're running for mayor, right? You're running for re-election.
Sir, please.
You are
to the board.
actively texting the lawyer on his phone. You are actively texting the lawyer, and I have pictures of your text messages to the lawyer.
Sir, please, you can only address the board as a whole.
Okay, I'll address the board. There's a lot of corruption, and if you guys vote yes to this, I will spend the next 6 months making sure none of you guys get reelected. I promise you. 20 million views a month. I am a corruption guy. I promise you, I will come after you. Your people that voted you in do not want this. They've made it purposely clear. You should recuse yourself. I promise you, this will not end here. I promise you guys. The people of this town, the people of this county do not want this data center. 2016, iPhone 8. This phone is not an iPhone 8. That's how much technology has changed. And it's not built for an AI data center. So.
Okay, sir, I said the next person that claps has to be removed. Back here. Okay, deputies, please. Any of the ones in
Remove
the
them,
room.
please.
We will have decorum. Ma'am, we are not going to proceed in this way. No, ma'am. Just, we will wait. Please, can we wait?
Sir, officer, he's not getting removed. It's the gentleman in the white shirt back here, and I believe it's the lady in the gray over here.
She's seated.
He's not, we're not asking him to be removed. Or am I wrong?
No.
It's the gentleman that clapped right there, correct?
Yes. Yes. And
the lady that had the outburst. Right there, sir. You went right there. Yes.
Sir, are you in line to speak? You're standing in the aisle. Are you in line to speak? Yeah. Okay, thank you. I'm sorry, just a minute.
Go ahead, Tatiana.
Oh, I asked her to wait until the room was cleared. It's okay. Okay, sorry. Go ahead, ma'am. Thank you.
Thank you. That's a hard one to follow. Tatiana Yaquez, I'm a resident of Wellington, a member of the Western Palm Beach Community Alliance. I'm also a retired land use and litigation attorney and former member of Wellington's Planning and Zoning Board. The thing that excites me, because I'm a bit of a planning nerd, is making sure that our codes protect us. And for those of you that don't have a planning or a legal background, I don't know if you know what our most important code that protects us here in Palm Beach County is. What is it? The comprehensive plan. It's a boring document that many people gloss over. We've heard these terms today, EDC, heavy industrial, light industrial. That's the most important thing before you today. It doesn't matter that there was a definition in 2016 and somehow it's been interpreted through 23 different hearings by staff, by the applicant. What you have to look at is what the comp plan tells you to look at. When you have your checklist of what this project has to comply with, the first thing is consistency with the comp plan. When staff approves things administratively, as they've told you they can do, they also have to say that something is consistent and find that it's consistent with the comp plan. That's in every single development order that's being sought before you. So this project just doesn't comply with that. It's not about the definition. It's not about twisting the definition. It's about whether it is a lighter industrial or heavy industrial use, because if it isn't, then it violates the comp plan and you can't approve it. And that's also the way that you can send a message to staff that they can't administratively convert the warehouse uses into AI data center because they have to find consistency with the comp plan. And if you find that this is not a light industrial use, then it is not consistent with the comp plan and you stop staff from doing that administratively as well.
Thank you, ma'am.
Thank you.
All right, it is very simple. No AI data centers in Palm Beach County. The people do not want it. Wild Florida does not
Sir,
want
could you
it.
state your name? Oh, sorry.
Sergey Kelly. No AI data centers in Florida. No, none in Palm Beach. Wild Florida doesn't want it. The people do not want it. It'll pollute the water. This is not some magical cloud machine that won't have any other impacts. It is not what was approved in 2016. That should be very, very obvious. The moratorium you guys used as a political stunt perhaps, or maybe it was in good faith by some of you, will be null and void if you approve an AI data center in Palm Beach County. It takes away the whole point. And if you ask anyone who's been here for more than 40 years, who loves the area, who knows Florida, they will say that development has gotten out of hand. And I found it very interesting. First, the developers and the lawyers left out any mention of the Everglades in any of their presentations, despite the fact right below Southern Boulevard is the Everglades, the historical Everglades, the functioning Everglades. We use the stormwater treatment areas to clean our water. None of you, I'm surprised, would not bring up the Everglades. In Palm Beach County, the emblem of Florida is the Everglades, and you're directly going to impact that. I know you probably are getting courted by developers and lawyers and whoever, but it should be, none of us should have to actually be here for you guys to do the right thing and ban Project Tango and all AI data centers in Palm Beach County unless the people want it and vote for it, and there will be a new uprising of political candidates who will do the thing for a wild and free Florida. Thank you.
Thank you.
Hi, my name is Neil Bennett. I'm a resident of Arden, and I'm here speaking on behalf of myself, my wife, and this guy, my 18-month-old son, Gabriel. It's really simple. I do understand that this is a quasi-judicial hearing, and we're talking about facts, and you've heard a lot of emotion, but let's talk about facts. Fact number one, a 2016 definition of a data center, which is the code you're using right now, is not compatible with today's modern hyperscale AI data centers. It's just not. This project should be considered either heavy industrial or some new category that hopefully your staff will draw up code for. It's based on noise, equipment, water use, power needs, and impact beyond the property, including the heat island effect. I spoke at the zoning commission meeting a couple of weeks ago, and the zoning commissioners got it right. They understand that this impact is not compatible with being next door to a neighborhood, a school, or the light industrial uses approved in the EDC use. And the other bottom line, Mr. Cox even admitted at the zoning commission that hyperscale AI data centers create adverse uses beyond the border of their properties. And you can actually go back to the testimony from that day and hear it in Mr. Cox's own words. Thank you.
Hello, my name is Emily Ryan, and I live in Jupiter Farms. I appreciate you guys taking the time to listen to me this evening. So I work 2 jobs. I took off both to be here, so I really want to be here. A few years ago, I didn't want to be here. My mental health was at an all-time low. I think a lot of young people are experiencing that in this country. And what helped me was wild Florida. Going out into the natural spaces, falling in love with the wildlife, seeing manatees pop up with their noses coming out of the water, and listening to the bird songs. Birds, they communicate through their songs. Do we know, long-term, what this humming sound is going to do to the wildlife in the area? There's already little pockets of islands for these animals to navigate through the wildlife corridors. They don't have maps. A panther doesn't have a map. We could restore that population all we want, but they're getting hit by cars left and right. I don't see a need to keep continuously developing and causing sprawl here. I don't think it's compatible with Florida. We have the Everglades, which is the drainage basin for the entire United States. And I just don't see how an AI data center that's going to take more water, more energy, and could potentially have long-term health effects. I'm anxious to have children one day, and I'm scared to even do it in this community if this data center goes into place. Thank you.
Ma'am, what's your name again?
My name is Emily Ryan.
And you submitted a card?
Yes,
I guess you did not submit the card. Please give that to our clerk right here.
you got it.
Right here,
Oh,
Thank you.
sir.
Good afternoon. My name is Colton Wilson. I came here today because I refuse to sit back and watch another community become a bargaining chip for powerful interests. As I look around this room, I see two very different groups of people. I see citizens who live here, raise families here, pay taxes here, and will live with the consequences of your vote for decades. Then I see the attorneys, the consultants, the lobbyists, and developers in expensive suits who don't have to live with any of it. They collect their fees, move on to the next county, and leave the people of Palm Beach to deal with whatever comes next. That's the difference. This isn't just about data center. It's about whether local government still works for the people or whether the people have become an obstacle standing in the way of corporate interests. And I want to ask every member of this council a question that many people in this room are already asking themselves. Can each of you honestly say that no land developer, no lobbyist, no political donor, and no special interest has influenced your position on this project? Because if that's true, then be transparent. Let the public see it. Don't just ask us to trust you, show us why we should. When residents repeatedly see massive developments pushed over neighborhood objections, it's only natural that they begin to question whether their elected officials' loyalties are where they truly lie. Are your loyalties with the families who elected you, or with the developers and corporate interests asking for another approval? You weren't elected to maximize corporate profits. You were elected to protect this country, or this county, and the people who call it home. History won't remember who approved another development project. It will remember who had the courage to stand up and say enough.
Thank you. Sir?
Yeah, Ben Brown. I live in Arden. I'm going to start off a little different. I'm going to not say thank you for the time because you said 45 minutes and gave them almost 3 hours and then cut off some of my time. So I won't waste any more of it. Right and wrong, that's really what it's about here. It was wrong that this thing came on consent agenda back in December, and we had to raise a bunch of noise and get it on your radar and do your job for you. As we went along, you did no homework, no research, like which has been mentioned here multiple times, and it's embarrassing along with the staff because the questions, again, are redundant and the same over and over and over for months. The next thing that's unacceptable and wrong is the county commissioner back there who can't represent herself because she made so many wrong decisions, she couldn't even sit up here as a mayor. That's an embarrassment to all of you and to me being in District 6. What else is wrong? We have no fire station within 6 miles of our community to put out the fires that may occur at this facility, especially with lithium. What else is wrong? When the 3 deputies died, which was a tragedy, there was all kinds of attention and notoriety and notice that we only had one exit and entrance to Arden. 8,000 residents. It's ignored by Baxter, by all of you, by your staff, by Patrick Rutter, but guess what gets pushed along the lines? A data center. I wonder if the campaign contributions, Miss Woodward, have anything to do with your vote coming up. Miss Baxter, Mr. Weiss,
Sir,
I wonder when you run for
sir, you
mayor
will
of the
address
city, if the people are gonna think kindly of you for not protecting the water of the
Sir,
city,
your
and
time
standing
is
up
up.
for the people. Vote and do the right thing because it's all
Sir,
been
your
wrong.
deputies, please have this man removed. Your time is up. Thank you. Are there any more cards?
One last card. We got Carla Boucher.
Ma'am, you will be removed as well. All right, take them both.
Last card, Carla Boucher. You have 10 seconds. Okay, that's it. Vice Mayor, should we take a break?
We are going to take a break at this moment. We will come back at 7:15. We'll take a 30-minute break. 30 minutes.
insurance is needed, where to look, or if I even have